Good morning, good morning, good morning. Or should I say, hear ye, hear ye, hear ye. It is day 17 of the retrial of Karen Read. We are still in the Commonwealth's case in chief. Yesterday, we heard from the coroner, which I'm sure is testimony that the jurors were waiting for. But it is Friday, it's May 16th, it's day 17. That's going to get confusing. They never just line up, do they? And then we've got a weekend and it's going to get all thrown off. But we are going to go to court today. I expect we're going to get into the rest of that scientific testimony. We know the Commonwealth has 2 new medical experts. We know that there is the brains of the brain, who is the forensic neuropathologist that we saw last trial. I don't know if they'll call her this trial. We'll see. And then we have all the other scientific evidence, which I imagine is what they're going to wade through on a Friday because, well, we've got to go through DNA testing, blood testing, the manual fitting together of all the pieces of the taillight and all the rest of it. And if I'm the prosecutor, that's what I'm going to do on a Friday because the jurors are probably tired. It's been a lot this week, and that's evidence that you need like 3 sentences of that testimony, but it's so much foundation that has to be laid before you get to like what is the result that it just can feel like a bit of a slog in court. So I imagine that's what they're going to do on Friday and then start with their medical experts maybe on Monday because the jury will be more fresh then. Explosive afternoon in court yesterday. If you missed it, that'll be in the case briefs. Those are all on the Emily Show podcast. You can find that on YouTube, which is like the #1 platform for podcasts anyway, according to YouTube at Brandcast, and from what I'm seeing here too. So you can listen to all of the case briefs on the Emily Show podcast channel or the audio feeds. If you have the Law Nerd app, we just send you a notification every time they drop. But yesterday in court, man, oh man, I'm real interested to see what the court's going to do with that. But because the court did ask Attorney Alessi yesterday what were the alternatives to keeping out the testimony, we can already kind of see where her head's at with that because the Commonwealth asked for ARCA to be excluded and she's not doing that, though I think it is a very different situation. I'm sure we'll get to talk about that a little bit more today. Replay crew that's inevitably coming in to watch. Love you all. The timestamps are down below and away we go. We should just, are you guys ready for Friday in court? I can't even talk. I haven't, Friday in court? Friday, look. I ordered a Frappuccino. Where's my Frappuccino? I'm teasing. Today it's a cappuccino. I'm ready. I'm ready for coffee. I'm ready for court. There's going to be cursey words. Are you guys ready? I'm ready for weather. If I disappear unexpectedly at all today, just know that it is probably due to a power outage and or the internet going down because we have a lot of weather coming our way today. Hopefully it will be after. I think we're in the window that'll be after stream, but just know that if that happens, it's the weather. Just blame the weather or my cat. You can pick one, whatever you want to blame, the weather or Fred. It's one of the two. Either way, the power's probably been unplugged. All right, let's get to court. I'm ready for some hearings. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. It is. It's 100%. It's 100% a Fred Storm. It's 100% a Fred Storm. This cat. Yesterday, somebody in the chat said, can we stop talking about cats? And I'm like, no. So for whoever commented that, if they ever bothered coming back, no. This morning, Fred, first of all, the cats normally sleep with the kiddos. Fred busted in to the bedroom at like 5 a.m. I sleep on my side, climbed up my shoulder, stood on my shoulder, and just yelled into my ear. I was like, what do you need? You have food, you have water, you are, what? Entertain me. Entertain me, human. Entertain me. Fred had food. Oh, Georgia's human is 100% my teen. Fred is like, whoever will pet me, but Travis first. George is like, Travis, and maybe I'll put up with the rest of you if I feel like it. But George is 100% Travis's kid. 100% Travis. 100%. No one else. George was just like, why isn't everyone awake? I know, I see the chat. The chat is like, the Fred slander will not stand.
Before the Honorable Beverly Canoni, Justice of the Norfolk Superior Court, and for the County of Norfolk.
Court?
Give your attendance and you shall be heard.
I cannot hear the hear yous nearly as well.
Court is now open. You may be seated.
Court is now open.
Again,
You may be
counsel.
seated.
Good morning again, Ms. Reed. Good morning, jurors. So, I appreciate your patience. I have to ask you.
They went immediately to sidebar this morning for quite a bit. Because of course they did. Because that's what they do.
Since we left yesterday.
They get on the record, they go to sidebar.
Were you also able to follow my instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday?
That's a bit aggressive. There we go. That's
I
better.
have one other important instruction.
Oh boy.
And it's so important that each and every juror can hear the evidence or the testimony that's presented, can follow the testimony, and can understand and evaluate the testimony of each witness and the exhibits. In order to do that, I just want to be very clear that it's important that people do not comment on the evidence or make any comments. Once you enter the room, it's probably a good idea to just listen. Don't talk,
boy.
Don't make any facial expressions, no muttering under your breath, no audible noises.
Oh dear.
Because people need to hear what's going on and to understand everything. So out of respect for your fellow jurors, I would ask that you be very careful to make sure you do that, and out of respect to the lawyers who worked so hard to get this case before. Okay? Thank you very much.
Yikes.
That, Mr. Brennan, your first witness, please.
They have a juror that's me. They just have a juror or more that's making facial expressions and muttering under their breath. Oh my God. Somebody's like, what the fuck is this? That's me speculating. I am absolutely speculating. But we don't see the jurors. So something the attorneys have noticed with regard to the jurors. They're much closer to them. I don't follow who's looking at the jurors or watching the jurors. I'll go look and see if we have any more information about that from sources in the courtroom. But, oh boy, the judges just, maybe that's what they were at sidebar about. One of the jurors is either making comments, or it could be that a juror complained and has nothing to do with the lawyers, because I've seen that as well, that a juror complains that another juror is disruptive. They want them to sit there more stoically. Right. Okay. Okay, Your Honor. Well, Friday's coming in hot. Let's see what Mr. Brennan wants. Brennan, what do you need?
If I could begin by offering a stipulation that's agreed to between the parties.
Well,
Okay, can we turn the AC
if
down?
it's a stipulation, obviously it's agreed to between the parties. That's what a stipulation means.
Down, please.
Good Lord. Friday. Coming in hot. Stipulation to the jury from the parties.
Yes.
Your Honor, if I may, I'd like to read a stipulation agreement between the Commonwealth and the defense.
Okay.
And the stipulation between the parties is as follows. Now comes the Commonwealth and Karen Read, the defendant, in the above captioned matter. Both parties respectfully stipulate to the following. The two Massachusetts State Police troopers present at...
They're going to tell us? They're going to tell us. They're going to tell us. They must not be anticipating calling someone else. They're going to resolve this issue for the jury in a stipulation. Okay, hold on. The two masked Massachusetts state troopers at the autopsy.
Stipulate to the following. The two Massachusetts State Police troopers present at the autopsy conducted by the medical examiner, Dr. Scortibello, on January 31st, 2022, were Trooper Keefe and Trooper Watson, Former Trooper
What?
Michael Proctor was not present.
That was me. Keefe and Watson? Who's Watson? Also, they did say 2 state troopers. I wonder if Watson is not in the homicide unit. Because Trooper Keefe asked if he was the only one in his unit. I went back and watched his testimony, and he said he was the only one in his unit. If Watson is in a different unit, then Keefe would not be incorrect if Watson's in a different unit, because that is not a name we have heard. Because when I went back and watched Keefe's testimony, he was asked, are you the only one from your unit? If Watson's not in the CPAC unit, then Keefe's not wrong. But good Lord. We're doing that
Yes.
one more time.
Your Honor, if I may, I'd like to read a stipulation agreement between the Commonwealth and the defense.
Okay.
And the stipulation between the parties is as follows. Now comes the Commonwealth and Karen Read, the defendant in the above captioned matter. Both parties respectfully stipulate to the following. The 2 Massachusetts State Police troopers present at the autopsy conducted by the medical examiner, Dr. Scortibello, on January 31st, 2022, were Trooper Keefe and Trooper Watson. Former Trooper Michael Proctor was not present.
All right.
Thank you.
And we stipulate, Your Honor.
Yes, thank you.
The defense agrees.
With that, Your Honor, I'd like to introduce and play clip number 21.
Okay.
They're going to introduce clip number 21. I wonder if this is the clip I was talking about yesterday. Here's initial thoughts until we know more. A, the defense stipulated to it, which means they agree with it. A lot of people said, but the label on the top of the picture, that was the defense labeling. Looked like Proctor to me too. However, many of you in the chat were like, okay, but it's a bald dude in a mask, and we've seen a lot of the state troopers, and they're all bald dudes. Fair. If Watson is in a different unit, crime scene, which is what the pathologist thought, she said maybe a trooper and maybe somebody from crime scene. There are troopers that work in the crime scene unit. Keefe had worked in the crime scene unit before he transferred to the Norfolk DA's office, CPAC, Detective Homicide Unit. And so on cross-examination, Keefe was asked, were you the only one from your unit that attended the homicide or attended the autopsy? And he said, yes. He can't expand on that in cross. He was the only one in the unit. So now my questions are, what the heck is up with the log? Because the log didn't say Mr. Watson. It said Mr. Connor and Mr. Keefe, unless the coroner misread it. But then you would think that the prosecutor would say, are there any other names? What a freaking mess that doesn't need to be a mess, that is all of a mess. That is all of a mess. Okay, let's see what clip he's going to play. Well, Trooper Watson, your name is now dragged into this too. We need to know what unit you were in 2022. Because I haven't heard Watson as one of the names from those that were in CPAC. It's, we would have remembered Watson. What a mess. What a mess. Well, I guess that answers that question-ish. Do you feel answered, chat? Does anyone feel resolved? Does anyone feel resolved? The defense wouldn't have agreed to it. All of you, a number of you are like, I want receipts. The defense wouldn't have agreed to the stipulation if it wasn't verified. Why would they? A stipulation is both parties agreeing to the jury that a fact is a fact. It is all the attorneys saying, this is a fact. All of the attorneys have agreed that this is a fact before the jury, not in dispute. That is what a stipulation means. That is a fact, and that fact is not in dispute. Chat is in dispute. We are unresolved. There's so many more questions. But for the purpose of the jury, this is an established fact. Lord,
Paul, Paul.
Ugh.
Turn the AC off.
There are so many more
Hold on 1 second,
questions.
please, I just want that.
There are so many more questions. For everyone, there's a full Whiskey Tango Foxtrot situation. All right, this is coming from the clip of Karen Read. I said yesterday what I thought they would play. Anybody remember what I said I thought they would play? Yesterday I said I thought they would play the clip of Karen Read talking about like picking glass out of John O'Keefe's nose. I thought they would play that after the coroner yesterday because it seemed like they were asking about the injuries. Awkward Aquarians, like the glass shard on his face. Yep. I thought after the talks about the injuries to the victim's face that they would play the clip of Karen Read talking about glass by his nose from the Discovery ID series. I can't imagine they would play anything else, but we'll see.
So John's laying there, his left and his right, and I approach John from the left. That's where the street is. And he had a piece of glass, like perched on his nose, like just wedged like a splinter would be. And I just pulled it, and as soon as I pulled it, it just gushed blood down his face.
Yep. We're going to watch that one more time. This entire statement doesn't make a ton of sense, and I have so many questions about it. But it's going to be significant to the jury that the defendant is saying that there is glass on the victim's face. They're not going to argue, could it be glass? Could it be ice? Could it be lunch meat? Could it be this? Could it be that? They're going to say the defendant says there's glass on the victim's face and she pulled it out. So as the defense tries to argue that those injuries are from something else, they're now fighting against their client's own words because there's a broken drinking glass found at the scene. There is presumed broken glass on the bumper of the vehicle. We'll see if we get more information about that today. And the defendant is saying there's glass on the victim's face and she pulled glass out of his nose. So the jury is going to take that as the defendant telling them, well, there was glass on his face. Okay. So those injuries, did those injuries come from glass? I can't imagine that the jury is going to think they came from something else after she said they came from glass. And the defense is going to be fighting against the defendant's own words that those injuries came from something else.
So John's laying there, his left and his right, and I approach John from the left.
Also, that doesn't make any sense because he wasn't laying perpendicular to the street.
That's where the street is. And he had a piece of glass, like perched on his nose, like just wedged like a splinter would be. And I just pulled it, and as soon as I pulled it, it just gushed blood down his face.
So we need this marked.
Yes. We have the item.
I wonder how much the accident reconstructionist for the Commonwealth will be talking about that drinking glass, because we've now seen 2 clips of Karen Read talking about that drinking glass, saying John got out of the car with that glass.
Your Honor, the Commonwealth calls Andre Porto to the stand.
All right. The next witness is up with Adam Lally. But Karen Read, we've seen her talk about John getting out of her car with the glass, and then they found that broken glass at the scene. So her own words connect John O'Keefe and that glass that is now broken and the glass in his face.
You solemnly swear the honesty of the court and jury in the case
So
of the
I imagine what we're going to see from the Commonwealth is argument that glass, this is my speculation, that glass is what caused the dent or the shattering of the taillight in John O'Keefe's hand. So I imagine we're going to hear in accident reconstruction a lot more about that glass. And what I have found is that the jurors generally will put quite a bit of emphasis on what the defendant says. So her words are going to be one of the hardest things for the defense to deal with in this case. Let's continue on.
Hey, Mr. Lally, whenever you're ready.
Thank you, Your Honor. Good morning, sir.
Morning.
Could you please introduce yourself to the jury, spelling your last name for the court?
Yeah, my name is Andre Porto, last name spelled Porto.
And what do you do for work, sir?
I'm a forensic scientist too in the DNA unit at the Massachusetts State Police Crime Lab.
DNA.
And where did you go to school?
I received my undergraduate Bachelor of Science in Microbiology from the University of Massachusetts in Amherst. And then I received a Master of Science in Biomedical Forensic Sciences at the Boston University School of Medicine.
Now, following your education,
Emily,
where
you
did you
didn't
go
graduate
to work?
from UMass.
I
know,
started at the
but I spent very formative years there before I transferred.
Massachusetts State Police Crime Lab in the DNA unit.
And how long have you worked at the state lab?
Slow down.
Oh, sorry.
Was the
How long
Hobart
have you
Hoedown
worked at the
still
state
a
lab,
thing
sir?
when
Since
you were at
September
UMass,
2019.
sir?
Now, when you joined the lab, what was your position and title that you were initially hired for?
I was hired as a Forensic Scientist 1.
Now, can you please explain to the jury your duties and responsibilities as a forensic scientist 1?
Sure. So a Forensic Scientist 1 is a
Look
training
at
position
Lally.
where we're
Lally's
hired
just
and
like-
we undergo an extensive training program where we do undergo the analysis process in training casework samples, where we learn how to do the lab work and analyze profiles. And at the end of this
Chrissy, that
training,
makes sense.
I took a competency test to make sure that I was able to accurately conduct the DNA analysis process. And once I passed that, I was then put on to do casework. And a year after completing both my competency tests and a year after my hire date, I was then promoted to a forensic scientist.
J-Mofo, you don't need to apologize
you're
for going to
currently a forensic
BU.
scientist too, is that
If I had
correct?
applied
Correct.
to BU, they would have
And what is
laughed
the
at my
difference between a
GPA.
forensic
I don't
scientist
think
1
they
and
had
a
a water
forensic
polo
scientist
team.
2?
So a forensic scientist 2 is just the automatic promotion that you get after a year of hire and passing the initial competency test. And we're able to do the DNA process in casework samples.
Now, so what type of analysis do you currently do at the Massachusetts State Police Crime Lab?
Can we just take a minute to appreciate, A, that Adam Lally is naturally speaking at like 1.25 speed, and B, his questioning is so cleaned up. His questioning is just, we're not 17 questions into background training and experience. It's just boom, 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 boom. I have to wonder if for Lally, not having every single witness be his responsibility has helped not only in preparation, but also in his cadencing, because this trial is a lot for one attorney to do. And I just wonder if that has allowed him to just take a breath and go back through when it is not so intense for him to ask the questions, because it's much more effective. Just much more effective. Like, Lally had his Wheaties this morning. He's just ready to go. Just ready to go.
I can do the DNA analysis process in casework and
it's
no
Massachusetts.
samples.
He had his Dunkin' this morning.
That
Let's
includes
be
the lab
honest.
work as well as analyzing the DNA profiles that are generated from the work.
Now, first, just in general terms, but specifically with reference to DNA analysis, can you explain to the jury how is that
Lally, who
analysis
dis?
performed?
Sure. So there's 4 steps in the analysis process. The first step is extraction, where
How many
we apply
breakfasts will we
heat and
talk about
chemicals to the
DNA?
samples to break open the cells and release that DNA to be available for use.
Release the
Step 2 is called
DNA.
quantitation, where we take a small sample of that extracted DNA to estimate, and we use chemicals and run it through an instrument to estimate how much DNA we extracted. And then we proceed to step 3, which is called amplification. And that's basically, think of it as a molecular
morning was so
photocopier
wild.
where we target specific areas of the DNA
And
to
now
make millions of copies of it.
we've got a
and
couple
then
hours
we
of
run
DNA.
it through, go to detection, where we run it through an instrument, and we generate the DNA profile as an electronic file on a computer.
Now, is the state lab where you work accredited?
Yes, it is.
And by whom?
Trooper Watson, man.
We are accredited by an organization called
are
ANAB,
you?
which stands for ANSI National Accreditation Board, and ANSI stands for American National Standards Institute.
I need you to slow down. Please.
Sorry.
Sir, it's a lot of science words. You're delightful. It's a lot of science words. And the court reporter is like, help. I do
Now,
not
Mr.
have them
Porto,
sped
are
up.
there steps taken in your lab during that process that you were just explaining to prevent against contamination?
Yes, there are.
And can you explain what those are?
Sure. So there are various steps. One step to prevent contamination between analysts would be to bleach and wipe down the workstations before use and after. Another way to prevent DNA transfer from analysts to the samples is to wear personal protective equipment, such as lab coats, gloves, masks, hairnets, and beard guards. And a way to prevent transfer from
Beard
sample
guards.
to sample would be to frequently change gloves, as well as only have one sample open at a time.
Oh, yes. You don't want to commingle
Now,
the DNA accidentally.
with your work at the lab, is there a review process that your work undergoes?
Yes, there is.
And can you describe that process to the jury?
Sure. So once I complete my work, the file undergoes two types of reviews. The first is a technical review, where another
That's
qualified analyst will take the file and they'll do
different
their own
lawyer today.
independent assessment and make
Annie
sure
said-
that they come up with the conclusions and that they agree.
To be fair to Lally, and he said, I've seen Lally in another case, and this is his normal. What he did last time was weird. It is. It's a whole different thing. I just wonder what the I wonder what the inter-office pressure dynamics were like prosecuting this case, because I've definitely seen prosecutors who weren't quite themselves in court in high pressure cases, especially when the cameras turn on. It not everyone wants to be streamed in that way. So this is a whole different attorney. I'm not mad at it. It's direct, it's clean, it's crisp, it's easy to follow. Get it,
with the
Lally.
conclusions that I reached, and they'll also make sure that all the protocols were followed and every decision is scientifically sound. Once that review is completed, it undergoes an administrative review, where another qualified analyst will then look through the file and they look for clerical errors,
He is still
such
talking
as
really
typos
fast.
or missing page numbers or missing case numbers. Once those two reviews are completed, the results can then be reported out.
Now, as a part of that accreditation process that you were speaking about a few moments ago,
It's time to just eat
do you
breakfast,
undergo
y'all.
anything called proficiency testing?
What do
Yes, I do.
y'all have for breakfast?
And can you explain to the jury what that
some wild grain
proficiency
biscuits.
testing process consists of?
They're delicious.
Yeah, so a proficiency test
some
is a
sausage.
test that's administered twice a
this
year
morning.
by an external vendor. And the results of this test are not known to the analyst at the time. And we basically treat it like it's a real case where it undergoes the analysis process as if it were a real case. And this test is used to show that the analyst is demonstrates ongoing competency in the DNA analysis process. And successful completion of the test is required to maintain qualification as an analyst.
And what areas do you specifically undergo proficiency testing in?
DNA analysis.
Look how quick they're
And have
moving
you
along.
successfully completed each of those proficiency tests that you've taken?
Just like,
Yes.
Now, Mr. Porto, could you explain to the jury what exactly is DNA?
Yeah, so DNA stands for deoxyribonucleic acid, and it's basically the building block that makes us who we are. We each have two copies of our DNA, one that we inherit from mom and one that we inherit from dad. And that this combination makes sure that, barring with the exception of identical twins, we all have different DNA.
And is DNA the same in every cell of a person's body?
sir, can we talk
Yes,
about
so
the
what that means
mitochondria?
is if I were to take a
We
blood
learned
sample
about
and a
that a
saliva
lot.
sample from the same person, the same DNA profile will be generated.
Now, you spoke a bit earlier about the different steps included in the DNA testing. If you could, just a little bit slower, go through each of those 4 steps again for the jury.
Sure. So like I said, it's a 4-step process. So extraction, quantitation, amplification, and detection. So extraction, we use chemicals and heat to burst open the cells to make that DNA available for use. Quantitation, step 2, we take a small sample of that extracted DNA. We use a different set of chemicals and an instrument to estimate how much DNA is available for use. Amplification is the third step, which I mentioned is the basically molecular photocopier, where it makes millions of copies of specific areas of the DNA. And then the fourth and last step is detection, where we run those amplified copies through an instrument, and we generate the DNA profile as an electronic file on the computer.
Now, Mr. Porto, what is STR?
So
Mr.
STR
Porto,
stands for short tandem repeats,
down.
and they're the locations that we're making the millions of copies of.
Now, in your work at the lab, do you have something that's referred to as a known item?
Yes.
And can you explain to the jury what a known item is?
Sure. So a known item is an item that's taken directly from a person to be used as a reference sample, so we know what the source of that profile is.
And conversely, what is a questioned item?
A questioned item is an item that's taken, let's say, from a crime scene where we don't know what the source is.
Lauren, that's fair. Lauren said I know
Now,
too much
do you
about
also have
mitochondria now due
chronology
to my
within your
master's
lab
degree.
as far as a parent
I was
versus
making
a
a high
child
school
item?
biology joke.
Yes, we do.
And can you explain how those labels are and how they reference to what you do in your work?
Sure. So a parent item is, for example, the original item, and the child is a sample of that item. So, for example, this box of tissues would be the parent item, and if you were to swab the outside, the swab would be the child item. So the box of tissues would receive, let's say, an item of 1-1. The swabbing of the outside would receive an item of 1-1.1.
That's a great way to describe it.
What are
It is so clean and clear to be like, how do you number things? We number the box, then we number the swab, and the swab gets the point, whatever. Really, really easy to explain the item plus the swab.
positive and negative
Appreciate that.
controls?
Yeah, so a positive control is a control that has it's a known sample with a known DNA profile that we use in every step of the DNA analysis process to make sure that each step and instrument worked as expected and properly. And then a negative control is a sample that has no DNA in it. It only
Controls?
receives the chemicals that we use. And that's to ensure
Look
that the
at
chemicals
that.
that we're using don't have any DNA inherent to them.
Like a whole scientific
Now,
process.
when you
and
as an
shit.
analyst or a forensic scientist too are assigned work within the DNA unit, where do you retrieve that evidence from?
Yeah, so I retrieve it from a locked cold room that's only accessible via keycard.
Now, why are items kept in cold storage?
Yeah, the cold storage helps preserve the DNA for long-term storage.
And as far as the
Look
the
at how
heat
well he
versus
understands the
cold,
process. This is the process.
why is it that it's specifically kept, or why does the coldness of the storage room help preserve the item?
The cold can help prevent, let's say, growth of bacteria and mold that can degrade DNA.
Lally,
And
we're
what
dealing
does
with
heat do conversely,
biological
in
material. It can
reference
get
to
nasty.
An item of forensic value.
Heat can help degrade DNA and also promotes bacterial and mold growth that can further degrade that DNA.
Now, when you receive an item from the cold storage, how is that item typically packaged when you retrieve it from there?
Sure. So the item comes in these plastic, clear, transparent plastic sealed containers that has a label with a case number on it. And inside of that, each sample is within like a small plastic tube that has a label with a case number and item number.
Now, at some point, were you assigned to perform some work on a lab case number 22-02184 pertaining to this defendant, Karen Read?
Yes, I did.
And what type of work in general terms were you assigned to do in this
This
case?
is where I
I was
would slow
assigned to
them
do the
down,
DNA analysis process.
but I don't have them sped
That
up.
was on several items, is that correct?
Correct.
They are just
And
zooming
could you
on
explain to
their
the jury
own.
the sort of the process that you used to analyze evidence in this case?
Sure. So the case underwent the 4 steps that I explained before. So extraction, quantitation, amplification, and detection.
And
Oh, yeah, I don't have them on
there was a known
1.25.
standard that was done in this case, specifically in item number 8-1.1.1. Is that correct?
Correct?
And did another analyst test and report the results from the known blood standard from that item 8-1.1.1?
Correct.
And how is that done?
Yeah, so that undergoes the same process that I explained. It'll go through the 4 steps: extraction,
How fast
quantitation,
Lally's
amplification,
going.
detection. And then the analyst that did the interpretation and reported that out, the known standard out, they went through the profile to make sure that it's from one person or single source. And once that went through the review process that I explained, so technical and administrative review, and once that was all completed, the standard was available to be used for comparisons.
And y'all, I
And to
agree.
whom was that?
This is normal speaking speed for many of us, especially those of us whose brains process at the speed of ADHD. Unfortunately for the court reporter, taking down scientific testimony at this speed is wild. Like, this is very fast for court speed, especially for scientific testimony. But this witness and Lally know that the jury just wants the answer. What's the thing you tested? What was the result? That's it. But Lally has cut down his background, training, and experience questions to just the main points that are needed, and it's freaking glorious. I am so happy to see it because it was so frustrating last trial. So I'm here for all of it. But the poor court reporter the court asked the court reporter asked him to slow down. The judge asked him to slow down. This is fast for court speed. And, the typing court reporter, somebody would throw up their hands and be like, slow down. They would be gesturing wildly.
Known standard identified as belonging to?
John O'Keefe.
Now, you used the word in there as far as a single source. Can you explain to the jury what your understanding?
Do we know what was tested? Yes. Yeah. Yes, we do. We know what was tested. It was item 8-1.1.1. And we're talking about the known samples.
And once that was all completed, the standard was available to be used for comparisons.
And to whom was that known standard identified as belonging to?
Known standard.
John O'Keefe.
Now, you used the word in there as far as a single source. Can you explain to the jury what your understanding of that term is based on your training and experience?
Sure. So a single source is just a DNA profile that has one contributor to it. So only one person contributed DNA to that profile.
Right.
What exactly is a DNA profile?
Yeah, so a DNA profile is basically the combination of all of the locations that we amplified during the third step of the process. And it's basically, you can think of it as like a chart, like an EKG, where it has peaks and valleys, and each peak has a specific number, and the DNA profile is just a combination of all those numbers put together.
Now, can you explain to the jury in general terms, to start with, the process of comparison between a known standard and a questioned or unknown standard?
Sure. So first, I did the analysis on the question items. I did the 4 steps. I analyzed the profiles that were generated. I then interpreted, make sure that I could determine the number of contributors. And once that was completed, I then used the standard that was available and compared them to all the profiles that were suitable for comparison.
Amy asked if I think Brennan
Now, sir,
wrangled
starting
Lally's
with
questions.
Item 3-1.1.
I think this is
what
probably.
was that a sample from?
I think this is probably Lally's normal. I think that there were impacts from the other trial that probably impacted the way that trial went. So I think this is probably his normal. I imagine he and Brennan didn't talk about it much, unless Brennan said, "Look, it's going to be fine to just keep it simple."
That was a sample from taillight passenger.
And from a specific vehicle, is that correct?
Correct.
And what, if any, information were you given as to that vehicle that the swab from the taillight was from?
Taillight swab.
Do you mean like the license plate? Could I refer to my notes?
Yes.
Thank you.
Lally, what do you mean?
Your Honor, with the court's permission, this is a little detail towards the testimony.
I don't
goes.
have
May-
a problem. Does the defense object?
I do not object.
Okay, thank you.
Thank you, Your Honor.
The question was
So the license plate.
essentially, may the expert refer back and forth to their notes without asking each time if there's no objection from the defense? And you heard Yannetti say there's no objection. Just there's a lot of technical notes in there. We just need the identifying numbers to be correct, and we don't need to be going back and forth and back and forth and back and forth. The defense has the reports. The prosecution has the reports. They all are
It was
fine.
right,
Just
3G6
read the license plate number. It's
684.
fine.
Right, I'm sorry. 3GC 684.
Now, with reference to the swab from the taillight, were you able to generate a DNA profile from that item?
I was.
And from your comparative analysis from that question item to that of the known standard of John O'Keefe, what did you conclude?
So the DNA profile was interpreted as a mixture of 3 contributors, including male DNA. And the DNA profile from this item is at least So sorry. I'll just restart. So the DNA profile was interpreted as a
That was the please slow the fuck down, sir. I don't know if that was the court reporter's hand. I think that it was. That was like, please slow down.
male DNA, and the DNA profile from this item is at least.
That's the court reporter.
So sorry. I'll just restart. So the DNA profile was interpreted as a mixture of 3 contributors, including male DNA, and the DNA profile from this item is at least 510 non-alien times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals. This provides support for an inclusion.
Now, sir,
The taillight has John O'Keefe's DNA on it. Is anyone surprised? Is anyone surprised at all? No. No. It has John O'Keefe's DNA and 2 unknown DNAs on the taillight. So it is at least 510 nanillion times more likely that is John O'Keefe and 2 unknowns than it is 3 unknowns. So it is John O'Keefe plus 2 unknown DNA.
what does that mean?
So an inclusion is basically when I look at the
Tell us more about the unknown. Don't worry.
DNA profile that was generated,
Don't worry.
and I compare it to the known DNA profile. And if the characteristics of
I
the
just don't
known
think any of this
profile
is
are
a
consistent
serve.
with the characteristics observed in the questioned DNA profile, that's an inclusion.
My husband is calling.
Now, as far as that number, 510 non-alien, how many zeros in that number?
So a non-alien is a 1 followed by 30 zeros.
Now, that profile, in addition to Mr. O'Keefe's profile, also had 2 unknown contributors, correct?
Correct.
Now, was that item also submitted to an outside vendor named Bodhi Technologies for further analysis?
Correct.
And with reference to your comparative analysis from the profile from this item to Mr. O'Keefe profile, if you could again just expound upon what does inclusion mean?
Yes, so an inclusion, I compared the known standard that I had available for use from John O'Keefe to the DNA profile generated from the taillight. And the DNA profile was, if that was consistent with the DNA profile that I observed in the questioned item, and that's what an inclusion means.
Now, regarding item 3-6, what is the description of that item?
Yeah, so 3-6 is a root end of hair from exterior passenger side rear panel.
And is that the same vehicle as far as the taillight sample?
Correct.
The hair.
Now, with respect to hair in general, there's a root end and a shaft end, correct?
Correct.
And what limitations does your lab have with regard to DNA testing of hair?
So when we test hair, we're actually, the root end of the hair, we're looking at any potential skin cells that might be attached to the root end. So that's where the DNA that we're looking for is coming from. And if there's not too many, yeah.
Are you familiar with the term based on your training experience known as autosomal DNA?
Yes.
Oh,
And
goodness.
can you describe for the jury what your understanding of that term is?
Yeah, so autosomal DNA is DNA that's located in the nucleus of the cell, and that's the DNA that we inherit from both mom and dad.
Now, are you also familiar based on your training experience with a term known as mitochondrial DNA?
Yes.
And can you please explain to the jury what your understanding of the term mitochondrial DNA is?
Yeah, so mitochondrial DNA is DNA that's found in the mitochondria of a cell, and we inherit that from the mother.
It may be somewhat evident, but could you please explain to the jury sort of the difference between autosomal DNA on the one hand and mitochondrial DNA on the other?
Yeah, so like I said, the autosomal DNA is the one that we have 2 copies of, where we inherit one from mom and one from dad. And then the mitochondrial DNA is a circular DNA that we just inherit from mom.
Now, is the Massachusetts State Police Crime Lab equipped to perform mitochondrial DNA testing?
No, we're not.
Now, was the DNA extract from the hair also sent to that external vendor, Bodhi Technologies in Lorton, Virginia?
I'm not sure if the extract was sent, but I know that the shaft of the hair was sent to Bodhi.
And we will see
Now, what testing
the
did you
technicians from
perform on
Bodhi
the hair?
at some point.
I did the regular DNA analysis process on the root end of the hair.
And that was done prior to it being shipped to that external vendor, is that correct?
Correct.
And what conclusions were you able to draw from the testing that you did on the hair?
Yeah, so there was no human DNA detected, and STR analysis was not performed.
Now, what does that mean, sir?
Yeah, so
Can you just tell us if it's a dog hair? That's really all we want to know at this point.
So there might be DNA on there, but it was below what our instrumentation could detect.
Also,
Now,
if
turning your attention.
if the hair was John O'Keefe's, would it shock anybody? Like, I think the hair is more relevant if it's somebody that's not John O'Keefe or Karen Read. I don't know if the hair is super relevant if it is John O'Keefe's. You know? The only way that I would find the DNA to be super compelling is if they had swabbed the edges of the broken taillight versus the outside that anyone can touch anytime they touch the car. If it was the pieces of the taillight that aren't going to be touched until it's broken during the breaking and after, that would be more persuasive to me.
Into item 3-2.1.1.
But they didn't swab that, so we'll never know.
What is the description related to that item, sir?
It's a sample from the exterior of broken drinking glass.
And is
We'll
there
get
any
to the
further-
exterior of the drinking glass. Rocky, he didn't say not human hair. He said no human DNA detected. And that could mean that the sample size is just too small. I was just quipping. Do not take away from that testimony that the hair is not human. That's not what he said. So I was just being quippy.
Other indication as far as the broken drinking glass, as far as where it was recovered?
Oh, yeah, 34 Fairview Road.
And were you able to generate a DNA profile from this item, the drinking glass?
Yes, I was.
And from your comparative analysis from this question item to that of the known standard of John O'Keefe, what did you conclude?
Yeah, so the DNA profile was interpreted as a mixture of 3 contributors, including male DNA. The DNA profile from this item is at least 530 non-alien times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals. This supports an inclusion.
This is the last time I'll ask you this, but just if you could reiterate to the jury, what does an inclusion mean?
Yep, so an inclusion is when I compared the known standard to the question item, and if the profile in the known standard is consistent with the profile in the question profile, that's an inclusion.
And that number again, as far as 530 non-alien, how many zeros again in that number?
That's a 1 followed by 30 zeros.
Cool. Big
Now, sir, if I
numbers.
could turn your attention
But
to
there's
another
also
item,
2 unknown samples in that.
7-1.2.1. What is the description related to that item?
Sample from stain A on upper right leg of jeans.
And is there any further indication as to whom those genes belong to?
John O'Keefe.
Now, were you also able to generate a DNA profile from this item, the stain A on the upper right leg of Mr. O'Keefe's jeans?
Yes, I was.
And from your comparative analysis from the question item to that of the known standard of John O'Keefe, what did you conclude with reference to that item?
The DNA profile was interpreted as a mixture of 3 contributors, including male DNA. Contributor 1 is suitable for comparison, and due to limited information, contributors 2 and 3 are not suitable for comparison. The DNA profile from this item is at least 570 non-alien times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals.
suitable means
this
it's
provides
too
support
small.
for an inclusion.
And that
Thank you, sir. Now, turning your attention
Combined
to
DNA.
item 7-1.3.1, what is the description related to that item?
Sample from stain B on upper right leg of jeans.
And same genes as the previous item?
Yes.
Now, were you able to generate a DNA profile from this item, stain B, on the upper right leg of the genes of Mr. O'Keefe?
Yes, I was.
And from your
And?
comparative analysis from this questioned item to that of the known standard of John O'Keefe, what did you conclude?
Yep, so the DNA profile was interpreted as a mixture of 3 contributors, including male DNA. The DNA profile from this item is at least 660 non-alien times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals. This provides support for an inclusion.
Now, sir, with reference to item 7-1.4.1, and again, these items with the dash and the point, is that what you're referring to earlier as the parent-child relationship between items?
Yes.
And what is the description for
weird way.
7-1.4.1?
Sample from stain C on upper right leg of jeans.
Now, were you able to generate a DNA profile from this item from stain C on the upper right leg of Mr. O'Keefe's jeans?
Yes, I was.
And from your comparative analysis of this question item stain C to that of the known standard
for
of...
future lawyers and current lawyers everywhere, if the court will allow it, just put up a picture of the jeans that are labeled with the stains so the jury can see it when they're talking about it. Just put up a picture. Stain A, stain B, stain C. It's already been admitted. Just let them see where it's coming from so they don't have to go compare later.
John O'Keefe, what did you conclude?
The DNA profile is a mixture of at least 2 contributors, including male DNA. Contributor 1 is suitable for comparison. Due to limited information, contributor 2 is not suitable for comparison. The DNA profile was interpreted as a mixture of 2 contributors. The DNA profile from this item is at least 830 non-million times more likely if it originated from John O'Keefe and an unknown individual than if it originated from 2 unknown, unrelated individuals. This provides support for
John
an inclusion.
O'Keefe's blood is on John O'Keefe's jeans.
Now, sir, with reference to item 7-1.5.1, what was the description of that?
Sample from stain D on upper right leg of jeans.
Now, were you able to generate a DNA profile from this item from stain D on the upper right leg of Mr. O'Keefe's jeans?
Yes, I was.
And from your comparative analysis from this item to the known standard of John O'Keefe, what did you conclude?
The DNA profile was interpreted as a mixture of 3 contributors, including male DNA. The DNA profile from this item is at least 670 non-million times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals. This provides support for an inclusion.
But were they suitable for testing? Were
Now, sir, did you also do some testing on an item 7-1.6.1?
Yes, I did.
And what was the description associated with that item?
Sample from stain E on upper right leg of jeans.
And were you able to generate a DNA profile from that item, stain E, on the upper right leg of Mr. O'Keefe's jeans?
Yes, I was.
And from your comparative analysis from that question item to the known standard of John O'Keefe, what did you conclude?
The DNA profile was interpreted as a mixture of 2 contributors, including male DNA. Contributor 1 is suitable for comparison. Due to limited information, contributor 2 is not suitable for comparison. The DNA profile from this item is at least 1.0 decillion times more likely if it originated from John O'Keefe and an unknown individual than if it originated from 2 unknown, unrelated individuals. This provides a support for an inclusion.
I used a
Megan,
different number
he did
there
not-
as far as the decillion.
He has
how
not
many
said
is your-
that each one was the unknown were male DNA. He is saying including male DNA, which could simply be John O'Keefe's, because on a number of these, the other contributors are too small to get a sample from. So it is really going to just depend on, when was the last time John O'Keefe washed his jeans? He was at a bar with other individuals. There could be a lot of things, but he didn't say that each sample had 3 contributors and all 3 contributors were male. He said that there are unknowns and most of those unknowns couldn't be tested. So that's where we're at on that. Hopefully that helps. So the unknowns are unknown because a lot of those sample sizes were too small. It means there's other DNA there, but they can't get enough DNA to sequence it to compare it to anything that's just not suitable for comparison. So sometimes he is saying that there is John O'Keefe's DNA and 2 unknowns that aren't suitable for comparison, meaning the amount of DNA is so small they can't even make a profile to compare it. So I'm noting when he is not saying that they're not suitable, because I wonder if on cross we're going to get to, well, you didn't say on stain D that the 2 unknowns were not suitable for a comparison sample. So were the 2 unknowns on stain D run through anything? Or were they too small? So right now they're going through all the stains on the genes and the contributors, but we do not know the makeup of the unknowns. And we might hear some of that on cross, but the sample sizes are just too small. So that language of not suitable for comparison, there's just not enough DNA there. And there's just not enough DNA there. So those stains are John O'Keefe's blood and other snippets of profiles. And it could be a lot of things, but it could include, and they haven't said, and I don't know if they will get to it on cross, but it could be Karen Read's DNA from hugging on John at the bar. It could be DNA from people, from really anything, because it's a pair of genes. So we'll see. But we're going to go through all of the different stains. They're moving pretty quickly. And they did get permission from the court for him to go through that with his notes instead of to have to refresh each time. Everyone has these reports. No one is fighting over what's in the reports. And it's important to have this information come in accurately because the report is not in evidence with the jury. The testimony is. So that was already permitted by the court.
Zeros is a decillion.
Yeah, a decillion is a 1 followed by 33 zeros.
That was a lot of DNA in that one.
Now, with
There's a
each of
bigger
those
sample.
items that you just testified about as far as the genes, the question items from the stains on Mr. O'Keefe's jeans, those were each located on the right leg, correct?
Correct.
Correct.
Now, did you also perform some analysis on item 7-1.7.1?
I did.
And what is the
Lisa, he did
description
not give that
associated with
information.
that item number?
Sample from unstained areas of the exterior of jeans.
Now, were you able to generate a DNA profile from that item, from the unstained areas of the exterior of Mr. O'Keefe's jeans?
I was.
And from your comparative analysis from this questioned item to the known standard of John O'Keefe, what did you conclude?
The DNA profile was interpreted as a mixture of 4 contributors, including male DNA. The DNA profile from this item is at least 53 septillion times more likely if it originated from John O'Keefe and 3 unknown individuals
So these are
than if it originated from
non-stained
4 unknown,
areas of the
unrelated
gene.
individuals. This provides support for an inclusion.
So
And
unstained
again,
area
sir,
of the
with that
genes.
number, as far as 53 septillion times more likely, how many zeros in a septillion?
A
Good
septillion
Lord.
is a 1 followed by 24 zeros.
So John O'Keefe's DNA is on John O'Keefe's genes,
Now, sir, if I could turn your
where
attention
even where
to,
there's not blood.
What's listed as number 12 in your report, but item 7-18.4.1. Did
again-
you do some testing on that item as well?
Yes.
If I'm on the jury and you're not showing me the picture of the genes right now, I'm fighting for my life to stay engaged by taking notes. It's the only way my brain wouldn't start just singing, I don't know, the entire Dave Matthews Band discology in order, or at least trying to name all of the albums in chronological order and then each song per each album, because my brain would find something else to do. But attorneys don't often do that because they don't always think that the jury wants to see where the different spots on the genes are.
And what was the description
The
associated
jury's
with
hearing
that?
John O'Keefe's DNA's on John O'Keefe's
Sample from
genes.
stain C on top front gray, on top front of Gray's long sleeve shirt.
So now we're moving to
And the
the
gray long
hoodie.
sleeve shirt, is that attributed as belonging to a specific person?
Yes, John O'Keefe.
And were you able to generate a DNA profile from that item, specifically sample from stain C on the top front of the gray long sleeve shirt of Mr. O'Keefe?
I was.
And from your comparative analysis from that questioned item from the shirt to the known standard of John O'Keefe, what did you conclude?
So the male DNA profile was interpreted as originated from a single contributor. The DNA profile from this item is at least 58 octillion times more likely if it originated from John O'Keefe than if it originated from an unknown, unrelated individual. This provides support for an inclusion.
Okay.
And again, sir, that
John
number
O'Keefe's
as far
DNA
as
is on John
58
O'Keefe's hoodie?
octillion times more likely, how many zeros in an octillion?
So an octillion is a 1 followed by 27 zeros.
Now, sir, if I could take you down to listed as 15 in your report, but did you do some testing on item 7-18.14.1?
I did.
And what was the description associated with that item?
So sample from stain L on back bottom right of gray long sleeve shirt.
And were you able to generate a DNA profile from that item?
I was.
And from your comparative analysis with reference to that item, the sample from stain L on the back bottom right of the gray long sleeve shirt, in comparison to the DNA profile from the known standard of John O'Keefe, what did you conclude?
So the DNA profile was interpreted as a mixture of 2 contributors, including male DNA. The DNA profile from this item is at least 1.0 decillion times more likely if it originated from John O'Keefe and an unknown individual than if it originated from 2 unknown, unrelated individuals. This provides support for an inclusion.
Now, sir, did you also perform some analysis on an item numbered 7-18.17.1?
I did.
And what was the description associated with that item, sir?
Sample from unstained areas of exterior of gray long sleeve shirt.
And similarly, were you able to generate a DNA profile from that item to sample from the unstained areas of the exterior of the gray long sleeve shirt of Mr. O'Keefe?
I was.
And from your comparative
was
analysis
John
from that
O'Keefe.
question item to that of the known standard of John O'Keefe, what did you conclude?
The DNA profile was interpreted as a mixture of two contributors, including male DNA. Contributor 1 is suitable for comparison, and due to limited information, contributor 2 is not suitable for comparison. The DNA profile from this item is at least 960 non-alien times more likely if it originated from John O'Keefe and an unknown individual than if it originated from two unknown, unrelated individuals. This provides support for an inclusion.
Thank you, sir. I'm going to group a couple, four separate items from your report, starting with what's listed in your report as number 9 is item 7-3.1.
Are we moving to a different item
Correct.
from the
And
gray
what is the
hoodie?
description associated with that item, sir?
Are we done with the
Sample
hoodie?
from stain D on bright instep of sneaker.
And 11 from your report, you also did some analysis on item 7-18.3.1. Is that correct?
Correct.
And what was the description associated with that?
Sample from stain B on top front of gray long sleeve shirt.
And item 7-18.7.1, do you see that as well?
Yes.
And what was the description associated with that item?
Sample from stain F on top front of gray long sleeve shirt.
Okay, still on the
And
hoodie.
lastly, in this group, item 7-18.8.1, what was the description associated with that?
Sample from stain G on back left sleeve of gray long sleeve shirt.
And with respect to each of those last four samples from those items, were you able to generate a DNA profile with respect to each of those four?
Profiles were generated from them.
And what did you conclude based on the generation of those profiles with those four items?
Yeah, so the profiles that were generated were not suitable for comparison.
All right, they were too
And
small.
if you could explain briefly to the jury, when you say not suitable for comparison, what do you mean by that?
Yeah, so for 7-3.1, it was a mixture of at least 5 contributors. And at the DNA unit, we validated, basically we tested and make sure that our protocols were we can only interpret mixtures of up to 4 contributors. So I determined that there were 5 contributors, so that makes it too complex for us to do comparisons to it. So it's not suitable for comparison for that reason. And the other 3 items, due to the quality of the profile, they were not suitable for comparison. And basically what that means is that there were such low amounts of DNA that was in the sample that there was a lack of information from the profiles themselves, so they weren't really suitable for comparisons.
And just to be clear, the item that you're referring to with the 5 possible contributors, that's a shoot, correct?
Correct.
Now, if I could turn your attention in your report to what you have listed as number 10, there are a number of different items listed there, correct?
Correct.
And starting with item 7-17.2.1, what is the description associated with that?
Sample from stain A on top front left of orange t-shirt.
And
All right, we're on to the t-shirt.
7-17.3, what is the description associated with that?
Sample from stain B on top of front left of orange t-shirt.
And item 7-17.4.1, what is the description associated with that?
Sample from stain C on top front left of orange t-shirt.
And item 7-17.5.1, what is the description associated with that item number?
Sample from stain D on front bottom right of orange t-shirt.
And item 7-17.6.1, what is the description associated with that?
Sample from stain E on back left shoulder of orange t-shirt.
And so each of those respectively were samples taken from stains on the orange t-shirt of Mr. O'Keefe, correct?
Correct.
Okay.
Now turning your attention to item 7-18.2.1, what is the description associated with that?
Sample from stain A on right sleeve of gray long sleeve shirt.
So he's
And item
lumping all of these together.
7-18.5.1, what is the description associated with that?
Sample from stain D on center front of gray long sleeve shirt.
And item 7-18.6.1,
I just have to wonder if these are
what is
all
the description
not
associated
suitable
with
for
that?
comparison.
Sample from stain E on center front of gray long sleeve shirt.
And item 7-18.9.1, did you generate a profile from that item as well?
Yes.
And what is the description associated with that?
Sample from stain H1 on back left of gray long sleeve shirt.
And
I
item
think Moxie
7-18.
in the chat said 5 contributors from an item found in a blizzard. Here's what's hard about John O'Keefe's clothes. They got thrown onto the floor of an ambulance and then thrown onto the floor of a hospital and then put in a evidence bag. and then put on butcher paper and then at some point checked into the lab. So the clothes were all over the place. So I don't find a ton of evidentiary value in what is or is not on the clothes because they were all over the place due to life-saving measures. So it's just, for me, it's just, okay, the clothes were all over the place. However, if they didn't test the clothes, it opens the door for a lot of arguments about why didn't they test the clothes? So they have to go through the testing of the clothes. They have to show what the testing shows, even though a lot of the samples were taken off the clothes and there just wasn't enough DNA on the sample to make a profile. So they have to bring it in. But the clothes are contaminated based on where they went after John O'Keefe was treated. So it's just, it has to come in because otherwise the argument is nothing was tested, and it has to be walked through. But a lot of the areas when they got those not suitable for testing, just the DNA sequencing couldn't be done because the sample size is so small. That doesn't surprise me with how wet everything was. So is it super relevant? Yes, because you need to talk about what was done, what was tested, and what the results are. But is it determinative one way or the other? I don't think so. I don't think it's determinative one way or the other because of how much cross-contamination there is for all of this. So that's kind of where there is. LSC said, shouldn't there be an evidence log? There is an evidence log once it gets to the lab, but there sure should be one before it gets to the lab, and there isn't. So, Joe D, why would his clothes come off in the ambulance? They cut all of his clothes off for life-saving measures and to treat him, which is not uncommon in this circumstance. So they were undergoing life-saving measures. All right, let's continue on.
Point 10.1, what is the description associated with that?
Sample from stain H2 on back left of gray long sleeve shirt.
And item 7-18.11.1, what is the description associated with that?
Sample from stain I on back right shoulder of gray long sleeve shirt.
And item 7-18.12.1, what is the description associated with that?
Sample from stain J on back bottom right of gray long sleeve shirt.
And lastly, with this group search, item 7-18.13.1, what is the description associated with that?
Sample from stain K on back bottom right of gray long sleeve shirt.
And so each of those items beginning with 7-18 were associated with various stains taken from various areas on the gray long sleeve shirt of Mr. O'Keefe.
So many
correct?
stains. That was
Correct.
a massive
And
group of
with
stains.
respect to each of those areas of the orange T-shirt and the gray long sleeve shirt, were you able to generate a DNA profile from those items?
I was.
And from your comparative analysis of each of the DNA profiles from those items to the known standard of John O'Keefe,
They just grouped a
what did
massive
you
amount
conclude?
together.
So the male DNA profile was interpreted as originating from a single contributor. The DNA profile from these items is at least 490 octillion times more likely if it originated from John O'Keefe than if it originated from an unknown, unrelated individual. This provides support for an inclusion.
Now, again,
So,
if you could just remind the
That
jury,
entire list that they just read through, that whole list of swabs is all single contributor DNA. So all of it is just John O'Keefe's DNA is on his clothes. Okay.
and when you say single source contributor, what does that mean?
Yeah, so a single source
Just
profile
all of
is a profile that has one contributor to it. So like one person contributed DNA to that
I'm
profile.
going to finish eating breakfast.
And with respect to the number as far as 490 octillion
Unless
times
he's taking
more
notes
likely,
about something else.
how many zeros are in that number?
So an octillion is a 1 followed by 27 zeros.
Now, lastly, sir, did you perform any analysis with reference to items numbered 8-2 and 8-3?
I did.
And what were the descriptions, respectively, for items 8-2 and 8-3?
So item 8-2 was right hand fingernail clippings from John O'Keefe, and item 8-3 were left hand fingernail clippings from John O'Keefe.
So fingernail clippings from both the right and left hand of Mr. O'Keefe.
Correct.
And were you able to generate a DNA profile from those item numbers, the right and left hand fingernail clippings of Mr. O'Keefe?
I was.
And based on, from your comparative analysis of the DNA profile from the right and left hand fingernail clippings, both of Mr. O'Keefe, taken in conjunction with the known standard of John O'Keefe, what did you conclude?
Yeah, so the male DNA profile was interpreted as originated from a single contributor, and the DNA profile from these items is at least 490
So there was no
octillion
other
times
DNA
more likely
under John's
if it
fingernails.
originated from John O'Keefe than if it originated from an unknown, unrelated individual. This provides support for an inclusion.
So with respect to each the right and left-hand fingernail clippings of Mr. O'Keefe, both of those were identified by you
All right.
or your analysis as
So
a
John
single
O'Keefe's
source
fingernail,
contributor, correct?
clippings were
each,
all tested for DNA.
490 octillion times more likely
Only
to have
John
originated
O'Keefe's
from John O'Keefe than from an
DNA.
unknown, unrelated individual. Is that correct?
Correct.
Thank you.
Okay.
Thank you, sir. I have nothing further on.
Okay. On to
Yes.
cross. I imagine it won't be extensive, but on to cross with Yannetti.
Good morning, sir.
Good morning.
Mr. Porto, I would like to start by asking you about item 3-1.1, which you've identified as a sample from the passenger side taillight of the vehicle. Can you orient yourself in your report to that item?
Yes.
And that, of course,
He's like, can you
was
flip to the page?
passenger side taillight that was attached to the vehicle, correct?
Correct.
You were never asked to do any DNA comparison on any pieces of taillight connected with this case, correct?
Let me check my other report. For taillight, there was another item that was item 3-3.1, which is sample from apparent glass on rear bumper, if that's what you're referencing.
Okay, so if I suggested to you that the taillight was plastic, that glass wouldn't have been the taillight, correct?
I don't have, that's beyond my scope of testing.
Gotcha. Okay. With regard to the
And that's
passenger
fair.
side taillight,
He's like, I tested glass that was recovered from the bumper. I can't tell you if that is pieces of taillight or not pieces of taillight because I don't know. But they can close that door with another witness because the answer is he didn't test any other pieces of taillight. And we know the glass on the back of the bumper is not taillight. He doesn't know that.
found that there were 3 contributors of DNA to that taillight attached to the vehicle, correct?
Correct.
Right.
One of those contributors appeared to be John O'Keefe. Is that fair to say?
He was included into
right.
the profile.
With regard to the other 2 contributors, who were they?
They could be anybody.
Unknown.
Were you ever asked to compare DNA samples from either Canton Police Detective Kevin Albert or Canton Police Chief Kenneth Berkowitz to the DNA profile that you analyzed from that passenger side taillight?
I was not.
Now, with regard to the broken drinking glass, which is item 3-2.1.1, do you see that in your report?
I do.
With regard to that, you came up with a DNA profile that also had 3 contributors, correct?
I imagine he's going to ask us for each one.
One of those contributors appeered to be John O'Keefe, correct?
He was included, correct.
Who were the other 2 contributors?
I don't know. They could be anybody.
Right. Could
Were
be
you
anybody.
ever asked, with regard to that broken drinking glass, to compare the DNA profile that you analyzed with the DNA of either Boston Police Sergeant Brian Albert or ATF agent Brian Higgins?
I was not.
Now, with regard to 7.1.2.1, or maybe it's 7-1.2.1, that's the stain A from the upper right leg of the jeans?
Correct.
All right. And you were aware, you were told that those were the jeans that John O'Keefe was wearing on the morning in question when he was found?
Based on the sample description, that's what it seems.
All right. And it turned out that his DNA was on his own genes, correct?
Yep.
He was included in the profile.
All right,
from
and that was unsurprising to you, correct?
Yep. Why
And
are you
with regard
objecting to that?
item, you found that there were 3 contributors of DNA, correct?
Okay.
Correct.
With John O'Keefe being one of them.
He was included in the profile, yes.
And who were the other 2?
I don't know. They could be anybody.
Let's move on to stain B. Also,
He's gonna do this with
from the
everyone, I'm
upper
sure.
right leg of the genes. That is 7-1.3.1. You see that in your report.
I do.
When you found a DNA profile, how many contributors of DNA were there?
3 contributors.
All right. And again, this was John O'Keefe's genes, correct?
Based on the description, yes.
So he was one of the 3 contributors.
He was included in the profile, yeah.
Who were the other 2?
I don't know. They could be anybody.
Moving on to stain C from the upper right leg of the genes. 7-1.4.1. You see that in your report?
I do.
With regard to the DNA profile that you analyzed there, how many contributors of
Carry
DNA
genes
were there to that
and
profile?
genes this
At
morning.
least 2, and it was interpreted as 2 contributors.
Genes and genes.
And again, this is the same pair of genes that he was found in, correct?
Based on the description, yes.
And you said at least 2 contributors. It actually could have been more than 2.
Based on our protocols, I had to call it 2, and we determined it as 2, but it could be more than 2, yes.
Okay. Well, let's pay attention to
Were the
the
samples
one that
too
was
small?
not John O'Keefe, at least that one. Who contributed that DNA to his pants?
I don't know. It could be anybody.
Right.
Moving on to stain D, which is 7-1.
This is going to be the answer for the entire time. Could be anybody.
0.1.
Could be anybody.
If I can
Could
just
be
put
anybody.
my glasses on to make sure I've read my own writing correctly. Actually, is it 7-15-1?
Yes, Yannetti. Same.
Did I get that wrong the first time?
D?
I'm sorry?
Do you mean
Stain D.
Stain D is
Can we go back to
7-1.5
Yannetti and
points.
glasses?
Oh, I got it right the first time. Okay.
Can we get glasses, Yannetti?
With regard to that stain, you also got a DNA profile, and how many contributors were there to that DNA profile?
I interpret it as 3 contributors.
And again, this is John O'Keefe's genes, correct?
Correct.
He was one of the contributors to his own genes, correct?
He was included in the profile.
And
Correct.
with regard to that
His genes
stain
were on
on
his
the upper
genes.
right leg of his genes, who contributed the DNA to the, who were the other 2 contributors of DNA to that stain?
I don't know. They could
Could
be
be
anybody.
anybody.
And then finally, with regard to that upper right leg of the genes, there was also a stain E, correct?
Correct.
How many contributors did you find to that DNA profile?
2 contributors.
One of which was John O'Keefe to his own genes, correct?
He was included, yes.
And who was the other contributor to that stain on the genes?
It could be anybody. I don't know.
And by the way, just for the record, that was 7.1.6.1?
7-1.6.
7-1.6.1. Thank you, sir. Okay, now, with regard to the unstained area of the exterior of the genes, do you see item 7-1.7.1?
Yes.
You found a DNA profile with regard to that unstained area as well, correct?
Correct.
How many contributors of DNA
That
were
was me,
there
not
to that
you.
unstained area?
You're not
of the
late for
genes?
anything.
I interpreted it as 4 contributors.
And John O'Keefe was one of those, correct?
He was included in the profile.
His own genes.
Based on the description, yes.
Who were the other 3 contributors to that DNA profile?
I don't know. It could be anybody.
And before we move on to the sneaker, I just wanted to ask you a question about the passenger side taillight that I neglected to ask you. That was the one where there were 3 contributors, correct? And again, I'm going back to 3-1.1.
Correct.
Sorry to skip around, sir. I'm not trying to make this
all
any
right.
more confusing than it is. With regard to the passenger side taillight and that DNA profile, are you able to determine when that DNA was deposited on the passenger side taillight that was attached to the vehicle?
No, I'm not.
Are you able to testify
Time,
with
space,
any
wibbly wobbly.
certainty that it was deposited there, say, on January 28th or 29th of 2022?
No, I can't.
It was there before it was swabbed.
Consistent with your analysis of it,
That is it.
are you
Also, I
able
don't know
to
how
say
to turn off those
whether it
notifications.
occurred prior
So sorry.
to
I'll figure it out
January
before the end of this
28th
trial.
of 2022.
No, I can't.
Were you aware that that vehicle was John O'Keefe's girlfriend's vehicle?
I was not.
Were you provided any information about just how often he had been in and around that vehicle prior to January 28th,
I agree with
2022?
Yannetti on this. It's expected, to me, it's suspected that John O'Keefe's DNA would be on the car. It's just common
So
sense.
moving on to 7-3.1,
It's not-
which was the right instep
It's not an
of
unknown
the
car
sneaker,
to him,
correct?
you know?
You see that
Correct.
in your report?
Yep.
With regard to that particular stain, you noted how many contributors of DNA?
Yeah, it was interpreted as at least 5 contributors.
And when you have interpreted as at least 5 contributors, what does that do to your ability to find out who contributed that DNA?
So based on our protocols, we're not able to do any comparisons to any mixtures that are 5 or more contributors. So it's not suitable for comparisons.
Okay, which means that with regard to the sneaker at least, you couldn't even say whether John O'Keefe's DNA was on it, correct?
Correct.
And with regard to all 5, do you have any idea who contributed the DNA to that sneaker?
No, I don't.
Right. Could be anybody.
Now, moving on to, I just have a couple more for you, sir. Moving on to what is labeled as stain L, which is 7-18.14.1, I believe. Do you see that in your report?
I do?
And that was a stain on the back bottom of his long sleeve shirt, correct?
Correct.
And were you told that the long sleeve shirt was his outer clothing when he was found?
I don't
Probably
believe so.
not.
How many contributors to that stain on the back bottom of his long sleeve shirt did you find in that DNA profile?
I interpret it as 2 contributors.
And did you make any match with regard to either of those contributors or both?
I did comparisons, and John O'Keefe was included as one of the contributors.
Okay, so John O'Keefe was a contributor of DNA to his own long sleeve shirt, correct?
Based on the descriptions, correct.
All right, and whose other DNA was on that shirt?
I don't know.
And then finally, with regard to
Right.
7-18,
A whole bunch of- I don't know.
17.1, that was an unstained area of the exterior of that shirt, correct? That same long sleeve shirt.
Correct?
And you tested that and got a DNA profile, correct?
Correct.
How many contributors were there to that DNA profile?
I interpret it as 2 contributors.
Was John O'Keefe one of them?
He was included as one of the contributors.
Okay, so his DNA was found on his own shirt, correct?
Based on the description, correct.
And who contributed the other DNA profile to John O'Keefe's sweatshirt?
I don't know.
Right. I don't know.
With
Could be anyone.
regard to any of the stains on the upper right leg of the jeans, I counted 1, 2, 3, 4, 5 that you've discussed here today. Were you ever asked to compare the DNA profile with the DNA profiles of either Brian Higgins or Brian Albert?
I was not. Oh,
All right.
I'm sorry.
And your answer was you were not?
I was not.
Did anybody ever provide you with DNA profiles of Brian Higgins or Brian Albert?
Sustain to that.
If I may have one moment, Judge.
Yes.
All right. Let's see where they go from there. But the cross-examination is, I think, effective. So you don't know who any of the other contributors are? No. And all the DNA that you identified as John O'Keefe's on his own clothes? Yes. But on his shoe, you couldn't even test it because there were so many different potential profiles? Yes.
I just have one more question for you, Mr.
And you didn't
Porto,
test it
I do
against
wanna
these
thank you
individuals?
for answering all my
No,
questions
sure.
here today. You wrote reports on your analysis of all the items and the work that you did on this case?
I did.
And you are directed, pursuant to protocol, to address those reports to somebody, correct?
Correct.
Who
Is
was
it the
that
lead
you
investigator?
sent the reports to in this case?
I'm sustaining the objection.
Why?
Did you send those reports to Michael Proctor?
Sustained.
Why?
Jurors, strike the question.
Why?
I have nothing further. Thank you, sir.
But why? He's allowed to say who he sent the reports to and who was requesting them. I don't understand the basis for that objection or it being sustained.
Mr. Porto, based on your training and experience in years of doing DNA testing at the lab, when it comes to samples from items of clothing, is it uncommon or
Redirect.
common to have multiple contributors?
That depends. It can happen, but it's possible, yes.
Is it something that's
Right.
a complete anomaly?
I wouldn't say so, no.
Now, turning your attention back to item 3-1.1, that's the sample from the passenger side taillight of the defendant's vehicle, correct?
Correct.
And Mr. O'Keefe was found to, his known DNA profile was found to be an inclusion for the DNA profile from the swab from the defendant's passenger side taillight, correct?
He was included in the profile, yes.
And to what statistical, what is the number associated with that inclusion, sir?
The DNA profile from this item is 510 non-alien times more likely to have it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown unrelated individuals.
Now, Mr. Porter, if I could turn you back to number 10 in your report, there's a number of different items listed there, correct?
Correct.
And as far as the items listed associated with various stains on various areas of Mr. O'Keefe's orange T-shirt and gray long-sleeve shirt, there's about 13 different DNA profiles that you generated in reference to those items, correct?
Emily, this witness didn't
Correct.
test to see if it
And
was
from
blood or
those
not. That'll be
13
a
different items,
witness.
they're all from a single contributor, is that correct?
He just
Correct.
tested
They were
DNA.
interpreted as originated from a single contributor.
And as far as the DNA profile, your comparison of each of those 13 different stains on the orange T-shirt and the gray long-sleeve shirt, what were your conclusions again as your comparison with the known standard of John O'Keefe?
Yeah, so the
how
profile
does
was
this
interpreted
help?
as originated from a single contributor, and the DNA
Okay.
profile from these items is at least 490 octillion times more likely if it originated from John O'Keefe than
Lally,
if it originated from an
John's
unknown,
DNA is
unrelated
on
individual.
John's clothes.
This provides support for an inclusion.
And lastly, with reference to the fingernail clippings from both the right hand and
one's
the left
important.
hand of Mr. O'Keefe,
That one
those
matters.
were also, your analysis provided for inclusion of Mr. O'Keefe's known DNA standard, correct?
He was
Single
included in the
source.
profile, correct.
And again, the profile from both the right hand and the left hand fingernail clippings was a single source contributor, correct?
That one.
Sustained.
How many sources were associated with those?
She's sustained.
Sustained.
Nothing
She's
further.
sustaining those as outside the scope. Sorry, Lally.
Yes, Your Honor, thank you.
You are all set, Mr. Porter.
Those were sustained. She's not letting Lally get outside the scope, and the defense has been objecting to that a lot
the
more
next
this
witness?
trial.
Your Honor, the Commonwealth will call Ashley Vallier.
Next witness is witness number 32 for the Commonwealth. It's going to be another lab witness. But the court is not just sustaining objections for the Commonwealth, which I know is a common perception. There are times I don't understand what she's doing, but she's also not letting the Commonwealth go outside the scope. What was the point of that last witness? DNA was tested. DNA was tested from a bunch of different swabs. Some of the swabs are only John O'Keefe. Some of the swabs contained multiple contributors that were unknown. John O'Keefe's DNA is on his clothes and on the taillight, places we would expect it to be. I think the thing the defense is going to argue the most is that the shoe couldn't be tested because so many contributors were on the shoe. So many different profiles were picked up. And the prosecution's going to argue more about the fingernail clippings and that there was no other DNA under the fingernail clippings. All right. That is the summary of DNA. John O'Keefe's DNA is on his clothes.
Put the jury in the case down here.
There we
The
go.
whole truth and nothing but the truth, so help you God.
This is what, 32?
All right, Mr. Lally, whenever you're ready.
Thank you, Your Honor. Good morning, Ms. Vallier.
Good morning.
Could you please introduce yourself to the jury, spelling your last name for the court?
My name is Ash Vallier, spelled Vallier.
And where do you work?
Ash is
I
a
work at the Massachusetts State Police Crime Laboratory.
crime lab tech.
And where did you go to school?
I got my bachelor degree in biochemistry and cell biology from UC San Diego.
Hey!
And master degree in biomedical forensic sciences
Callie!
from Boston University.
Let's go. Yeah, I believe
Now,
Ash was
following
blonde last
your
trial.
education, where did you go to work from there?
Directly after I got my degree at Boston University, I worked at the Broad Institute.
And then BU.
What did you do at the Broad Institute?
I did quality control checks of items that potentially could be tested for pharmaceutical use.
Now, how long have you worked at the Massachusetts State Police Crime Laboratory?
A little over 6 years.
Now, is the state lab accredited?
It is.
And by whom?
ANAB.
And what does ANAB stand for?
It stands for ANSI National Accreditation Board.
So the abbreviation
ANSI
includes
within the
another
ANAB, what does that
abbreviation?
stand
That is another acronym that I don't recall right now.
Fair. The
Now,
acronym
as part
includes
of
an
that
acronym as part of the
accreditation
acronym.
process, do you undergo any sort of type of proficiency
Lord.
testing?
I do.
And can you explain to the jury what that proficiency testing process
funny.
consists of?
It is. It's
A
acronym
proficiency test
inception.
is a test that is given from an outside agency in the discipline that you do casework in, that you would work through like a normal case, but it has an end expected result at the end.
And how often do you undergo proficiency testing?
Every year.
And what areas do you specifically undergo proficiency testing in?
I've done proficiency tests in gunshot primer residue and physical match analysis.
Physical
And
match
have you successfully
analysis
completed
is
each
why
of-
Ash is testifying, because this witness is the physical match analysis expert. I don't want to just say the puzzler, but put together all of the different pieces with the physical match of matching up the light casing. So we're going to hear about the taillight physical
Those
match.
proficiency tests that you've taken?
I have.
Now, when you
It was really
initially
interesting
joined
testimony
the
first
State
trial.
Police Lab, what was your position and title that you were hired for?
I was hired as a forensic scientist 1.
Now, can you please explain to the jury what your duties and responsibilities were as a forensic scientist 1?
So a forensic scientist 1 is the introductory level. It's when you start your training in whatever discipline you're going to be trained in, and quality
Yes.
control checks.
The puzzler does sound like a
After
Batman
you've been at the
villain.
laboratory for
This witness
over a
is
year,
definitely not a villain.
and you're signed off to do
I really
casework,
liked
you become a forensic scientist
their
2.
testimony last trial.
And you're currently a forensic scientist 2, is that correct?
Yes.
What is the difference between a forensic scientist 1 and a forensic scientist 2 at the Massachusetts State Police Crime Laboratory?
A forensic scientist 2 has been at the lab for over a year and can do casework.
Now, just in general terms, what does the trace unit do or examine within the State Police Crime Laboratory?
I'm a part of the trace, arson, and explosives unit. So we analyze a wide range of pieces of evidence. So there's trace
Also
covers a lot of
bombs.
small things. So paint, fibers, glass,
Explosives.
gunshot primer residue,
we talk
physical
about the
matches.
explosives?
Arson covers fire debris evidence, and explosives covers explosives.
Explosives.
Now, specifically
No.
with reference to physical match.
This witness doesn't get to deal with explosives the way that the crash daddies get to deal with explosives, because generally if the crime scene is having to deal with explosives, it's because very bad things happen. But is it something that would be scientifically interesting? Yes. It is a very interesting job, I think.
Analysis. Can you explain to the jury, just in general terms at first, how is that analysis performed?
So physical match analysis is piecing broken things together to see if they were at once a
Puzzles.
single item. Generally, you look at the questioned item first, the item that you don't know specifically where it came from. Look at that, and then you would look at the known item which is an item with a known source, like specifically like this window or like this vehicle. They're analyzed at separate times. And then if it looks like there could potentially be a physical match, you would analyze them together and see if they have a mechanical fit.
Now, when you retrieve items just in general to do some sort of physical match analysis, where do you get those items from?
Lyndon has retitled the job position to Puzzles and Pyro.
We have evidence storage locations at the laboratory.
Yes.
And how are they typically packaged when you receive
Oh, yes. This witness has a very
They can
cool
be packaged
job.
in cardboard boxes, brown paper bags, heat-sealed plastic bags. It depends on the individual items.
They get to put things together and figure out
when you're doing this
if they
analysis
fit.
as far as the physical match
Professional
analysis,
puzzling.
what do you do to your
so
bench
cool.
between your examination of separately packaged items?
I mean, before I do any analysis, I bleach my bench, clean my tools, and then put down a fresh sheet of butcher paper
And why do you do that?
to make sure everything's clean.
Now, again, speaking more in general
Why would you
terms
do
of
that?
what types of evidence can you perform a physical match analysis?
Sorry, can you repeat the question?
Sure. In general terms, with your work within the lab, on what types of items can you perform a physical match analysis?
A lot. Anything that has a broken or irregular edge.
anything that's not liquid
Would that include glass?
Yes.
or gas.
Would that include plastic?
Yes.
Physical
What are some
objects.
of the other things that would also include?
Physical objects.
Any sort of like polymer, metals.
not liquid and gas.
When you're
Lally.
doing a physical match analysis, what instruments do you utilize in the course of that analysis?
Generally, I'll use a stereo zoom microscope. Depending on the size of the items compared, I can use other microscopes as well.
Now, what is a stereo zoom microscope?
A stereo zoom microscope is a microscope that's mounted on a stand, so it gives a wider range of view that you can look at larger items.
And how are you using that specifically in your physical match
Cool.
analysis of, let's say, items of plastic?
I'll use it to look at the edges
Edge expert.
and see if there's
Yes.
any like defining characteristics along those broken edges.
Now, as you're going
Right.
through your analysis, do you document your work as you go?
I do,
And how do you do that?
with handwritten notes and with photos.
Now, at some point were you assigned to perform some work on lab case number 22-02184 pertaining to this defendant, Karen Read?
Yes.
And what type of work were you assigned to do in this case?
I was asked to do physical match analysis, and then later on I was asked to look at, do some trace recovery, look at
And I love that
some
it's
debris.
a stereo.
Starting with the
magnifier,
physical
like,
match
it's just
analysis,
cool.
how many different items approximately were you asked to look at?
Lots.
over 10.
Several, fair to say?
Yes.
Okay. And how are each of those items packaged when you receive them?
So the questioned items were packaged first in a large paper bag, and then each item was individually packaged in a smaller brown paper bag within that container.
Now, again, just in general terms, because you've used it a couple times. When you say questioned item versus known item, as it pertains to this analysis in this case, what were the questioned items generally, and what was the known item?
The question items were items labeled as coming from a road, and the known item was labeled as coming from a taillight from a vehicle.
Now, in this case, did you perform your physical match analysis in the same manner that you've previously described based on your education, training, and experience within the lab?
Yes.
Okay.
Now, initially, you had examined some various plastic and glass items, and there was a drinking straw in there as well, correct?
Yes.
And
Knight
specifically,
said, did I miss someone
as far
saying
as
pieces
the
are found on
item
the
numbers
road?
that you looked at in this.
I think this is a good time to pause and answer this question because I think it's a good question before we get back to Ash puzzle piecing back everything together and then doing like a whole 3D thing, which is cool. Yes, the crime scene CERT team that went out in the blizzard on the 29th, that found a very few pieces of taillight found them near the shoe on the road. Everything else was found on the yard. But the first pieces recovered were found near the shoe, near the curb in the road. So hopefully that clarifies that. And now we are going to get into, well, the straw, it seems, is what is being asked about.
Analysis. Could you provide the jury with the list of just the item numbers first to start with?
May
Your
I?
Honor.
You have your report with you, Ms. Vallier?
I do.
Okay. Is there any objection, Mr. Nady?
I imagine there's not.
No objection at all.
So feel free to use your.
Thank you, Your Honor.
So the questioned items labeled as coming from the road were item 7-5, item 7-6, 7-8, 7-9, 7-10, 7-11, 7-12, 7-13, 7-14, 7-15.
That's way more than what was in the road.
And 7-19. And the known item labeled coming from the passenger side taillight is item 3-1.
Now, Ms. Vallier, within those specific item numbers of how things are labeled at your lab, if there are different pieces associated with the same item, how is it that you label those, specifically in this physical match analysis here?
So some of the items had multiple pieces within that item. So I labeled them A, B, C, etc., depending on how many pieces there were.
Now, if you could, please explain to the jury just, again, the process that you followed in your examination of each of those items.
So first I looked at the questioned items, the items labeled as coming from the road. I looked at, I documented the overall package because they were all packaged in the same container, the same brown paper bag. Documented that individually. Inside of it, there were a bunch of individual brown paper bags. Documented that, and I went one at a time through them, opening each paper bag, taking written notes, taking photos of the items inside. Within each item,
Documenting everything.
I looked to see if any of those pieces fit together. And I cleaned my bench in between the items.
Of course you did. Diligent. Notes at every
May I
step.
approach?
Cleaning the bench in between. The lab is not. The lab has done
Your Honor, show Mr. Yannetti all this photo.
really good job
Is there an objection to any of them?
in
Mr. Vallier?
just
All right, so why don't
doing
we
what
just
they're
go ahead
asked
and
to.
mark them all
But
as evidence?
I know a lot of you have
Your Honor, if
commented
I
on
could,
whether.
I was going to take them item by item.
Okay, that's fine.
Oh, he said I'm going to take them
Next,
item by
showing
item,
the,
and they're going to go through the
four
photos.
photographs.
Seems nervous.
Recognize those.
Being a witness in a trial is one thing. Being a witness in this trial that is televised and streamed and contentious,
I do.
What do you
whole
recognize
different
those
thing.
to?
These are photos that I took of item 3-1.
Whole different thing.
Again, what was the description associated with item 3-1?
Passenger side taillight.
And was that description further give sort of a specific vehicle or a license plate associated with the vehicle that the taillight came?
It does. Massachusetts 3GC684.
Your Honor, the Commonwealth will seek to introduce in a minute the next exhibit A through D.
Right, those are coming. That's why I wanted to just mark them all because they're all coming. right?
That's fine. If the court prefers, I can provide them.
All right.
Exhibits 170A through 170D.
Beth,
May I approach
Prosecutor
the room,
Lally
Major?
is doing the direct examination of this witness. They've been splitting up the witnesses a little bit, so Lally has done a number of the scientific witnesses. So I'm not surprised. And we're going to go through a lot of
Four
pictures,
photographs, just ask if you
and
recognize
then
I do.
they're going to explain how the physical match analysis
Photos
happens.
I took of item 7-5.
those. And again, from your report, what was the description in reference to item 7-1?
Yeah.
Thank you. You're fine. It's Mr. Lally.
Okay. Piece of plastic, red,
I think
recovered
that was
from
a speak
34
up
Fairview
from the
Road.
court because of the AC unit.
Your Honor, the Commonwealth will seek to introduce in a minute the next exhibit A and B.
Okay.
171 A and B.
My apologies, Your Honor. With the court's permission, may I publish some of those
Yes.
photos to the jury? Ms. Gilman, if I could first ask for photograph 2122. And Ms. Vallier, what's up on the screen, that is the bag associated with the passenger side taillight or the known
My
item,
best
correct?
friend's right.
Correct.
And Ms.
Everyone,
Gilman, if I could have
every single time.
photograph 2125. And Ms. Gilman, if you could
Those
just
are
enlarge a
itty
little
bitty
bit towards the
pieces.
bottom where the ruler is. Now, Ms. Vallier, what's up on the screen now as far as the sort of notations there? Who made those?
I did.
And how do you know that you were the one who made those?
That's my handwriting, and those are my initials.
So the AMV is for your name, correct?
Yes.
And with respect to each of the items that you photographed, you had photographs that were taken of sort of what was in the evidence bag in total, displayed on your table
A
that you had
ruler.
cleaned with the
Look at
solution and
that.
everything else, correct?
Yes.
And Ms. Gilman, if you could just zoom out a little bit to show the item. And again, what's up on the screen, that is item 3-1, the known item as far as the tail light from the defendant's vehicle.
Yes.
And Ms. Gilman, if I could have 2126. And Ms. Vallier, if you could just describe for the jury, what are we looking at in this photograph?
Those are those same items, just turned over.
And lastly, for this set,
Well, that's
Ms.
incredibly
Gilman, if I could have
thorough and
2135.
appreciated.
And again, same item as far as 3-1, the tail light taken from the defendant's vehicle.
Yes.
Ms. Gilman, if I could ask for photograph 1905.
Danita, these are the date. The date is the date that the witness was taking the
Ms.
photos
Vallier,
and
as
doing the
far as
analysis.
with each of these items,
I don't know if Lally will ask when they were asked to do this, but the date on the photos is when the analysis was being done, when the photos were being taken. If we get to when it was requested, I think this was a delayed request, not a delay by this witness in getting to the request. I'm sure we'll get there, but a lot of the testing was done substantially later. So yes, the testing, it looks like, started in March of 2023. So does that surprise anyone? Oh dear. Wait. The feed just like yeeted itself. That was me. And then this actually, look, y'all just take a moment to appreciate that there's an evidence sticker on the evidence bag and there's initials. These are from 2/4/2022. So these are actually bagged and tagged on the 4th, and then they're going to be cut open. And they, when the lab opened everything, photographed everything, opened it and photographed it again, front and back side. Look at that. The scientific witnesses did what they were supposed to do.
items you take photographs when they're inside the bag and then once you take them out of the bag, correct?
Yes. Every step of the way, photographs.
And Ms. Gilman, if I could have photograph 1908.
Every step of the way. That's what was in the
And
bag.
What are we looking at in this photograph?
The contents of item 7-5.
May I approach again, Your Honor?
Yes.
We'll do two more photographs.
Photo in the
You
bag,
recognize those?
photo out of the bag.
I do.
And what do you recognize those?
Photos of item 7-6.
The barcode should
That's
be
one
printed
off
out
the
from
bag
the
and then
evidence
one when the
locker,
item is taken
so it
out
can
of the
just
bag,
be
is that
scanned
correct?
where
Yes.
it goes.
And what was the description for item 7-6?
Piece of plastic, clear, recovered from 34 Fairview Road.
And appreciate those. Colonel Commonwealth, seek to introduce the minutes. The next
We're going to go
entity.
through a lot of photos, and these are the photos of what the item looked like when the witness received it, and then what was
With the court's
inside the
permission, may I
bag
publish those to the jury?
before they do the manual mechanical
Ms.
puzzling.
Gilman, if I could have photograph 1921,
Puzzling's not the technical word, but
and then
the
photograph
vernacular I will use.
1924.
Chat, do you allow the parlance of puzzling? Hopefully my
And what's
parlance is
depicted up
proper.
on the screen, is that what you just have before you as the photograph that you took of item 7-6 recovered from 34 Fairview Road?
Yes.
Thank you. May I approach the
Thank you,
witness again, Your
Chat.
Honor?
You've allowed
Yes.
my parlance. I appreciate it.
Two other photographs, you review those? Do you recognize those?
I do.
What do you recognize as?
Photos I took of item 7-8.
One of the bag and then one of the items removed from the bag, is that correct?
Yes.
And what is the description associated with item 7-8?
Piece of plastic, red and clear, recovered from 34 Fairview Road.
Commonwealth seek to introduce and admit as the next exhibit. A and B.
Claire, do not worry. Enjoy your new rescue
Your
partner.
Honor, with the court's
And
permission, if I could publish those.
the first 5 minutes of
Yes.
court, and then just come back to this, because we just did DNA and it's best summarized. So, like the first 5 minutes, and then back to this, because the first 5 minutes.
Ms.
a lot
Gilman, if I could
happened.
have photograph 1931
Since then, not so much.
and then 1934.
Bag, outside of bag.
And Ms. Gilman, if you could zoom in just a little on those items, please.
Oh, there's that weird, big, round, flat plastic piece.
And Ms. Vallier, again, what are we
That doesn't
looking
make
at in
any
this
sense.
photograph of item 7 dash? Oh, what are we looking at again in this photograph? Excuse me.
Photos of item 7-8.
May I approach the witness again, Your Honor?
Yes.
That big round plastic piece with like the dot in the middle. And I was like, is that a lid to something? Like, what is it? So
You
weird.
recognize those?
We just don't know.
I do.
What do you recognize those?
Photos of item 7-9 and 7-19.
And as far as the first photograph, as far as the bag, and then second with the items taken out of the bag, is that correct?
Yes.
So
I imagine
7-9 and 7-19
during this
were contained in
testimony,
the same bag.
They were.
court-
I then separated them into 2 separate packages.
The court's notes are
And
keeping
as far
track
as 7-9 and 7-19,
of the item numbers and the evidence numbers.
If you could, tell the jury what was the description for each of those items.
Item 7-9 was pieces of glass recovered from 34 Fairview Road. Item 7-19 is trace item, black straw, recovered from 34 Fairview Road.
Your Honor, Commonwealth seek to introduce and admit as the next exhibit, A and B. May I publish, Your Honor?
It's just,
Hold on.
Oh, forgive me.
74A and 174B.
Now you can publish.
My apologies.
like, so the court's keeping
Ms.
note
Gilman, if I could
of the
have
numbers.
1958, please. And then 1962.
Glass. Broken.
And again, Ms. Vallier, what are we looking at in this photograph?
And strong.
The contents of that bag, item 7-9 and item 7-19.
May I approach again, Your Honor?
Yes.
Yes, they do say 2023. That's not incorrect. That is when
Photographs, do you recognize those?
the work is being done at the lab. I don't know if we'll get to the questions about who
I do.
submitted the request to the
recognize?
lab and when.
Photos of item 7-10.
And again, one
Yeah,
of the bag and one
that's
of the
when that was
contents of the
happening.
bag, is that correct?
Yes.
And if you could, please tell the jury what was the description for item 7-10.
Piece of plastic, red, recovered from 34 Fairview Road.
Mickey P, this is a great question.
Introduce and admit as the next exhibit, A
As
and
I'm
B.
wiggling around in my chair, Mickey P said, did they not open the bags until 2023 because they
175A
didn't
and
get
B?
them until then? Actually, no.
May I publish?
This I can answer. The crime lab got most of the evidence. I cannot remember if it is all, but most of the evidence in March of 2022. But for the crime lab to do anything with the evidence, there needs to be a request. And then it goes through the different stages at the crime lab. So things will be swabbed. Those swabs will go to DNA. There will be different groups within the crime lab. I don't know when the request was made for the physical match analysis. It is incredibly likely that there was not even a request for it to go to their unit for the physical match analysis until 2023, that law enforcement didn't even ask that that be done because the lab isn't looking for work. The lab doesn't say, we should do this too. Law enforcement has to request it, and then it has to get into the queue behind the other work once it's requested. I don't know when the work was requested because physical match analysis in this case might not have been something anybody even thought of until after the swabbing, the photographing, and the DNA was done. So it's not like you have the witnesses going, hey, it would be interesting if we tried to match these. They have to wait until law enforcement requests it and then until they have time and opportunity to do it. So I just want to know when it was requested. That's what I'm curious about. I don't know if we'll get that answer. Maybe we will, maybe we won't. But if nobody makes a deal out of it to the jury's also going to be like, 2023. Okay, I guess that's when that was done. Hopefully that makes sense, chat. But yeah, the lab doesn't get to decide what they test, how they test it, and which unit of the lab it goes to, because they're all just in separate little units. So things have to go through the swabbing all happens first before it gets to any of the other units that they're doing physical manipulation with the items. Hopefully that makes sense.
Is that for the jury, Your Honor?
Yes.
Ms. Gilman, if I could have 1952. And 1956. And again, Ms. Vallier, what are we looking at in this photograph?
Piece of
Photo of item 7-10.
presumed taillight.
Thank you. Gilman, you can take that down. May I approach the witness, Your Honor?
Yes.
Two other photographs, do you recognize those?
I do.
And what do you recognize those?
Photos of item 7-11.
We're
Again,
going to
one
go
photo of the bag, one
through
photo of the items outside of the bag.
every
Yes.
single
Again, if you could, please tell
bag
the jury what
of evidence that they
description is
opened.
associated with item 7-11.
just every single one.
Piece of plastic, 6, red, clear, and black, recovered from 34 Fairview Road.
Commonwealth is seeking to produce and admit as an
Lindsay
exhibit
said,
A.
asked if this witness was at the crime scene. No. That everything collected off the crime scene. We heard all that testimony early on from Cert and Buchanan
May I
and
publish, Your
Proctor
Honor?
Yes.
and Connor
Ms. Gilman,
Keefe.
1979
This is crime lab witness.
and 1982.
They get the bags, they open the bags, they do what they're asked to do with it.
Again, Ms. Vallier, I'm sorry, Ms. Gilman, if you could zoom in just a little on the items themselves.
Items.
And Ms. Vallier, what are we looking at in this photograph?
Photo of item 7-11.
These are photos, again, that you took in the lab during the course of your comparative or physical match analysis, correct?
Yes.
The lab just does what they're
May I
asked.
approach again, Your Honor?
Yes.
Well, the lab's just supposed to do what they're asked. They're not supposed to go do things because they are curious.
Two other photos, if you could look at those.
It's going to be a long day of this. It's going to be a full day of
Do you recognize those?
laying the
I do.
foundation for the items and then what
Photos
they
I
did
took
with
of item
them
7-12.
And
on
again,
and on
photograph
and
of the
on.
bag, photograph of the items outside of the bag.
Yes.
If you could, please tell the jury what's the description of item 7-12.
Trace item, 14 glass and clear plastic, recovered from 34 Fairview Road.
Now, the Commonwealth is seeking to introduce and admit as the next
Okay.
exhibit, A.
Exhibit 177A and 177B.
Your Honor, may I publish?
Yes.
Ms. Gilman, if I could have photograph 2015 and 2018.
Pieces.
Again, Ms. Gilman, if you could just zoom in a little on the items. Thank you. And Ms. Vallier, again, can you describe what's depicted up on the screen?
A photo I took of item 7-12.
Your Honor, may I approach?
Yes.
Chronic Sharks Art Journal said, how did you know it was a taillight, Doctor Who? I licked it. I actually sent
Other photographs.
my
Do you
teen
recognize
the periodic table meme of science, can you lick it?
I do.
those? What do
It
you
was very
recognize those?
funny.
Photos I took of item 7-13.
He disagreed with some of the,
bag and then one
can you
with
lick it or you
evidence
shouldn't
from
lick
the
it?
bag.
Yes.
And
On the
if you
periodic
could, please
table.
Tell the jury what is the description for item 7-13.
Piece of plastic, red and black, recovered from 34 Fairview Road.
I'm about to seek to introduce in a minute next exhibit A and B.
Exhibit 178A and 178B.
Your Honor, may I publish?
Yes.
Well, Lally's going to get his steps in today. Lally's steps are going to be like, look at this photograph. Go
And
get the other
2000.
photographs. Look at these photographs. Back to get
And
the
again,
other
Ms. Gilman,
photographs.
if you could, please zoom in on the items.
Look at these
Thank you.
photographs. Oh, Emily, you're
And Ms.
right.
Vallier, directing your attention to the screen, can you describe to the jury what is depicted on the screen now?
Are both teams.
A photo I took of item 7-13.
We're getting into some of
May I
the
approach the witness,
pieces
Your Honor?
Yes.
of presumed taillight that were found way later. What's notable to me is how large some of those are. And they're like, no, we found them like 2 weeks later.
I do.
What do you
Craft
recognize
Witch,
that?
Rachel, you're right.
Photos I
Lally's
took of item 7-14.
healthcare data.
And again, one of the bag and one of the item removed from the bag.
Yes.
And again, could you please tell the jury what the description is associated with item 7-14?
Pieces of glass recovered from 34 Fairview Road.
I want to seek to introduce the next
Dale
exhibit
in the
A and B.
chat asked who sorted all these into different bags. They were bagged each time they were recovered. So a lot of these are recovered on different days. If you look at the photos of the bags, the evidence bags
publish,
show
Your
the
Honor?
day that they were recovered.
Ms. Gilman, if I could
So
have
these are being
2009.
bagged the day they're recovered. So
And
this one was
2012.
recovered February 11th. It went fast,
Again,
but
Ms. Gilman,
February
if you could
11th.
zoom in on the item. And Ms. Vallier, as far as what's depicted on the screen, again, if you could describe for the jury what that is.
A photo of item 7-14.
May I approach the witness again, Your Honor?
Yes.
So this testimony is all foundation that is needed to get to the ultimate testimony for this witness, which is that manual compare or the manual, well, the puzzling. Keep forgetting
do.
the proper
And what
term
do you
for the
recognize?
scientific puzzling.
Photos of item 7-15.
Mechanical
Again, one of
match
the bag and
analysis.
one of the items taken from the bag, correct?
Yes.
So all of this foundation is
And, If
necessary.
you could, please tell the jury what is the description associated with item 7-50.
Piece of plastic, 3 clear and 5 red, recovered from 34 Fairview Road.
And then the evidence bags show the date. I'm going to just start reading them out just because it goes so fast. And for those of you that are listening, we'll read the date that the item is recovered as they're being admitted.
May I publish, Your Honor?
Yes.
Ms. Gilman, if I could have 2072.
So this was recovered February 11th at 34 Fairview by Trooper Proctor.
Yes.
5 pieces of red
And
plastic.
2077, please.
That is
Again, if you could zoom just a little as far as the item.
that February 11th piece of taillight is not small. This was being assessed by the witness on February 17th.
Is our concern. And Ms. Vallier, what are we looking at in this photograph?
Item 7-15.
May I approach again, Your Honor?
Yes.
Other photographs, do you recognize that?
Yeah, it's a
I do.
very large
you
piece of
recognize
taillight.
Photos I took of item 7-16.
And again, one of the bag and then one of the contents from the bag, is that correct?
Yes.
And if you could, please tell the jury what was the description associated with item 7-60.
Piece of
The
plastic,
Commonwealth
red
will
and
say it
clear,
was
recovered
under
from
the
34
snow.
Fairview Road.
And that's why it wasn't seen before. So they're under the snow.
Exhibit 181A and B.
May I publish, Your Honor?
Yes.
Ms. Gilman, if I could have 2036 and 2040.
This is from February 18th. That went
Ms. Gilman,
fast.
if you could zoom in just a little.
So these are the pieces
very
from
much.
February 18th.
And Ms. Vallier, if you could, please describe for the jury what we're looking at in this particular photograph.
This is item 7-16.
Ms. Gilman, you can take that down.
Rude Dog in the chat asked, and that I'm not name calling. That is just the handle for all of you listening in the background. When completed, can this witness tell us the impact point that the cracks rated from? No,
Now,
I don't believe
with
so.
respect to each of these
The match
items
analysis,
that
yes,
you
but I don't
examined
think
in
the
your
impact
physical
point.
match analysis, again, as far as the process is concerned,
It's a good
with
question,
the
though.
question items, what are you doing with reference to each of those question items first?
First, I document them as you've seen. I'll see
We
if
did
any
see
of those
all the glorious documentation
within the item have a physical match with each other. And then I'll package that away and look at all the questioned items before I compare inter-questioned items to see if there are any physical matches in between all of the 7- items.
And as far as your notes are concerned, what is it that you're noting in reference to each of those items as far as what characteristics of the item are you taking note of?
I'll note the size, the color, and the material.
And what, if any, measurements do you take of each of those respective items as well?
I'll take the length and width of each item.
Now, with respect, starting with item 3-1, the passenger side taillight from the defendant's vehicle, sort of internally within that item 3-1, what did you conclude as far as your physical match analysis within that item alone?
Within item 3-1, I believe 4 of the pieces fit together.
I wish Lally would put the photo of 3-1 on the
Your Honor,
screen when asking these
the witness
questions.
may refer to her notes
Yes.
as to. Thank you.
May we refer to the photo? May we refer to the photo? Just put the photo up. 3-1. You already had it up. Just put it back. Just put it back.
Yes, 4 of the pieces fit together within item 3-1.
And which 4 of the pieces?
Pieces A, B, D, and F.
And as far as the labeling of those pieces of an individual item, let's just start with item 3-1. A, B, D, and F. How are they labeled, and how do you sort of physically label those items?
We have a label maker in the lab, so I'll print out the
Stickers.
the case number, the item number, and then A, B, C, and my initials, and that goes physically on each of those items, or all of those pieces.
Stickers.
So if any of those items had a
Which is why the items go to trace first so they can be all swabbed. Emily, you're way too excited about a label maker. Look, man, we are deep in foundational scientific evidence. The fact that things are getting documented is just happy for me. But everything goes to trace first, so all the swabbing, and that can be done before it moves on to the other units in the crime lab so that none of the evidence or potential evidentiary value would be changed by it being handled, having stickers put on with it and stuff like that down the road. So yes, I'm very excited because this witness takes evidence out of the different evidence bags and then starts doing the physical match together and then matches them all together across different evidence bags. So you have to be clear which pieces came from which evidence collection because they all have to go back where they started from. So it's a lot of organization, and this witness is incredibly methodical, which is really what you need from scientific witnesses. You want someone who is very methodical to go through, photograph which bag, photograph which pieces, label everything before they start not mixing it together, but before they start matching it together. What I will note is that the evidence collections, and they went past it pretty fast. I think it'll come up in cross. Some of you have already mentioned it in the chat. The evidence was collected on different days. And so we saw that on the evidence bags as we went through February 3rd, February 11th, February 8th. And now they're matching together the evidence that's collected together. So how much of the evidence collected together matches together from the same area of the taillight is interesting to me, and I think will come up on cross, because the things that are collected on February 11th, those things just fit together, and the things on February 18th, those things just fit together. Like if you took puzzle pieces and put them in a bag and shook it out and scattered them about, would you have a bunch of pieces grouped together that fit together? Or if you took a bunch of puzzle pieces and put them in a bag and shook them up, would you need all the pieces together before you can start matching them? That's my question. It's gonna come up on cross, I'm sure. So let's continue.
Sticker on it with a letter or something associated with that, that would be something that you did during the course of your physical match analysis, correct?
Yes.
Now, if I could turn your attention to item 7-5, piece of plastic red recovered from 34 Fairview Road. What did you conclude as far as your physical match analysis just within that single item?
There was no physical match noted among those 3 pieces of apparent plastic.
Right.
And when you say no physical match found from the different pieces within that item, what does that mean?
I wish Lally was showing them on the screen.
The broken edges of each piece did not align.
So the broken edges of the individual pieces within item 7-5 did not fit together with the broken edges of pieces within item 7-5, correct?
Yes.
Okay. Now, with respect
again,
to item
some of them don't.
7-6, a clear piece of plastic recovered from 34 Fairview Road. What did you conclude based on your physical match analysis just pertaining to that item 7-6?
So this item was 2 pieces of colorless apparent plastic, and there was no physical match noted between those two pieces.
Some of them didn't match,
Now,
and I think that's important
with
too.
reference to item 7-8, red and clear plastic recovered from 34 Fairview Road. What did you conclude in regard to your physical match analysis just with the pieces contained within item 7-8?
So there were 14 pieces. Pieces C and D fit together, and pieces E and F fit together.
And when you say fit together, is there a term of art used within your field called
Puzzle.
mechanical fit?
Yes.
And can you explain to the jury what you understand that term
Mechanical
to mean
fit.
as far as what is a mechanical fit?
So a mechanical fit and a physical match are the same thing.
Synonymous.
The broken edges align together to show that they were once a single item.
Puzzle.
Now, if I could turn your attention to item 7-9, pieces of glass recovered from 34 Fairview Road. What were you able to conclude from your physical match analysis of just the individual
And I think
pieces
this all
contained
needs to
within
come
item
in
7-9?
Before they get to
So this item had
accident
3
reconstruction.
pieces, and no physical match was found between those.
Turning your attention to item 7-10, red pieces of plastic recovered from...
And yes, Lally's going to ask the same exact question in the same exact way about each evidence bag, wash, rinse, repeat. It's also fair to note that in a number of these, the pieces that are recovered on the same date do not match together. So again, if we're noting it where it matches, we also have to note it where it does not match, because there are different collections of evidence where nothing within that collection matches.
34 Fairview Road. What were you able... That is a single item, is that correct?
Correct.
So no physical match because there's nothing to match. It's just one piece, correct?
Correct.
And turning your attention to item 7-11, identified as 6 red, clear, and black pieces of plastic recovered from 34 Fairview Road. What did you conclude in regard to your physical match analysis just within those pieces contained within 7-11?
So that item had 6 pieces, and there was no physical match noted among those 6.
Now, turning your attention to item 7-12, which was identified as 14 pieces of glass and clear plastic recovered from 34 Fairview Road. Again, what did you conclude from your physical match analysis just from the various pieces contained within item 7-12? So
there were 14 pieces overall. pieces B, C, D, F, and K fit together mechanically as one unit. And then pieces E and I fit together mechanically as one unit. And pieces M and N fit together mechanically as one unit.
Now, through your examination of these pieces in particular and other pieces as well, did you note any debris contained on the pieces that you located?
Yes.
And
Really?
Can you say anything as far as what that debris was, or was there any analysis done of that debris specifically?
I just note that there was debris present, and I package it into a tin that's retained with the original packaging.
That's good to know.
Turning your attention to item 7-13, that was a piece of plastic, red and black, recovered from 34 Fairview Road. Is that correct?
Yes.
And again, just with respect to your physical match analysis of the various pieces of 7-13, what did you conclude?
So that item had 3 pieces, and there was no physical match noted among those 3.
So each
And again, with reference
number
to
Lally's going
item
through 7-13, those are
7-14,
different
piece of glass
evidence bag
recovered from
numbers.
34 Fairview Road, that was again a single item, correct?
Yeah, no
single
match on a
piece, yes.
single piece.
So I'll turn your attention to item 7-15, 3 clear and 5 red pieces of plastic recovered from 34 Fairview Road. Is that correct?
Yes.
And what were you able to conclude from your physical match analysis, again, just from the
Also,
various
yes, it's
pieces
supplement
contained
time.
within item 7-15?
Put them at my desk
So
during
there
this
were
trial.
8 pieces in this one. Pieces F and H fit together mechanically.
Turning your attention to, lastly, for this purpose, item 7-16, a piece of plastic, red and clear, recovered from 34 Fairview Road. What were you able to conclude from your physical match analysis just contained within the pieces of that single item, 7-16?
So that item had 7 pieces. Pieces A, C, and D fit together mechanically.
Now, Ms. Vallier, once you had examined each of those pieces individually, what did you do next in your analysis?
Next, I compared all of the inter-questioned, these items 7-5 to 7-16. I compared them to see if there was a mechanical fit amongst those, between those items.
Mr. Lally, is this a good place for our break?
That's perfect, yes, ma'am.
All right, jurors, we'll take our morning break.
And break.
Walk out right with the jurors.
The court's like, and it's time. And it's time.
Can I see counsel for a minute, please?
For everyone watching this trial for the first time, welcome. I know we have about 20% plus minus of you that are watching this for the first time. Yes, the foundation is necessary. Yes, it is always this tedious. Yes, you need to go through it. Yes, it is incredibly relevant. But yes, the jury just doesn't normally track this until it gets put together in closing or until the interesting bits are picked up during cross. But they are going through every single evidence item number that was reviewed, the 7- insert number here numbers, and then doing the photo of the evidence bag, photo of what's in the evidence bag. Then, did anything within that same evidence bag physically fit together or mechanically match together? Then, did things across the evidence bags match together? And then we will get to that. I'm going to zoom. Lady Blue NC said, did the judge rule on yesterday's motions? No. Nope. But we've got zoom room, so we're going to zoom. Oh, guess what? They're going back on the record before the jury's back.
All right, Mr. Lessie, I'll hear you.
Well, it looks like they're going back on the record. So I imagine, because I was going for my zoom room, and what did I see? But Alessi, and then Brennan, and then Alessi, and then Brennan. So I imagine this is about tomorrow or yesterday or wibbly wobbly. Imagine this is about yesterday. So the jury's on morning break.
All right, Mr. Lessie, I'll hear you.
You are unmuted.
Motions argument, it seems. And I say it seems because I don't know. Chat, if any of you were ahead in time and wibbly wobbly back to us, thank you.
Thank you, Your Honor.
Spoilers make me cry.
Your Honor discussed with the parties, and parties were heard with regard to the issues we have raised with regard to the timing of the May 8th report from Mr. Burgess that the defense received on May 11th. And what I wanted to do, Your Honor, is briefly provide the information Your Honor asked for yesterday, which was how much time we might need under various circumstances.
Okay.
And so I wanted to take a few moments to put that in context. It will only take me a brief amount of time to do so. So, Your Honor, there is a timing issue, but there's most importantly a substantive issue. I will not, of course, go into the detail of yesterday, but the timing really is informed by the substantive issue. And so, with regard to the matter, we went back and we looked at more deeply the effect of this timing and this movement of the what has been referred to as clock drift in Mr. Burgess's report that we got on May 11th. I spoke of the significance yesterday, and here's what I would like to add as is relevant to the time we're going to need. I again urge the court to reject it substantively, because what we did was we went and we looked at matters such as the cross-examination of a key witness in this case, Jennifer McCabe. She testified with regard to observing a vehicle at 12:45 a.m. And that's a significant point. I know I don't need to elucidate for Your Honor. It goes, all of this is going in significant part, if not total part, to what has been as alleged a collision here, which we vigorously contest. It just never, no collision ever occurred. But the timing of it, the timing of what's alleged by the Commonwealth is very important. The seconds are important. Literally 1 second can turn not only the Commonwealth's theory completely around in circles and debunk it, but also the jury's analysis of it. And this is the point I wanted to elucidate today, is that the jurors have been provided information, and the defense has aimed its defense on this claim based upon, in large part, timing. So now what we have is we have on May 11th, Mr. Burgess changing the timing. So what does it affect? Not only witnesses like Jennifer McCabe, who we strategized with regard to, but also my decision to not even cross Trooper Garino, because Trooper Garino had testimony with regard to when Ms. Reed connected with the Wi-Fi at One Meadows, and there's a certain time associated with that. We have Mr. Whiffen, who went through, the Commonwealth went through a timeline, and we believe they went through a timeline for the theory that they had, and I cross-examined Mr. Whiffen extensively with regard to that timeline. There were several defense strategies and effectuations of strategies based upon that timing. So with regard to the substance, Your Honor, and there's more, but I think that's a fair representation. It innervates our entire defense. The question now of Your Honor of how much time it will take the defense to react to Mr. Burgess, I wanted to say it's not only a reaction, but it's a substantive defense analysis, and 3/4 of the effectuation of that has already occurred through our presentation in terms of cross-examination. So we would have to, and we're still evaluating that, revisit all of that. And secondly, we would have to put that into the calculation of all of our witnesses that we've already prepared that are based upon that timeline. So it is a very significant point, and to the extent that the Commonwealth tries to argue, well, you know, we never really committed that much to a certain time period. I again urge the court to look at the report of Dr. Judson Welcher, where he has 1162-2 with a specific range 1238 to 43. And even in their range, it's a very small time, which further supports how each second matters in this regard. Now to the answer to the question Your Honor asked yesterday. Again, I urge that it just be rejected and we keep this trial moving in its current pace. To the extent that that does not occur, and again, we urge that it be rejected, the report, because it's a Rule 14 violation, there is no remedy for the defense. However, to the extent, and given Your Honor nonetheless asked me for an answer in time, we would need 4 days to be able to address it.
She might give them a long weekend.
Will not ever be able to recover strategically or substantively from it, given all that's been presented to the jury, and it will be very difficult to figure out how we're going to go present a defense after we've already presented to the jury our defense and our cross-examination. It's not really structurally possible to simply take 4 days and address Mr. Burgess, because we can't go back to all the witnesses I just mentioned and others and start crossing them in eliciting testimony with this new time period in mind. But I wanted to answer the question, Your Honor, respectfully. It would be 4 days for us to even go from where we are now and then try to alter not only witnesses such as Arca, but DeSogra and Gaffney and other types of witnesses that we have in that regard. So, Your Honor, respectfully, that is my response.
All right. Does the Commonwealth want to be heard?
Yeah.
Okay.
The reason Alessia's made this such a large point is exactly what he said. Their strategy is based on the information they had. That's why there's discovery deadlines, and you can't unring the bell. The bell has been rung. For the past discovery issues with the Commonwealth, the court has said, well, the remedy for that is a new trial, and you're getting a new trial. So could the defense ask for a mistrial here? Yes, they could. Do they want to? No, they don't. The defense doesn't want to have to start all over, and a mistrial means it just starts all over. It just wipes the slate clean and starts all over. The defense doesn't want to do that, and they shouldn't be forced into that position. Is the court going to dismiss the case over this? Probably not. Could the court choose to not allow it in? Yes. But here's why it matters. And this is the refresh of yesterday's argument, where the Commonwealth has provided a new updated report from their expert about the timing of a triggering event from Karen Read's vehicle. From my best memory from last trial, the vehicle itself has a vehicle time, and they are using the vehicle time and then John O'Keefe's phone, and then the time drift or the time warp or the wibbly wobbly is being shifted. So the previous report had indicated, and yes, I have on this post-it notes because I feel like I'm going to keep referring back to them, but the previous report had the triggering time set at 12:31:38 seconds and 12:31:43 in that window. When Whiffen testified that between 12:31:52 and 12:32:09, some pretty significant things happened on John O'Keefe's phone. Let's talk about what Whiffen said happened on John O'Keefe's phone. And this is why there was so much fighting. After the time period of the triggering event, which is when the Commonwealth, I think, will argue that the collision occurred and that John O'Keefe was incapacitated thereafter. It's why the defense asked so many questions about would John O'Keefe with his injuries be able to have any volitional movement. And we'll get into that with the other experts. But the testimony I anticipate based on the experts last time is that the experts will testify that John O'Keefe's head injury would render him unable to make volitional movement. So if the time of the triggering event collision is at the far end, 12:31:43, then anything that happens after that, there's a big question about, because the medical testimony I suspect will be that John O'Keefe would not be manipulating his phone after sustaining that injury to the head. So here's what Whiffen said. At 12:31:52, the phone was in a pocket state that was cleared, meaning the phone came out of a pocket or out from being covered, and it was looking to be cleared. Then at 12:32:03, at 12:32:03, the pocket state was cleared. At 12:31:52, the phone was in the pocket. At 12:32:04, Face ID unlocked the phone. At 12:32:06, the message was read from Jen McCabe, pull behind me. And at 12:32:09, the cell phone was locked using a button push. Those all happened after 12:31:43. What the Commonwealth's new report is suggesting is that it is not, in fact, 12:31:43. It is 12:32:16. 12:32:16 is after the 12:32:09 device locked. So it is moving the goalpost of when that triggering event happened. And the Commonwealth is saying that that is attributed to clock drift. The defense argued yesterday that the clock drift issue has been known for a substantial period of time, I think since the last trial, and that the clock drift issue is something the Commonwealth and their expert could have explored more fulsomely earlier. The new expert, per what was argued by Brennan yesterday, the new expert, Brennan said, was responding to the defense expert. And the defense said, my summary, bullshit. They knew that the timing was critical. They knew that the clock drift was critical. And they had Ian Whiffen's timeline. They knew all of this. So you can't, midway through trial, say this critical triggering event needs to be shifted to line up with their tech expert, whose report they already had. This is why there are deadlines. So that's why the timing matters so much, because after 12:31:43, which is the original time, all that stuff I just said happened on John O'Keefe's phone. Do we know that John O'Keefe did it? No, it's very hard to prove whose phone is in whose hand. Is it reasonable to believe that John O'Keefe was the one doing that on his phone when his face unlocked the phone? Yes, it's reasonable to believe that. A jury can find that. A jury has enough evidence to find that timeline from Ian Whiffen that shows that a phone is in a pocket, a phone comes out of a pocket. We saw numerous videos of John O'Keefe putting his phone in his pocket, taking his phone out of his pocket. Then it's Face ID unlocked. Then a text message is read. Then it is click button locked. All after they had originally said the triggering event that is a collision happened. That's why it's such a big deal to the defense. And the reason this is different than ARCA, because the defense turned over the ARCA shit way late and the court allowed it in. The court was not happy about it. The court's allowing it in and said the remedy for the prosecution is to do a voir dire prior to trial starting. The reason the two things are different is because what was happening with ARCA, and the Commonwealth was going to make them synonymous. What was happening with ARCA, they were aware of and happened before the trial started, with the caveat that they did not get ARCA's responsive report until trial had begun. The Commonwealth has said we need more time for our expert to evaluate the ARCA report. Fine. But the witnesses that the Commonwealth is going to examine or cross-examine regarding that report haven't testified yet. The defense is saying we would have a different strategy had this information come in. So they're very different circumstances, even though they're both dealing with reports that were turned over after the close of discovery. The defense has relied, and they're saying detrimentally relied, on those reports from the Commonwealth in their entire defense strategy. And you can't undo that and you can't fix that. And that's why the situation is different, because the defense has already evaluated so many of the witnesses critical to time, like Trooper Garino, like Jen McCabe, like Ian Whiffen. And Alessi laid out some of the strategy on that. We strategized based on the information we had. They can't just change it now. But it seems that that's what they're trying to do.
Respectfully, Your Honor, the defense is very confused. They attempt to confuse the issue.
Well, can you explain it? Because maybe we're all confused. I'm not mad at the purple tie, but I'm real mad at this whole situation. I'm going to need you to explain.
Respectfully, Your Honor, the defense is very confused.
Okay.
They attempt to confuse the issue. They attempt to confuse Your Honor about what the impact would be. This has never been a change. The government is not changing the
Explain to me how it's not.
timeline. The Commonwealth is not changing any information. The Commonwealth is not offering anything that affects in any way the testimony of witnesses. It's notable in the argument there is no relationship to the facts or the actual report that was provided. The
Read the report.
has always provided the data, which they have, and they hadn't a chance to analyze. And the interpretation of the data has been different between the parties. We have been clear from the beginning at the time in which the infotainment system shows that there was a collision. We've been clear. And the data has been clear. That has never changed. That data in the telestream system is based on a clock in the Lexus, which both sides know full well is different than a clock in an iPhone. You can see all the productions of Dr. Welcher's PowerPoint presentation where it shows that time, 12:31:43, has never changed. Also, it has been clear that both sides appreciate that there is a variance between the clock in the Lexus, which leads to that system information, and a clock in an iPhone. In fact, the defense was so aware of it, they hired an expert, Mr. DeSorga, who gave his opinions.
I have no idea if that person's name is Mr. Disorder or not, but I'm going with disorder because disorder. I'm just going with it. That's the defense expert that they hired.
About that variance. We have never suggested there was not a variance in this case. In fact, we have highlighted the variance. When their expert, Mr. DeSorga, provided a report, we believed that his analysis was wrong. And so we looked at the variance and the data that was available from the telestream system and John O'Keefe's Waze data that was on his phone that was always available to all of the experts in both sides. And when Mr. Burgess looked at the variance at the time of a three-point turn about 7 minutes before the collision, he simply matched the Waze information on Mr. O'Keefe's phone to that of the information from the telestream and saw that it was a 21 to 29 second variance. All that data was available to the defense because their expert made an improper conclusion is not our fault. This does not change the testimony of anybody. They point to Jen McCabe's text message where she said she thought she saw a motor vehicle out front that evening at 12:45.
She quibbled with that.
That is not consistent with the Commonwealth's timeline, but that doesn't change. That favors the defense. It does not change anything to do with ARCA. ARCA has not, as far as I've seen in any reports, ever talked about the variance, just Mr. DeSorga. And so because this is inconvenient for the defense, and because it further focuses the variance that we already discussed and provided, isn't a reason to exclude it. It's not late discovery. It's not a Rule 14 violation. It is further analysis of information that was already provided, opinions that were already provided, and it is in response to their experts' mistake about that variance. There's nothing new here. Nothing has changed.
Nothing new is what the Commonwealth is saying.
The only question I had for you yesterday, for you to respond to today, was the time, so I gave you more leeway.
And you're giving me more leeway, and I appreciate it.
Go right ahead.
So, 2 items, Your Honor. As I alluded to yesterday, and it's been a point that Mr. Brennan just made, we believe strongly, Your Honor, that at a minimum there needs to be a voir dire of Mr. Burgess. And we believe strongly there needs to be a voir
That she
dire
might
because
grant.
we have a serious concern that the sequestration order has been violated.
That she
He
might
has
grant.
changed a very key aspect of this matter after the testimony of Mr. Whiffen, after Mr. Whiffen presenting a timeline. In his report, Mr. Burgess, his new purported report of May 8th, he references to align it with Mr. O'Keefe's cell phone. That is
yes,
the essence
with
of
Whiffen's.
Mr. Whiffen's report, is anchoring in his timeline. He did a whole timeline on Mr. O'Keefe's report. And conveniently, the proposed alteration by Mr. Burgess in his report of this clock drift now makes it very, very close to fitting within Mr. Whiffen's timeline and the theory of the prosecution. At a minimum, we need a voir dire to ask Mr. Burgess, why did he do what he did? Another reason for the voir dire. Mr. Brennan yesterday said, we were surprised to get the report. That
He did say
further
that.
makes great concern as to why Mr. Burgess did what he did. Lastly, Your Honor, with regard to Mr. Brennan's point, he made it yesterday and I corrected it, he said it again today, that supposedly our witness, Mr. DeSogra, made an error and that we're trying to correct an error of Mr. DeSogra. That is incorrect, Your Honor. Again, Mr. DeSogra was responding to Mr. Burgess's report. Mr. DeSogra's report is entirely saying, okay, Mr. Burgess says this, and therefore the defense says this. Now Mr. Burgess is changing what he is saying. So it is completely incorrect to say that Mr. DeSogra is trying to correct an error. That would require, again, Mr. DeSogra to change what he has done. Final point is this. There was also an issue, Your Honor, and this is extremely important with regard to burden shifting. There's not only the question of should this be allowed at all, there's not only the question of how much time the defense will need, but there's a third and important issue, and that's burden shifting. What Mr. Brennan proposed yesterday was a very irregular process where essentially the Commonwealth gets 3
that's a
bites at
separate
the
issue.
apple for a problem that they caused.
That's a
The
separate
problem
issue,
we're
though.
talking about is Mr. Burgess changing a significant part of a timeline. Yes, there was a variance that he had, but he picked a range of the variance. He's now changing the variance. So what the Commonwealth is proposing is that our witnesses go forward, the Aperture gets to wait, they come on, and then the Aperture gets to come on yet again. We would urge...
I did not understand the Commonwealth asking me that. Are you asking me to do that, Mr.
I
Brennan?
appreciate the clarification.
I'm not sure what he's saying, so...
It sounds like Dobroja or...
Dobroja, disorder, disobra, disaster. I think Alessi's conflating 2 different parts of yesterday, which I can understand. Yesterday was much. The first part of yesterday's issue was the time warp. It's apparently more than just a step to the left. And the clock drift and the rest of it. That was the first issue yesterday. The second issue yesterday was ARCA and the response to ARCA's new reports. He is now taking I can't help myself. He is now taking a hop to the right into the issue of ARCA and the Commonwealth saying they don't have enough time to respond to ARCA, which is a separate issue that was argued yesterday from the issue of the clocks and the time drift, wibbly wobbly. So Alessi is now conflating the 2 arguments from yesterday and
whatever.
His name is DeSogra, yes.
DeSoder,
yes, we have time warped. I might have gone the wrong way. It's fine.
To come on yet again. We would urge
I did not understand the Commonwealth asking me that. Are you asking me to do that, Mr.
I would
Brennan?
appreciate the
I'm
clarification.
not sure what he's saying, so.
It sounds like DeBroja or whatever.
His name is DeSoder, yes.
DeSoder, you're suggesting that the Commonwealth suggested yesterday that he testifies first and then the Aperture witnesses?
What I understood was going to happen is Mr. Brennan said yesterday that Dr. Welcher cannot come in until after.
No, I didn't understand that. I understood Dr. Welcher, Shannon Burgess, and then Dr. Welcher for everything that you folks received prior, January 31st or whatever the date was. And then potentially for all the new ARCA information that came in May 7th, that portion, Dr. Welcher returning on rebuttal for. Not that they were holding back Dr. Welcher completely. Is that correct, Mr. Brennan?
That's the conversation I had. That conversation I wasn't part of.
Yeah, I think you misunderstood that, Mr. Alessi.
So
No.
just so I'm clear, what is it?
No, okay.
That
No.
the rebuttal-
Mr. Brennan,
No.
all right, this is separate, and I'd really like to give everybody a break here. What is it the Commonwealth is asking to do regarding that?
They're two separate issues. Alessi has conflated the issues because that is what Brennan asked for with regard to ARCA, not with regard to this problem.
Regarding Mr. Burgess or Mr. Welcher?
Dr. Welcher.
Dr. Welcher
What?
should come in and testify to his PowerPoint, all of his opinions, which address all of the prior
We've now changed
representations and
topics.
opinions of ARCA, although we still don't have any raw information, but we're ready to move forward. Regarding any new opinions, which there is over a dozen new opinions that includes testing, video, experiments.
This is the separate issue.
Dr. Welcher should have enough time to review, conduct his own testing, turn it over, and then in rebuttal address limited to the new issues raised by ARCA.
That's how I understood it, Mr. Alessi.
And that's how I did also, but the question is now with the Burgess changing of the clock drift, how many times is the Commonwealth proposing that Dr. Welcher gets to come in and talk about that? Is he just going to come in and talk about it?
So you talk with Mr. Brennan about that. All right, so I'm all set for this.
There are no changes. There is no changes in the timeline. He keeps trying to portray this as something has changed. Nothing has changed. It's the exact same. He's
Y'all don't
always said
agree.
there's a variance. He's been looking into the variance for a long time, and now he has found a method to show the exact variance. It's not changing. There's nothing in the reports that changes as far as the timeline. That's just an attempt to cause fear. There's nothing that has changed. We can look at the reports. It's all the same, always has been. Other than now he's identified the mistake of their expert, and that led him to be able to identify the variance, which is helpful and new. And the suggestion that there's been some violation of an order, no good faith basis whatsoever. None.
Does the Commonwealth oppose a voir dire just on that one issue?
Yes, because it's suggesting that there's a good faith basis for it. Nothing has. Ian Whiffin's report was available to the defense and our experts months and months and months ago. The issue of variance has been an ongoing issue for months. There's nothing that triggers a change in the testimony to adopt or adapt to it. Our timeline has been the same since when we turned it over at the beginning. They cannot point to one thing that has changed between Dr. Welcher,
Can we just have the report?
Ian Whiffin,
Can we
Jessica
just have the
Hyde,
report?
or Shannon Burgess. They are just saying things without a good faith basis. In the reports, show us where something has changed.
Get the report out and wave it around.
Your Honor, we would like to print the page in the clock adjustment because what Mr. Brennan says is...
Yes, and I'm happy to any information.
Yes.
All right.
Yes. Yes.
No.
Thank you.
All rise for the court, please.
Holy shit. Just get the report. Oh my God. It is so hard to evaluate these attorneys arguing without seeing the report, because during the break for the jury, which is going to be an extended break, the attorneys were back on the record to continue arguing about yesterday. The court asked the defense yesterday if they had an amount of time that they would need to deal with what the defense is calling a new report. The prosecution stance on that is they're confused and they're trying to confuse you, and none of this is new. I don't necessarily agree with none of this is new, but I haven't seen the report. I can tell you what the defense has said and what the Commonwealth has said, and they said at the end, the defense said to the court, let us print out the report and show you. And I think that's really the only option. Give the court the report, because the court does not have them. The court's not sitting there reading the report to say, I agree, I disagree. So in sum, as best I can, at the end of the morning argument during the morning recess, the defense said that at a minimum, there should be a voir dire on the issue of the clock drift between the experts, because there was a new report from May 8th. The defense says they got it on May 11th, and the defense says it shifts the timeline that the Commonwealth has put forward. The Commonwealth is saying nothing is new, nothing has changed. They're confused. The underlying data has always been there. And now our expert has a way to correlate the time from the Lexus and the time on John O'Keefe's phone. So the time on the Lexus hasn't changed. The time on John O'Keefe's phone hasn't changed. But our expert has found the variance between the two. And that is where the fight is. But the Commonwealth says the fight over the variance is not new. And it was after the Commonwealth got the defense expert report that they looked into it more. And the defense said this information should not come in. The new time variance shouldn't come in. But if the court's not inclined to do that, then at a minimum, the defense needs 4 days to figure out how to address it. And at a minimum, there should be a voir dire on the issue, which Brennan also disagrees with. He said there's no basis for a voir dire. Nothing has changed. Nothing is new. The defense has had all this information. Well, the defense says it seems to us that the Commonwealth's expert has violated the sequestration order because it seems that they are modifying the data to match what is in Ian Whiffin's report, to which the Commonwealth responded, our experts have had each other's reports, as have the defense, for months. So no, nothing is new. And it's really hard without the reports to know, because what I have found in this case is generally I see things somewhere in between how both sides represent them to be. So I just want to see the report at this point. I'm not surprised that the court asked for it. Would it surprise me if the court granted a voir dire on this issue? No. I think it is one of the most logical next steps is to grant a voir dire on it and to really get to the bottom of what happened and figure out if this is a change, if this is a substantial change, or if this is information that everyone has had. Because what the Commonwealth said is the defense has had all of our underlying data to be evaluated by their experts. They have all the raw data. This is an interpretation difference. But isn't that still a difference? The Commonwealth is saying nothing has changed. The defense is saying the Commonwealth's timeline has changed. And the court is saying, thank you, I have what I need. Can I just see the report? Will there be a voir dire on this? Will there not be a voir dire on this? Is it a significant change? Is it not a significant change? We don't have the report. But it seems that the timeline has changed based on the defense representation. And the Commonwealth is saying, based on what their expert said, we went back and looked at the clock variance, and we're not changing when something happened on the Lexus. We're changing how we interpret it vis-a-vis what's happening on John O'Keefe's phone, and that we've always maintained that. So, is this nothing new, or is it something new? What's interesting to me, and the one question I have, is that this first came up on May 15th. If the defense representation that they got this on May 11th, I'm just taking that at face value. The Commonwealth says they gave it to them May 8th. But if this was a explosive bombshell of information, I would have expected to see it come up in court the day that the defense got it. So I'm curious as to why it took a few days. If this is as significant a change as the defense says it took a few days to come up. But also, if it's not a change at all, then why is a report needed? If it's not new, why write a report? So I still have some questions, and I want to see it. Daisy said the Commonwealth got it May 8th, but didn't give it to the defense on May 11th. That's what's represented by the defense. The Commonwealth says they gave it to the defense on May 8th. And I do not take everything the attorneys say on either side at face value, because we have definitely seen some discrepancies where the defense has misrepresented things. And we have definitely seen discrepancies where the Commonwealth has misrepresented things. So when I say the defense represents X and the Commonwealth represents Y, there have been some misrepresentations made by both sides. So I don't know if the defense had it on the 8th or the 11th, but taking it generously, if the defense had it on the 11th, they didn't bring it up until the 15th, which for something that is substantial, I would expect it to come up sooner. And yes, they're busy, but there's a lot of attorneys working on the defense side, a lot of them. So the questions I have is, 1, is this a change or not? 2, is the court just going to have a voir dire to figure it out? 3, is this really an interpretation issue, or is it bigger than that? And is the Commonwealth trying to now modify their timeline so that it fits? Or is the Commonwealth's expert going to say, the Lexus says it's this time, John O'Keefe's phone says it's this time, and we have found a variance of, what did he say? I wrote it down, hold on. A variance of 21 to 29 seconds. And they are giving that range of, we found a variance between 21 and 29 seconds, and that range of 21 to 29 seconds fits within this time range. And if that's what it is, then that's what it is. So I'm curious as to how this is going to go. And again, without seeing the report, it's hard to know. I'm hopeful at this point that, well, let's just get the report and see. But the time variance that the Commonwealth says their expert has always stated was that between the clock on the Lexus and the clock on John O'Keefe's phone, that it's always been 21 to 29 seconds. And if this all falls within that range, then it really might not be new. But if it doesn't fall within this range based on past reports and new reports, then it might be new. Because we are dealing with every second counts. And what is this range? From 12:31:43 to 12:32:16? Depending on what those reports say, it's a matter of seconds. And it might fit into that 21 to 29 second variance. It might not. So we're going to have to see how the court determines this is represented, because there are some very big differences. It is not good that something that could be this significant is coming up now. Either way, that's a problem. And if the defense relied on the expert report, not their expert's interpretation, the Commonwealth expert's report, to their detriment, then it should be kept out. If this timing falls within the expert report and the defense was relying on their expert's interpretation, then it might be different. So, why was the Commonwealth surprised that they got a new report from their expert in May? And I think that's why you need a voir dire. Dude, why did you write a new report? And what changed? Put it in a voir dire. Just put it in a voir dire. Sure. But yesterday the Commonwealth said we were surprised to get a new report too. Then why was there a new report? Put it in a voir dire. Great. Great. Put put it in a new report if it's new. Don't put it in a new report if it's not, and do a voir dire. That's all. That's it. I think that's the only response. Do a voir dire. Let's have more information. And I think that is probably for the court the most cautious approach is to have the voir dire. Let's see. For those of you asking, would this be an appeal issue if the judge lets in the new report? If there's a conviction, yes. Let's see. The result that is easiest for the court. Have the voir dire and get more information before you make a decision. That is the easiest result right now. 2, keep it out. That is the second easiest result for the court. And by easiest, I mean, if there's a conviction, does this become a massive appellate issue? Easiest issues. Have a voir dire and then decide so you have more information. Easy. Keep it out. If she's convicted, it's going to become an appellate issue. If she's acquitted, well, the Commonwealth can't really appeal an acquittal. So when you're looking at it, when courts make big calls, do they sometimes break in favor of what's the least appellate issue? Yeah. What is the least likely to cause an issue? Those are the options that are least likely to cause an issue. Most likely to cause an issue is letting it in and not giving the defense any extra time. Letting it in and giving the defense extra time still might not cure the issue. So I think the voir dire, it depends on how the court reads the report, because the court's going to get the report to see. And then you get a voir dire. So let's go back to court from our only fan back to scientific testimony after that longer morning break today. And we will continue. So the jury is coming back in. I think the voir dire seems like the easiest option for the court to get the information that's needed. The prosecution objected to it. The court can order it anyway. The defense didn't want to do the voir dire Barca, and they did it anyway. So we are now after break. Jury's back. The jury would have just come in, and we're going to get back to the witness on the stand.
All right, so Mix Vallier, I'm going to ask you that you speak right into your microphone when you answer, if you could,
Keep
please.
your voice up.
Thank you.
So we are after the break. Jury is
All
back.
right, Mr. Lally, go right ahead.
Thank you, Your Honor. Now, Mix Vallier, we talked about sort of the physical match or mechanical fit analysis that you did with regard to each of the items individually, correct?
Yes.
And can you explain for the jury the process that you undertook in your physical match analysis between different item numbers?
So between different items, amongst the questioned ones, I only compared the pieces that were large enough to have a label on them.
Physical mechanical match.
Some pieces were quite small. I utilized several benches and divided them up into sections for each item, and individually pulled out all of those pieces. And then I had another bench where I did the actual comparison. I started with all the pieces of the same color and looked to see if any of those had potential edges that could match.
Now, with respect to items 715 and 716, did you do a physical match analysis between those two separate items?
May I look at my notes?
Yes.
Okay.
The court has given the experts with no objection, because there's been no objection, the ability to go through their notes. For this type of expert, that was a rude
Yes.
pause. Apologies. The court has given the scientific witnesses the ability to refer back to their reports broadly. That is different than other types of experts. And it is because A, there are a ton of reports, B, there are a ton of numbers, and C, everyone has these reports. So the defense can sit there and look through the report as the witness is looking through the report. The reports themselves aren't evidence. The testimony's evidence, but the information from the reports needs to come in just as it is in the report. The defense has no objection. The Commonwealth has no objection. It makes everything go smoother when it comes to getting that information before the jury, because what you don't need is a witness to conflate 14-17 and 14-18, one which might have 13 pieces of plastic and one that might have 9 pieces of plastic, and then it just becomes a whole fucking kerfuffle. So the notes are taken at the time. The notes are reliable. For these witnesses, it's really not a memory test. It is based on their notes because those are the tests that they did. So yes, they are allowed to use their notes. Let's continue with the testimony
And what,
of
if any,
the
conclusions did you
manual
come
match.
to in relation to your physical match analysis between item 715 and item 716?
2 pieces from item 7-15, F and H, fit mechanically with 2 pieces from item 7-16, F and G.
And what, if any, conclusion were you able to draw with reference to the physical match between pieces from item 715 and pieces from item 716?
Those 4 pieces were at one time together as part of a larger unit.
Now, Ms. Vallier, what physical match analysis did you do with reference to items 7-6 and 7-11?
So 1 piece from item 7-6, piece B.
Y'all, I know some of you are ahead in real time, but look, if there are spoilers, I will time you out. If there are lots of spoilers, it's just going to be yeet. So if there are spoilers, I don't appreciate it because it's really, really distracting to me. And I know the chat that's watching it in real time, it's distracting to them. It is so much. So thank you for no spoilers. And if there are, I'm just going to start hitting the yeet button. And I know you guys love watching trial here, but it is hard for me to focus when I am trying to absorb the testimony. We watch things on a bit of a delay. That is my preference because I want to stop and be able to chat with y'all about what's going on. But with the spoilers of what's going on in real time, it is real hard on me. So I appreciate it. And if there are spoilers and you're like, why can't I chat in the chat? It's because I'm just going to start hitting the button. So thank you guys. I appreciate it. Let us continue. Spoilers really ruin my day. So I will just yeet. And so will the mods, but it's me. The mods have seen me in their timing people out. So it's not helpful and it really is very distracting. So thank you for honoring my ADHD and sticking with the no spoilers because we watch trial this way. So thank you. I appreciate it. Ryan said, call it the ban hammer. It's the yeet button. It is the yeet cannon since I didn't get to make my own cannon, the yeet cannon. And I know most of you are just trying to help. But it is hard on me. So thank you guys. I appreciate it. Let us continue.
Fit mechanically with 1 piece from item 7-11, piece D. So those 2 pieces were at one time together as a larger unit.
Mm-hmm.
And Ms. Vallier, with reference to items 7-8, 7-9, and 7-16, what, if any, conclusions were you able to draw from any physical match analysis you did between pieces from those 3 items?
So 2 pieces from item 7-8, pieces C and D, 1 piece from item 7-9, piece A, and 1 piece from 7-16, piece E were found to have a mechanical fit. So those pieces were at one time together as a larger unit.
This is what's so hard with this testimony is without putting photos up for the jury, I don't know how the jury is keeping track of, we are now in all of the different bags of evidence and what is piecing together as a larger piece. And without photos, I don't know how the jury is sitting there going 7-8 and 7-16 and 7-14. What pieces are going together? But we'll get there. So I couldn't do it. If I was sitting on the jury, I'd be rolling my eyes back in my head. I just want to see.
Lastly, for this section, at some point did you do a physical match analysis for the glass pieces in items 7-12 and 7-14?
Yes.
And what conclusions were you able to draw from your physical match analysis between 7-12 and 7-14?
There was no physical match between the glass pieces from, or apparent glass pieces from 7-12 and the glass piece from item 7-14.
Now, Ms. Vallier, are you aware that there was an additional analysis that was done with respect to glass pieces and other glass pieces that you didn't examine in your analysis at your lab?
I know that there was other trace work done. I'm not sure exactly what the work was.
That
and do you know who performed that additional trace work?
Christina Hanley.
And who is she to you as far as in reference to your work at the lab?
She's my supervisor.
Now, with regard to each of these items individually, they came as labeled in individual bags as we demonstrated on the screen, correct?
Yes.
Okay. And with respect to those bags, did you note any particular date associated on the front of those bags?
That's documented in my photos.
And all I'm asking here is that with respect to each of those bags of items, whether they be 3-1, 7-4, 7-5 or 6 or 8, many of those bags had different dates on them, correct?
Yes.
Okay. And when you received those items in that bag, you essentially removed the items from those individual bags, placed them on the table, and examined them, correct?
Yes.
And that examination included a microscopic examination?
Yes.
Now, with respect to any of those items, there were some items that pieces within the same bag that had the same date on that bag did not fit together mechanically, correct?
Oh.
Yes.
However,
he knows where the cross-examination is going with that. So Lally's questioning, and I also find it hard to follow, and that's not all due to bad questioning. Some of it is just difficult without visuals. But Lally is talking about the evidence bags being same date or different date, and whether or not all of the pieces in one bag from one date all fit together or not. Some of the pieces from one bag from one date do fit together, but some of the pieces from one bag from one date don't fit together. And it is to cut off the line of cross-examination that's like, so all of those pieces on that day, I'm picking the 18th as a random example, those were all collected by Proctor alone. And look, all of those pieces that Proctor just collected alone on whatever made-up date, isn't it weird if all of those fit together? Yeah, because if something breaks and is in the street and in the yard, what are the chances that the 3 pieces out of 40 or whatever you pick up all happen to fit together? Isn't that weird? So it doesn't surprise me that Lally is trying to get ahead of that area of cross-examination because we know it's coming. And I think with the first trial and the internet, Lally is able to see where some of these arguments are going because they're not just happening in court.
there were items from one bag collected on one date that did fit mechanically with items from another bag collected on another date. Is that correct?
Yes.
I'm going to back up that. That's actually really
Now, if I
helpful
could
testimony that's getting buried in the middle of a lot of necessary but difficult foundation. It's
those items in that bag.
So that was a good line of questioning from Lally. It's just buried in the middle.
3-1, 7-4, 7-5 or 6 or 8. Many of those bags had different dates on them, correct?
Yes.
Okay. And when you received those items in that bag, you essentially remove the items from those individual bags, place them on the table, and examine them, correct?
Yes.
And that examination included a microscopic examination?
Yes.
Now, with respect to any of those items, there were some items that pieces within the same bag that had the same date on that bag did not fit together mechanically, correct?
Yes.
However, there were items from one bag collected on one date
One.
that did fit mechanically with items from another bag collected on another date. Is that correct?
Yes.
Now, if I could turn your attention to item 3-1.
Even Lally sounds tired
Again,
with the
for
questions.
the jury, what is the physical description associated with item 3-1?
Item, passenger side taillight, Massachusetts 3GC 684.
Now, did you perform a physical match analysis with pieces from item 3-1, 7-5, 7-6, 7-8, 7-10, 7-11, 7-12, 7-13, 7-14, 7-15, and 7-16?
I compared them, yes.
And what, if any, conclusions did you come to from your analysis, your physical match analysis between item 3-1 and all of the items beginning with the number 7?
Yes, it's needed. Yes, it's needed. Yes, it's needed. I laugh because I'm just having flashbacks of how tedious this is for the lawyer. It can be tedious for the witness as well. Yes, it feels like bingo calling, but this is the comparison between the physical taillight casing that was taken out of the SUV and all those 7- numbers of taillight collected at the scene.
There was a physical match with.
There was a match.
Do you want me to list?
If you
all
could,
of them?
please.
Okay.
It's like, God, no.
So 2 pieces from item 7-5, 4 pieces from item 7-8, 1 piece from item 7-10, 4 pieces from item 7-11, 2 pieces from item 7-12, 2 pieces from item 7-13, 4 pieces from item 7-15, and 4 pieces from item 7-16 were found to fit mechanically with item 3-1.
So not 7-14 and not 7-6.
What, if any, conclusions were you then able to draw from your physical match analysis between item 3-1 and each of those respective items beginning with the number 7?
Those pieces were once together as part of a larger unit.
There we go.
May I approach, Your Honor?
That's the conclusion. Those pieces were once together as part of a larger unit.
What's depicted in those?
Not all of the pieces.
I do.
And what do you recognize those?
Just Call Me Hen, this is a great question. Just Call Me Hen said, so not all of the pieces fit? No, not all of the evidence bags only contained plastic pieces. Some of the bags that they're talking about contained glass pieces and other things like the straw, etc. So whether or not that encompasses all of the plastic pieces, they have not asked yet, but there are other things that were evaluated that are not plastic. Hopefully that helps. But they have not asked. So all of the plastic from all of the bags fit. They're not there yet.
This is a comparison between item 3-1 and those pieces from all of the other pieces.
Please don't make me name them all again.
Introduce in the mix as the next exhibit A, B, and C.
So the conclusion is those pieces were once part of a larger or part of all one piece.
182A, B, and C.
Relzy said, so everything was thrown in one bag. No, we went through the bags much earlier. If you go back and look through the bags, you'll see.
And may I publish, Your Honor?
When you go through the bags, some of them had glass.
Gilman, if I could have.
Lally, I don't know what you're doing to that microphone, but good Lord, I might file charges. Not all the bags had plastic pieces in them, but there were numerous pieces in the different bags, and we went through that at length. I will save this for later. The answer is yes with an asterisk.
Photograph 2096. Ms.
There we
Gilman,
go.
yes. If you could even zoom in just a little bit more on the item itself.
So that
Ms.
is
Vallier,
that is the puzzle, the mechanical match.
what are we looking at in this photograph?
So those pieces that I labeled from item 7 dash, all of those, they all fit together mechanically into this piece.
I get
And as
get
far
why
as
they don't want to
earlier
say.
you were testifying as far as the label maker and the different various pieces that you would label throughout the process of your physical match analysis.
Yes, I
You
was
see
delighted
these
by
in
the
this
label
photograph
maker.
as well.
I do.
And where are they located with reference to the reconstructed piece above?
They're those little white rectangles on the piece.
This is before they
What's
match
depicted
it
here is
into all of the taillight.
the mechanical fit between items 7-5, 7-6, 7-8, 7-10, 7-11, 7-12, 7-13, 7-14, 7-15, and 7-16, correct?
Not item 7-8.
Emily, are you now giving spoilers? Yes. Sasquatch the Quatch said, I wish we could see it fit together next to an intact light. Sort of, but we'll see it with the casing. So we'll see it with the casing.
And 7-14.
Or I
but
suspect
the
we'll
other
see it
ones,
with the
yes.
casing.
And why not those two?
They didn't fit mechanically with the other pieces.
Ms. Gilman, if I could have 2150. And again, if you could just zoom in a little.
So that is the casing
And
and
Ms. Vallier,
the
what are we looking at in this
mechanical match.
So on the right side was that piece that was just shown. And on the left side is item 3-1.
And lastly, Ms. Gilman, if we could have 2151.
Yeah, this is why I say they should have shown it
Zoom in on that
the whole
item
time.
before. And Ms. Vallier, what are we looking at in this photograph?
So that's that right piece on top of the tail light from the previous photo.
And is this the mechanical fit that you were testifying about earlier with reference to item 3-1, the taillight housing, and all of the various pieces that were found in 34 Fairview, starting with the number 7?
Yes.
I like how Lally shortcut
Thank you.
that. All
Ms.
of the
Gilman, you can
various
take that.
pieces starting with the number 7 instead of reading them all off again.
Ms. Vallier, lastly, in reference, did you also receive some debris from John O'Keefe's clothing?
Yes.
And Mr. Officer, we can have the lights back on. Thank you very much. And what did you find contained within that debris from John O'Keefe's clothing?
So it was 5 different items. So it was debris collected from, labeled as coming from the clothing. There was mostly debris, some apparent fibers.
Are there any pieces of apparent plastic contained within the debris?
Yes.
Was there dirt contained within the debris?
Yes.
And that debris was labeled as an item 17-18.18, is that correct?
I believe so.
And what is it that you did with the debris from the gray long sleeve shirt and the orange t-shirt?
So those were all packaged in like glassine folds. And I looked through it and documented it.
When you say you documented it, did you look at it under a microscope?
Yes.
So you did an examination under a microscope, is that correct?
Yes.
Yes.
And did you measure some of those items contained within the debris?
Yes.
Specifically, did you measure items of apparent clear plastic contained within the debris?
Yes.
And what did you measure those items to be?
I appreciate that they check what the court, even though the court has given blanket permission to check notes, it was a topic shift, and I appreciate the consideration
The
for the court.
piece of clear apparent plastic was approximately 1/8 inch by 1/16 inch.
And once you had conducted your preliminary analysis of those items, where did those items go?
I did no further examination on this myself. Christina Hanley might have examined some of these further.
Thank you. I have nothing further.
No photo?
Giannetti?
All right, on to cross.
Good afternoon.
Good afternoon.
I'd like to first talk fairly briefly about your reconstruction of the taillight to which you've testified. At the outset, by the way, that was item 7-3.1.
Emily, your wishes have kind of been granted. You asked for glasses Yannetti earlier, and we get glasses Yannetti now.
About
Emily, you're incredibly biased about glasses. Yes. Yes, I am. Team glasses. We wanted glasses Yannetti earlier, and we got it.
Of the taillight to which you've testified. At the outset, by the way, that was item 7-3.1. Am I correct?
Sorry, for which one?
That's the taillight, this 7-3.1. Am I correct?
3-1, I believe.
7-3-1?
What?
The taillight is item 3-1.
Oh, 3-1. I'm so sorry.
The taillight casing is 3-1.
With regard to that particular item, your lab has different departments, correct? Criminalists who do different things, correct?
Yes.
You are aware that there are scientists within your lab who do DNA analysis, for instance, correct?
Yeah. Yes.
And with regard to the order of processing items, is the DNA analysis done before or after you get the item?
I know.
It's usually before.
Okay. In this case, it was before. Am I correct?
I believe so.
Were you made aware that there were 3 contributors of DNA to that taillight, 3-1?
I'll allow it.
She's not going to know that. But okay.
No.
Once you reconstructed the taillight, you'll agree with me that it was missing a piece, correct, or pieces?
There was an empty spot on the overall reconstruction, yes.
Would you say there's a blank space?
Were you ever provided with any pieces of taillight that would have filled in that missing spot?
No.
Were you ever provided or told about any pieces recovered from 1 Meadows Ave in Canton?
No.
Were you ever told about a collision at 1 Meadows Ave in Canton? In any case, you'll agree with me there was no glass in that taillight at all, correct?
Within the taillight, I classified them as apparent plastic pieces.
There's no glass as part of the taillight, correct?
They didn't test that.
I mean, it depends on what you call, like, the bulbs usually have glass as far as I'm aware.
Those are very, very thin glass, though, correct? Those bulbs?
Yes.
All right. Now, your lab received clothing in connection with this case. You've testified to that, correct?
I received the debris labeled as coming from the clothing. I never saw the clothing at all.
Right, but you're aware that your lab received clothing before the debris got to you, correct?
Yes.
And your understanding was that that was John O'Keefe's clothing in which he was found on January 29th of 2022, correct?
It's labeled as coming from him. I'm not sure of the date that it was found.
Okay. You understand the procedure that goes on at your lab when it receives evidence?
Yes.
And you know that once clothing is brought to your lab, it's given evidence numbers, correct?
Yes.
Yes.
And then one of your colleagues at the lab handled the clothing and or examined it, correct, before it came to you?
Yes.
Yes.
And your understanding is that one of your colleagues retrieved debris from those items of clothing and then packaged it in a fold before it got to you, correct?
Yes.
You then open up the fold and you look at the debris, correct?
Well, it's a glycine envelope.
You never saw that debris inside the clothing, correct?
Correct.
And the
defense's focusing on
Pieces of clothing that come in are given
John O'Keefe's
evidence
clothes,
numbers
which
when your lab receives
I think
them,
is smart
correct?
instead of focusing on the
Yes.
taillight.
For instance, the orange T-shirt was given or was named item number 7-17,
Yes.
and the gray long sleeve shirt was item 7-18, correct?
Yes.
And your lab is accredited, correct?
Yes.
There is a complete chain of custody from the moment the clothing was brought to the lab to when the debris was
that's the key.
removed from the clothing, ultimately to when you're in court today handling the items, correct?
Yes. Our in-lab chain of custody extends from when we receive it to when the submitting agent, it is returned to the submitting agency.
Okay. And you have complete confidence that the chain
The
of custody...
distinction there is that Yannetti is saying the lab has a complete chain of custody from when you get it to when you're in court today. The clarification on that was we have a complete chain of custody from when we get it and when we return it to the submitting agency. That's not when it comes to court. They have a complete chain of custody from when it's checked in and when it's checked out. It gets checked out, goes back to the troopers before it ever gets to court. I think that's an important distinction for the witness. Whether the jury catches it or not at this point on a Friday, who knows? But again, I appreciate that the defense has continued to use the scientific witnesses to highlight what it looks like when there is a chain of custody within an agency. And I think the defense has done that well.
Custody at your lab is effective at making sure that the evidence does not get lost or mixed up or contaminated, right?
I mean, the chain of custody is meant to track where a piece of evidence is. The evidence unit also does inventories and audits to make sure that things are where they're supposed to be.
And you have confidence in your lab's
The SOPs
chain of custody
keep things from getting
policies and procedures, correct?
cross-contaminated, not
Yes.
the chain of custody.
But you'll agree that your lab cannot control who handled the clothing before it arrived at your lab, correct?
Yes.
It's not the lab's
There are
fault.
times in which crime scene technicians or criminalists from your lab actually participate in the search for evidence at a crime scene, do they not?
Some of the people at the lab are crime scene responders, yes.
There are times when they actually take custody of evidence. Again, I'm talking about people from your lab, professionals. They take custody right from the crime scene and transport that evidence to your lab, correct?
Professionals, he says.
Yes.
In those circumstances, your lab would have a complete chain of custody from discovery to seizure to testing or whatever comparison you're doing until you release the items, correct?
Yes, but the electronic chain of custody doesn't start until that item is entered into our LIMS system at the lab.
Right, but when it's entered in, it would be entered in as having been seized by somebody from your lab, correct? In the hypothetical that I'm giving you.
Yeah, there's an evidence submission form that says that this crime scene responder submitted it to the laboratory.
There are other cases, however, when the evidence is brought to your lab by the police,
documented.
correct?
Yes.
Local departments have access to your lab?
For evidence drop-off, yes.
The state police have access to your lab for
This
evidence
witness
drop-off?
they're so careful with their answers and very quick with very careful answers. And I just appreciate it because Yannetti's questions are a little bit broader and they're getting narrowed back down. I'm not saying that they're fighting with Yannetti. I'm simply highlighting that you can correct and narrow an answer well without fighting with the defense attorney, because it does not feel like they are fighting with Yannetti at all. It is, local police have access to your lab. Well, what could access to your lab means? Are they running around like touching shit? No, they can drop things off. Again, it is a narrowing, but it is not quibbling. And I appreciate seeing the difference from some of the witnesses where you can see the quibbling. This is a narrowing and clarifying while being incredibly precise and also processing it much faster than I think any of the witnesses we've seen, because their answers are so fast on cross and precise. And a number of you in the chat are saying, right, it doesn't seem evasive. Exactly. That is a better way to say it.
Yes.
It's been a long day.
And in
But
this
yes,
case, it was not
evasive at
a
all.
criminalist or other professional from your
Precise.
lab who seized the clothing and brought it to your lab, correct?
I'm not sure.
Yeah,
Do you have a record of that in your report in terms of
We don't know who
it was
did what.
that brought the material to your lab?
I could look at the evidence submission form to see who.
With the court's permission?
Yes. Okay.
And I appreciate everyone staying on topic. We normally bounce when people are talking about other people going live. I think Ryan Hall's channel tends to be the exception because of the severe weather. So thank you, mods. It's okay. We thank you, chat. We saw it. Everyone can stay weather aware in their area. It can get very distracting talking about when people are going live. I've seen people streams or try to stream snipe Ryan Hall's chat, which is wild to me. I'm like, who would do that to him? But it hasn't happened on our chat in quite a while. But we generally try to just focus on what's going on in our cases in courts.
Do you have that with you now next week?
And not, I missed that question because I was reading all the chats about Ryan Hall going live and wondering about my weather. That's why we don't do it, because I squirrel and get completely distracted. If anybody asks, why are the rules in the chat the way the rules are in the chat? Because Emily has ADHD and I'm trying to focus on this and I will end up running sideways.
Do you have a record of that in your...
They asked, okay. Yannetti asked for a record of who dropped stuff off to the lab.
The professional from your lab who seized the clothing and brought it to your lab, correct?
I'm not sure.
Okay.
Do you have a record of that in your report in terms of who it was that brought the material to your lab?
Tell me in the chat. Do you have a record of who brought those items to your lab? Is the jury at this point in their head just going, but was it Proctor? But was it Proctor? Because Proctor's just become the elephant in the room. Is it Proctor? And for this witness, they really might not know, because I imagine just from how the lab works that it got checked in to trace because of what was collected at Canton PD, and it got all checked in by trace. The clothing would have come in and been checked in later by Proctor and gone to trace. So for the chain of custody for this witness, it would have been probably from trace to them or from trace to another unit to them. So they're not getting it from where it's checked in from. They're getting it from another department is generally what I would suspect. So do you have a report on that? I don't know if I have a report on that. And that would be why.
Do you have a record of that in your report in terms of who it was that brought the material to your lab?
I could look at the evidence submission form to see who.
With the court's permission?
Yes.
Because it would go through the different departments first. So
Okay.
Brennan asked to approach. They're looking for the evidence submission log. I like this witness, and I think their job is so cool. It's just cool. Emily, did you get this excited when Arca was talking about the yeet cannon? Yeah, I like scientific witnesses a lot.
All right, go ahead, Mr. Manning.
Having reviewed your reports,
I did. I
can
started
you testify to the jury about who it was that brought this evidence into the lab?
So you can tell us.
Okay. So submission 7, all the items that are 7- was submitted by Trooper Michael Proctor.
Shocking!
Were you aware of the date of the incident that gave rise to this case?
Ooh, I was hoping you would ask
yes.
this.
And what was that date?
I know.
January
chat,
29th, 2022.
Chat all just went shocked Pikachu. The entire chat went, no. All the taillight was submitted by Michael Proctor. And if Yannetti is going where I think he's going with these next questions, I love the timing of it, because here's what I think we are setting up to knock down on this cross. I love it when I can see it coming. All of the 7- evidence, the taillight pieces, and a few other things, all of the 7- evidence was submitted to the lab by Proctor. Do you know what date the incident happened? And then, do you know what date it was submitted to the lab? I imagine is where we're going. I want to know when the 7- series was submitted to the lab. I know the clothes got to the lab in March, but when did the taillight get submitted to the lab? And I think that's where we're going with this line of questioning.
Were you aware that the clothing that you received was seized from the Good Samaritan Hospital that very day?
No.
What date was the clothing brought to your lab?
Clothing was in March.
March 14th, 2022.
So that means that your chain of custody at the lab began on March 14th of 2022, correct?
Yes.
And would you agree with me
What about
that was
the
about
taillight?
6 weeks after the date of the incident, January 29th of 2022?
Yes.
And of course, you can't speak to the chain of custody from January 29th to March 14th of
I don't know what
2022,
happened.
correct?
Nope.
Correct.
And you have no information and do not know why Michael Proctor waited 6 weeks to bring this clothing to your lab, do you?
Sustained.
Do you know where Michael Proctor stored this clothing during that 6-week period?
Nope.
No.
Do you know how often he was alone with access to the clothing during
Nope.
that 6-week period?
Do you know
Do you know
who
if
else
he had access to
access
pieces
to
of
it?
red or clear taillight during that 6-week period?
Nope.
Sustained. Move on, Mr. Yanni.
That was so argumentative. It's going to come up in closing. But yeah. Argumentative. When did the taillight get
You were
submitted
not
to the
present
lab?
when the clothing was seized, correct?
When was the taillight submitted to the lab?
Correct.
You did not have custody of this clothing from January 29th of 2022 to March 14th of 2022, correct?
Correct.
You do not know what was done with the clothing before it arrived at your lab, correct?
You've covered this, Mr. Yanni. Move on, please.
One last question.
No.
You cannot vouch for how the clothing or taillight pieces were handled before they got to your lab, correct?
That's been
I
asked
cannot.
and answered. When was the
Anything
taillight
further,
submitted?
Mr. Lally, or you all set?
When was the taillight submitted?
I'm not cribbing it.
Nobody asked.
Mr. Vallier, there is a separate evidence unit contained within the Massachusetts
Redirect.
State Police Crime Laboratory, correct?
Correct.
And fair to say you have absolutely nothing to do with that, correct?
I'm not a part of that unit.
And so your responsibility as far as chain of custody is concerned is from when you retrieve the item during your analysis and then when you return the item.
He asked about the clothing. He asked about the clothing when the clothing was submitted. But I didn't hear him ask when the 7 series was submitted. But if they were submitted the same day as the clothes, he did ask. I'll have to go back and watch it. This is why we have chat rules, so I don't get distracted. I'll go back and watch it. But if all the 7 items went the same day, then that would have been March 14th. So I'll go back. All of you were like, no, he did. He asked if the 7s were all the same day. Perfect.
To the
Thank you,
evidence
Chad.
unit, correct?
Chad is Bay.
Correct.
And from that analysis that you performed, you found that there were 10 different items, starting with the number 7, that were a mechanical fit to 3-1, the taillight housing from the defendant's vehicle, correct?
Correct.
If it's 10 items, I
Didn't
don't have.
count.
I can count them.
As far as all those items beginning with 7 that you went through or elucidated on your direct examination, each of those were a mechanical fit to each other and then to the taillight housing in 3-1.
The pieces that were previously stated, yes.
Nothing further.
All right, Mr. Alicia, you are all set.
All right. And that is the end of Witness 32. And this witness is being excused.
Right, so jurors, that is it for today. I'm told when I spoke with counsel earlier that we are still on track.
I mean, nobody told us it was a half
I have
day.
to tell you those same cautions. Please do not discuss this case with anyone.
All right.
Don't do any independent research or investigation.
Heads up would have been
into this
nice,
case.
but
If you happen to see, hear, or read anything about this case, please disregard it and let us know. Be extra careful with your social media use. And also, I just want to remind you, next week, Thursday is a half day and Friday is a day off. All right?
well, that's helpful.
Please rise for the jury.
At least we have scheduling for next week. The jury has scheduling. It's also helpful when we put that on the record. So that is the end of court with the jury today. Let's see if they're, yep, court goes back.
Before we recess.
They said remain seated. So the jury is done for the day. It is a half day. Did we have a heads up that it was half day? No. Next week, they are going to have a day off for Memorial Day weekend, which is perfect because, well, I have like really complicated kiddo calendaring next week. So, I mean, I will miss y'all when we have less of a week next week getting into the Memorial Day weekend, but it ensures that I can stream and do all the end of the year stuff that I have to do. And if all of you are like, end of the year, Emily, it's May, not June. I know. The end of the year comes real early in Middle Tennessee. So I can do all the things I need to do for my kiddo's last day of school. I'm thrilled. Will this make things take longer? I don't know. I'm sure the court was always going to take off the Friday before Memorial Day for the jury. So next week, there will be a half day on Thursday, the 22nd, and then a full day off on the 23rd. Whoop, whoop. I'm excited about that. And then I'm out of town for a few days. And then Monday, there will be no court the 26th for Memorial Day. So they'll actually have, I mean, the defense today was asking for 4 days off with no court Friday, no court Monday. I mean, it's Memorial Day, but lawyers don't observe holidays. There will be a 4-day break for the jury. So let's get back on the record with court.
So before we recess, I appreciate that counsel provided me with the information. Mr. Leslie, I got the two.
Oh, the court got the reports. So back on the record. The court got the reports on the time
Reports
shift.
that you had that were incorporated in what the Commonwealth had given me a few minutes before, but I appreciate that it was pointed out here. We've had full argument on this yesterday and today. My findings for the record are that the defendant has not persuaded me of undue surprise or unfair prejudice by this information, and I don't find that there's delayed disclosure. Of course, all of this is ample game for cross-examination, certainly as to what Mr. Burgess knew, what he looked at, why he looked at it, when he looked at it, why he changed his report, and violation of the sequestration order is all for cross-examination, and I will give you a lot of leeway with that, Mr. Alessi, but I'm not having a voir dire on that. Mr. Alessi, I can tell you, obviously, you've got a great facility for cross-examining on the underlying information here. You've done fulsome cross-examinations. I have every confidence you can do it here again. But if after the direct, you demonstrate that you need further time, I'll certainly hear you on that. And more importantly, perhaps, if you feel that the testimony of Jen McCabe and the others that you've mentioned is critical and that you need to recall them, I'll hear you on that as well. So regarding Dr. Welcher, as my understanding, the request yesterday was for, and it's been a request, I think, a few days. We've addressed it at sidebar, and I found that it wasn't the right time. Let's see how much Dr. Welcher could go through. I understand Dr. Welcher will testify in the Commonwealth's case in chief like next week or so, Mr. Brennan.
Hopefully next week, if not,
All right.
the day after the holiday.
And that will be for all of the material that was provided to the defendant initially, right, by the Commonwealth's discovery deadline?
Correct.
And what you're asking for is that after ARCA testifies the new information, you're asking for rebuttal, right?
Yes, limited to the new information.
All right, so I would allow under these circumstances a limited rebuttal, and we can define the scope after we hear the testimony of Acker. So those are my rulings. Your objections were noted. I'll see everybody on Monday.
All right.
Okay. Well, I'm going to back that up and do that one more time. The court has all the reports. We do not have the reports.
Before we recess,
We're going to listen to this one more time. I'm very interested to hear what the court has to say again.
I appreciate that counsel provided me with the
Interesting.
information. Mr. Leslie, I got the 2 reports that you had that were
She's not going to allow the
incorporated
voir
and what the Commonwealth had given me a few minutes before, but I appreciate that it was pointed out here. We've had full argument on this yesterday and today. My findings for the record are that the defendant has not persuaded me of undue surprise or unfair prejudice by this information, and I don't find that there's delayed disclosure. Of course, all of this is ample game for cross-examination.
right.
Certainly as to what
So the court has said that she found no undue surprise.
yesterday and today. My findings for the record are that the defendant has not persuaded me of undue surprise or unfair prejudice by this information, and I don't find that there's delayed disclosure. Of
And
course,
she doesn't find there's delay. Okay, let her finish her sentence.
all of this is ample game for cross-examination.
Okay, so what the court has said is she's reviewed the reports now. Do we have the reports? No, we don't have the reports. We have the defense's representation of the reports. We have the Commonwealth's representation of the reports. We don't have the reports. But the court said that this is not undue surprise and not unfair prejudice. I don't have the reports to evaluate them independently. We have what the Commonwealth says that they say, and we have what the defense says that they say. And now we have what the court says that they say. There, I'm sure, will be much debate over this, but the Commonwealth has said that this is all based on underlying information that the defense already had. If the court agrees with that, and it seems that she does, then it is not quote unquote new information. The court is treating this like a battle of the experts. Go ahead and cross-examine on it. Cross-examine on it. Cross-examine on all of it. But the court is finding that it is not undue surprise, that it is not late discovery, and that it is not, what did she say? Unfair prejudice to the defense, which indicates to me that the court is finding that this is not new information. So she's going to allow the defense to cross-examine on all of this, and then said if witnesses need to be recalled, she would allow those witnesses to be recalled, which a lot of the time the court would not allow. So the court's remedy is this is for cross-examination. This is not new. And if you do need to ask other witnesses questions, I will entertain it. Let's hear the rest of what she says. Because she said if after direct, the defense wants more information, my words, not hers, that they can ask.
Certainly as to what Mr. Burgess knew, what he looked at, why he looked at it, when he looked at it, why he changed his report, and violation of the sequestration order is all for cross-examination, and I will give you a lot of leeway with that, Mr. Alessi, but I'm not having a voir dire on that. Mr. Alessi, I can tell you, obviously, you've got a great facility for cross-examining on the underlying information here. You've done fulsome cross-examinations. I have every confidence you can do it here again. But if after the direct, you demonstrate that you need further time, I'll certainly hear you on that. And more importantly, perhaps, if you feel that the testimony of Jen McCabe and the others that you've mentioned is critical and that you need to recall them, I'll hear you on that as well.
Okay.
So regarding Dr.
So the court, well, at the end of day 17, the court has issued her ruling with regard to 2 issues. One, the experts regarding the time shift, time warp, wibbly wobbly, and 2, regarding ARCA and the Aperture experts for the prosecution. Let's start with the second part because it's easier. With the Aperture ARCA issue, and those are the Commonwealth's Aperture experts and the defense's ARCA experts, the court did not block ARCA from testifying when the Commonwealth asked, and asked ARCA to get their new testing and new reports and new opinions in by May 7th, and ARCA has done that. The Commonwealth has complained that they did not have enough time then to have their expert review the new findings. So what the court has allowed is that the Aperture experts would testify in the case in chief for the Commonwealth regarding ARCA's previous expert opinions and what they had said in their previous reports, which were turned over in advance, well, briefly in advance of the first trial. The Commonwealth said that ARCA has new opinions and numerous new opinions in this trial. That doesn't surprise me. ARCA has been hired by the defense now, not just by the feds, and has asked ARCA to act as responsive witnesses to the Commonwealth's new expert. So ARCA has turned over all of their information and the Commonwealth's experts going through it. The court is going to allow the Commonwealth to use their expert in their case in chief and then bring their expert back in rebuttal only as to ARCA's new information that was turned over late to the Commonwealth. And whether or not, and I'm sure there are lots of opinions about whether the defense has reason to turn it over late or not, it is still late as just a matter of course, and the expert needs time to review it. So the court decided to allow that to be split. Could the court have delayed the trial? I suppose. Did that happen? No, we're in trial and here's where it is. So the Commonwealth, if they choose to, will be allowed to bring their experts back in rebuttal only to go over the new information from ARCA, not the previous information from ARCA. So that is the ARCA issue. That is how the court is addressing it. The court did not block ARCA's new opinions. The court did not limit ARCA's new opinions. The court did make the defense jump through quite a bit of hoops on that, including the voir dire and the rest of it, but the court is letting that all in and has given the Commonwealth more time to address it, which means that the defense is going to be very busy because the Commonwealth's expert is still going to be working regarding the new opinions from ARCA. Back to the experts over the clocks and the time shift. The prosecution is arguing that all of the underlying data and all of the information had been turned over to the defense. And even though there is a new report from their expert from May 8th, that new report is not new information. That is what the Commonwealth argued this afternoon. The defense argued that it absolutely is new information and that it changes the timeline and that the Commonwealth is shifting the timeline to match Whiffin's testimony and asked for a voir dire and then gave the reports to the court to review. The court reviewed the reports today and said that she did not find that that was that was not, what were her exact words? I wrote it down. So much has happened today. That the defense did not suffer unfair surprise or undue prejudice, and that it was not late disclosure. What I can gather from what the court is saying is that she does not agree that this is new information, even though it is a new report, and told the defense that that was all grounds for cross-examination. She also told the defense that she was going to give them pretty wide latitude on what is going to be a battle of the experts issue. You can cross-examine on why there is this new report. You can cross-examine on whether or not they broke the sequestration order. You can cross-examine on all of this. And the court has indicated that at the end of direct examination of the Commonwealth's expert, if the defense feels they need more time, that she will entertain the defense asking for more time then, which is a really clunky remedy, in my opinion. But she also told the defense if after they get the new, if after the Commonwealth's expert testifies, the defense wants to recall witnesses that they had previously called, that the court would allow them to do that. Earlier in the trial, I have been asked quite a lot, can the defense call this witness back or call this witness back? And I have said repeatedly that the only reason you're recalling an expert is if you need to cross-examine them or examine them on something you could not have examined them on when they were on the stand. And the court is indicating with that ruling and finding that this is something that they could not have been examined on when they were on the stand. So she will entertain allowing the defense to recall those witnesses, which is not dissimilar to what she did in the first trial when there were issues that were discovered later. And the defense said, this witness has already testified. You might remember if you watched the first trial at one point, the court said, do you need to call this witness back? And Jackson said in court, I've done the damage I needed to do to this witness, but was nonetheless frustrated. In this case, I've seen a lot of questions, particularly around this area. Why isn't this a mistrial? The defense did not ask for a mistrial. The defense asked for more time, which they're also going to get because the court is taking a little more than a 4-day weekend for Memorial Day, is taking a half-day Thursday, full day off on Friday, and then a full court holiday on Monday. So the defense will get the time that they asked for. They said they needed about 4 days, and they're going to get that. But the defense did not ask for a mistrial in this case. Why? Because then they start over. It just resets the case back to starting this trial again, and they don't want to do that. I think the defense has made some really good headway in this trial that they wouldn't want to lose, because who knew there would be this many surprises in this retrial? And there have been, I think, some significant moments for the defense. Are they going to have to work with this? Yes, they are. Is that what the court ruled? Yes, they did. But without seeing the reports, I'm very curious as to where the interpretation of those reports lies, because, well, we don't have them. And without having those reports, it's difficult to ascertain how the court is seeing it. So what we can go off of is what the defense said, what the Commonwealth said, and what the court said. And I know that not everyone is going to like what the court said. However, we don't know what's in the reports. We know what's represented to be in the reports. And both the attorneys can get a bit hyperbolic on the representation of things. I'm really curious to see what the cross-examination is and to see how that unfolds. I was hoping for a voir dire just so we would have more understanding, because we don't know. We don't have the reports. And I'm very curious, if there's nothing new, why is there a new report? However, if this is a massive shifting issue, then why did it not come up closer in time to when this report was turned over? So those are the questions I am left with. And I wonder if cross-examination of that witness is going to last at least a day, because, oh boy, oh boy, oh boy. There is going to be a lot to cross-examine that witness on. To wrap up the rest of the day, we ended the day with the crime lab puzzler, Vallier, who pieced together the taillight. This testimony came in, I think, much quicker and much smoother than it did in the first trial. It is still a lot of numbers and trying to correlate bags of evidence, what's inside those bags of evidence, and then how they were puzzled together or manually fit together to construct or reconstruct a taillight. And the expert opinion of that witness is that the items identified in all of that 7 series evidence bags did at one point come from the same item. So those pieces of taillights did come from the same item. What I really would have liked to have seen, and I'm still very curious about, is what items weren't fit together. Because when the witness was testifying about that, hold on, I have notes. Where are the notes? Back to the notes, back to the notes. Even my remarkable is tired today. It's just, it's just done. But when the witness was testifying about different bags of evidence, they talked about the numbers in that bag that fit. And it wasn't always the totality of that evidence bag. So what I'm really curious to see is what pieces fit together and what, if anything, didn't fit back together. I know there were glass pieces that were in those evidence bags, in a number of the 7 series evidence bags, and there were black pieces of plastic. I'm interested to see what was reconstructed, and then like what are the leftovers, or are there any leftovers? That I was curious about. It didn't come up in cross. It didn't come up in direct. I don't think we'll get that question answered. But then as Yannetti went through his cross-examination, Yannetti and the others on the defense team have done a really thorough job of asking the scientific witnesses, who I think the jury will very much like, to ask the scientific witnesses about whether they had control over the items before they got to the lab. Now, of course they didn't, but it highlights for the jury that, well, garbage in, garbage out, right? You don't know what happened to the clothing, the taillight, or anything else before it got to you. All you can evaluate is the evidence as it is when you received it. And your protocols are followed and your chain of custody is followed, but you have no idea what happened before that. And highlighting for the jury who had access to all of these things. Well, shocker, it was Trooper Proctor. And the defense has consistently in cross-examination brought up Trooper Proctor's name to the point that I wonder if when the defense asks a witness, can you tell me which trooper brought this to the crime lab? That the jury in their head is going, oh, I bet it was Trooper Proctor. I can't imagine that they're not at this point filling in the blanks for themselves. And that is a problem that the Commonwealth is going to have to address, because the defense is moving fully ahead with their Bowden defense that this investigation did not follow investigative leads and was not well done. And I think they've highlighted that. It makes the case cleaner for the jury than, I think, running down all of the avenues of what did Higgins do? What did Albert do? What did this person do? What did that person do? I think it's much cleaner to leave those questions for the defense. The defense asked the DNA expert today. There were all these unknown samples. Were they tested for Brian Albert or against Brian Albert? No. Were they tested for Brian Higgins against Brian Higgins? No. The DNA analyst responded over and over and over again. Those other samples could be anyone. Don't know. Could be anyone. And it leaves those questions unanswered, which is a problem for the prosecution and goes to the Bowden defense for the defense. So they didn't follow this investigative lead. They didn't follow that investigative lead. They didn't test the DNA on the taillight. They didn't test those unknowns against these other individuals. So was it really a thorough investigation? It's a fair question. And I think the difference that we're seeing between this trial and the first trial is, one, the questioning on both sides is just cleaner. And I think that's because the direct examinations are so much cleaner. It is easy to see what the witness testifies to affirmatively and then what they testify to in cross-examination. So it just is easier to follow. But the defense also isn't running after all of the third-party defense witnesses as much, so there aren't as many side quests. My concern when there are too many side quests is it shifts the jury's focus away from what did this investigation to, and shifts their focus to, oh, well, what did Jeb McCabe do? Oh, well, what did Brian Albert do? Oh, well, what did this person do? And then they're looking towards the defense to prove to them and to close those loops. It's not the defense's job to close loops. It's their job to make sure that the prosecution doesn't close the loops. That's their job. It's the prosecution's job to close the loops. And I think in the way the defense approached it in the first trial, it left some loops open for the jury. And pointing everything back to the investigation continues to point back to what the Commonwealth has proved and continues to push that back onto the Commonwealth. What did they prove to you? And the defense's theory of the case is very clear from their opening. No collision. And they have used their cross-examination strategically to push back at no collision. How they will address whether or not there is a time shift here will be very interesting, and we'll have to see it as that evidence comes in with the witnesses, because we know that it's coming in. But I don't doubt that Alessi will fulsomely cross-examine that witness, that this has shifted. because it seems that it is shifted, but the court doesn't see that as new. So at the end of week 3, the defense has kept the pressure on this investigation. The prosecution has finally called the coroner, which I think has also kept the pressure on the investigation. And at the beginning of the day, we learned that the troopers at the autopsy were Trooper Connor Keefe and Trooper Watson. If you're going to leave a comment saying, Emily, WTF is Watson? I don't know. I think this is the first time we've heard Watson's name. And my question is Watson part of the CPAC unit? Because Yannetti very clearly asked Trooper Keefe in his cross-examination, was anyone else from your unit at the autopsy? And to that, he said no. So, was Trooper Watson part of the unit, CPAC at the Norfolk DA's office, or was Watson from a different unit, which is possible. But now I don't think we're ever going to get an answer. But did I think that picture looked like Proctor? Yeah, I sure did. Sure did. Is this why I say we have to wait because the lawyers will give us the information? Yes. Did I break my own rule? 100%. Why? Because it's so freaking weird. The evidence has come in weird. And apparently Watson was the other trooper at the autopsy. And how do we know that that's a verifiable fact? Because it was stipulated to by the parties. The defense and the prosecution stipulation means it is a fact that is not in dispute. And yes, I know the photo was titled Keefe or Connor and Proctor at what seemed to be autopsy. The defense put those labels on their photos in their system. I'm actually pretty surprised the prosecution hasn't objected to those, because the defense has labeled their photos all kinds of things that the jury has seen, and the prosecution could object and the court could force them to redact it, because are the file label names argumentative? Yes. Has the prosecution objected to it? No. Could they? Yes. And the court could force them to redact it, and they haven't. So do I rely on the file names placed there by the defense? No, they're argumentative. Of course the defense is going to label them the thing they want you to think. That's what they do. And the Commonwealth hasn't caught it. I don't love it. It should be photo 1127 or whatever, but it's not. So I don't put I don't put facts onto the file names, because I know that they are naming their files themselves. So with all of that, it has been a very interesting day for day 17 at the end of week 3 of evidence in the retrial of Karen Read. The Commonwealth said they thought they had about 23 days at most of their case in chief. So we're getting to the end of the case in chief for the Commonwealth. Who are they going to call? And I was very surprised that we did not hear today from the neuropathologist, Dr. Stonebridge. Maybe we will get into those medical experts next week. I think it was a good use of Friday for the Commonwealth to stick the scientific evidence on Friday. Just like plop it on Friday. It was a full day of Lally doing the questioning, whole different lawyer than last trial, Lally is. And it's information that's foundational and important, but it's also information that the jury is going to remember part of and will come up with other witnesses. So laying that foundation all day on a Friday makes a lot of sense to me, because the jury's probably fatigued. And we didn't even get to talk about the judge much, telling the jurors to mind the subtitles on their faces, my words, not hers, at the beginning of the day. What a busy week this has been. Lawnards, you have questions. I know you have questions. That's the end of day 17, but we're going to answer your questions. For those of you that are trying to catch up on the case, remember, I put that out on case briefs. Well, me and Team Baker, who have been working overtime to get this case done, and to get the case briefs out to you in the morning the next day. Those case briefs are up on the Emily Show YouTube channel. If you want to go subscribe over there, feel free. And if you want to listen on your favorite podcasting app and put it on the background, feel free. Those are summaries of the court days put together by me and Team Baker. And our editor, Jordan, has been working overtime. Producer Miguelina and the mods have just been working overtime. All of Team Baker has, because we're working on merch. And they've just done an incredible job. So thank you for all the love that you've been leaving on the case briefs, for everyone that said that they've been helpful, and for everyone who has said that they have not been able to watch this case day in and day out because it is way too stressful. And keeping up with this case on the case briefs has been 10 out of 10 for them. Thank you. And yes, we are working on some new things in the background, which caused glitches this week for the channel. So I've had like all of the stress and anxiety this week over all of the things. Just, oh my goodness, it's been a week. But we sorted it and it's fine now. And I am trying so hard not to ADHD side quest into a new project while still in the middle of this trial. I've gotten a lot of questions like, Emily, why aren't you keeping us up to date on, not from y'all in the chat, because y'all are all in on this, but what about this case? What about this case? What about this case? I'm like, y'all, I can't check out now. I have to stay mentally checked into this case, because if I check out, I'm going to go on a full side quest doing other things. Like, I don't know, a full side quest. So I'm trying so hard to stay focused and not be like following the dopamine all over to other new projects. But on Monday, there will be a new podcast episode. My intention was to record that early on Saturday. I think with the weather we have coming in, that's probably a solid plan just in case we lose power. But I'll be finishing prepping the podcast today and recording that earlier on Saturday, so I'll let you know. And then I'm going to look at the calendar with us having some breaks in court next week. We will have a members only live next week, probably Thursday. I just need to take a look. But on the podcast this week on Monday, I anticipate giving summaries of week 1 of the Diddy trial. What is going on in Idaho? We will cover that hearing in full another time, but we will cover that Idaho hearing in full. It's just going to be delayed until this is done. And then, of course, you guys, it's been so hard this week not to talk about courthouse, jailhouse Becky. Don't worry. It's going to be in the podcast on Monday. Members, you will get the notification to come and record with me behind the scenes. For all of you that are like, who the fuck is Courthouse Becky? She's the clerk from the Murdaugh trial. We got a lot to talk about. I haven't forgotten. Oh, I'm aware. But I can't side quest, because if I side quest, I will never be on time on stream. So for all of you who are like, what the fuck with Courthouse Becky? Just the tip. Arrested, go watch the video. We'll link it down below. Watch the video where I talk about the ethics violations, because the ethics violations are underlying the criminal charges against the clerk in the Murdaugh case. Oh boy. So we're going to talk about that more in the podcast, but the ethics breakdown will get you there. And for those of you that are like, Emily, Cassie was testifying in the Diddy case. Yes, I have a breakdown of Cassie's civil lawsuit. A lot of what Cassie testified to, we already knew because of how thorough her civil lawsuit was. So we can link that down below if you want a foundation on those, because that is what happened really this week in Diddy. Opening statements, the defense argued what we thought they were going to, and then Cassie Ventura testified. I think one of the big new things for me was how much that settlement was with Diddy, which was about $20 million. That was new information, but we'll do that in the podcast Monday. And we'll talk about Idaho Monday. Don't worry. So much is happening. Psychedelic Manic, it is my goal to get into Menendez Brothers updates if I can get caught up. If not, it'll have to be next week, but that's my goal. Miguelina said 30 million. See, this is why we prep. It's a lot. Let's get to some questions. You've got questions. I've got questions. We're going to have a lot of a chat on Monday for the podcast. Oh, buddy, it's busy. Me sitting here in my brain going like, oh, bitch, it's so much. And it's the end of school. And I've got to finish getting Travis packed to leave for DCI, because never did I ever suspect that my 17-year-old would just be gone for the entire summer at 17. I was just like, well, no, we have one more summer before he graduates from high school. Wrong, Emily. You do not. Am I emotional about it? Yeah. But that's okay. I'm going to miss him. He sends the best memes. He sends the best beams. So it's very busy at the Baker House at the end of the year. Settlement was 20 million, not 30. Miguelina chat disputes. For those of you asking about DCI, Travis is in the color guard. He has definitely taken himself out with his rifle a couple times, but color guard rifles, they're big. I realize I have to describe this when I talk on stream. They're big wooden rifles. They're big wooden planks, essentially. They're finished wood. They're not unfinished wood. They're finished wood, but he is in the color guard. So he is just incredible. I can't wait to watch him go spin with his guard all summer. So, Stacy Rose, he is in DCI. He has joined, for all of you that know DCI. Well, I can't even, he was in his gear on stream the other day. So it's not shocking which guard he picked, but he is with Cavaliers. So I normally just said the ones with the fun hats, and then everybody who knows DCI is like, the one with the fun hats. But he was in here in his Cavs gear. So yes, Cavaliers. So that's who he's with. No, not the basketball team. DCI shit. Don't worry about it. Let's get to questions because y'all have questions. I have questions. Are you all exhausted? I'm exhausted. But I had friends. I was a band kid in high school too. I had friends in Boston Crusaders, Knights of Bergen County when they existed, Santa Clara Vanguard. And Mandarins. I don't want to leave anybody out. Is there anybody else? There might have been. It's been a long time. Doug said Cavs are serious. Yep. And he loves it. They have he's just loving it. He loves the workout regimen. He loves all of it. He's 17. He's just 17. He's like, I am ready to run and be in pain and throw things and have the best time. Do I want to sleep on a high school gym floor all the time? No. Was I offended when I played Division I water polo and they slept us 4++ to a hotel room when we traveled for games? Yes. Emily, have you always been that bougie? Yes. Yes, I have. They're like, well, there's a pull-out couch. I'm like, really? Yes. I've always been this way. Which shouldn't be a surprise for anyone. And Laura True, yes, to your question in the chat. I matched Jersey Surf. Congratulations to T and congratulations to you. Did I run the bumper for questions? No. The FBI! I mean, today I feel like just hitting the entire soundboard.
Survey says!
That's where I'm at today. I just you know that scene in Ferris Bueller's Day Off when it's just bleh on the keyboard? That's how I'm feeling today. Jojo asked, EDB, did they use the same strategy in the first trial? The defense strategy in the first trial is very different. It'll be interesting if anyone goes back after this trial and watches the opening. But the first trial was very much, the first sentence of the defense opening in the first trial was, Karen Read was framed. My criticism of that is that it pulls the jury into wanting the defense to show them how she was framed. And it almost invites that shift of attention. Just like when Dick Harpootlian stood up in the Murdaugh case and said, and we're going to show you that Alec Murdaugh didn't do this. Why pull a burden onto yourself that you don't need? I appreciate the defense is going to show the Commonwealth didn't show you this. They didn't answer your questions. They didn't show you all their witnesses. It pushes it all back on the Commonwealth with their burden of proof. They didn't show you this witness. They didn't show you that witness. They didn't show you how John O'Keefe was hit. They just push it all back on them instead of saying, we're going to show you how this, how Karen Read was framed. So it's a different strategy. And I think keeping it simpler is easier. And I think the defense this trial has been very mindful of count 2. We'll talk more about count 2 as the case continues. Let's see. Tracy said, EDB, is it still grounds for appeal if they didn't ask for a mistrial? Yes, because they asked for different curable instructions. If Karen Read is convicted of anything, then yes, this will 100% come up in an appeal. based on what the report says, it's going to vary how much of an issue I think that is, because we have two very different representations of what the report says. And I want to see what the report says for myself. That's really what I want to see. I don't think I'm going to get to. So we will see. Daniel said, doesn't the new time make it less likely that Karen Read would have had time to get back to have her car connect to the home Wi-Fi 4 minutes later? It is also a fair point. I think the defense will have a very good argument that the Commonwealth doesn't really know what time this happened. They can't show what time this happened. And there's all this going on John O'Keefe's phone, and then there's all this going on over here, and they can't show it. I think the defense is also going to argue through their experts that John O'Keefe wasn't outside as long as they say that he was, because they asked about how fast the body cools of the coroner. I think we're going to see more made of that. And I think we're going to see the defense argue, well, look, if John O'Keefe was outside this whole time, the coroner told you how fast body temperature would drop, depending on the difference between the human body temperature at 98 degrees and the outside temperature. And now the Commonwealth has put in the outside temperature. And the coroner testified that the temperature your body is will drop faster the bigger the difference is between the outside temperature and the 98 degrees. So if that drops faster, then how is he 80 degrees when he gets to the hospital? Why isn't it lower? And I think we will see that information. So yes, I think the defense will work with it. And I want to see what the expert says, because I'm curious if this really is, hey, in this underlying timeline, I said there was a 21 to 29 second variance. And it might just be that the defense turns around and goes, how can you find anything beyond a reasonable doubt with a 29 second variance? Because the Commonwealth doesn't know when and how John O'Keefe was hit by the car. I'm waiting to hear more about John O'Keefe's clothing. We still haven't figured out what was going on his pants. A couple of you asked, did I do the bumper? No, I just started hitting the soundboard. I didn't do I just started hitting the soundboard because that's all I got today. That's just do it. That's it. That's where we're at. Joe said, I need a map of the incident. Need to see a picture. I wonder if we will see that with the accident reconstructionists. Again, I don't know how much the Commonwealth saying, hey, 12/31/38 to 12/31/43 to 12/32/16, is that going to override for the jury the coroner's testimony? Because I think some of the most damning testimony in this case so far for the defense, well, damning testimony negative to the Commonwealth, positive for the defense, is the coroner saying, yeah, I knew everything in your case in chief, and I still found that it was undetermined. Because if the jury liked the coroner, and I don't know why they wouldn't, I liked the coroner. If the jury liked the coroner, notice the defense didn't go after had the coroner been influenced. The coroner said, nobody came to me and tried to make me change my mind after the fact, and I knew all of that. I knew all the things that you're telling me. I didn't know about her media interviews. Okay. But I still didn't change my mind. And if the jury likes the coroner, they're going to be like, well, if the coroner couldn't find what happened, how do we find what happened? I think it's a real strong argument because it brings in a neutral prosecution witness who's not tied to Proctor and all the fuckery. And there's nothing that Proctor could have influenced, even if he tried, with that coroner. Is Dr. Scorty Bello being influenced by anyone? No. Dr. Scorty Bello is a badass. And it's just like, yeah, I knew all of that. And my findings are my findings. And they still didn't change my mind that this was a homicide. That's pretty strong argument for the defense. And the Commonwealth's strongest argument seems to be, see, Karen Read said things. Some of Karen Read's interviews are bad for her, but I don't know if it overcomes the coroner testimony. Because if a jury's looking at Karen Read's words versus the coroner, I don't know if it matters if Karen Read said that she picked some glass out of his face. I think it undermines the defense argument that there was a fight. But not being a fight doesn't mean that the Commonwealth has proved that Karen Read hit John O'Keefe with a car. So both things can be true, that there's not a fight and that Karen Read didn't hit him with the car, or alternatively, that the Commonwealth didn't prove that Karen Read hit him with the car. Because, well, that's the way the evidence is coming in. And even though it's coming in cleaner, it makes it easier to see where the issues are. And Tammy Morgan in the chat said, to me, the glass in the face promotes a fight. And it might be. It might well be. Though, if somebody got hit in the face with a glass, it would definitely be different injuries. The injuries, as we've heard them described, are small pieces of glass. But could the glass have broken and shattered back? Yeah, it could. Absolutely. But am I going to speculate on that much more? No. But if somebody was smashed in the face with a glass, the injuries would be much different. But it could be connected to the... Absolutely. The problem is for the Commonwealth, if we're all sitting here going, could it be this, 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 then those are a lot of questions. For those of you that watched the Sarah Boone case together with me or at all, did you sit there during the Commonwealth state's case and say, oh, it could have been this, it could have been this, it could have been this? No. You're watching the Sarah Boone case being like, ma'am, really? That's the difference. When you look at some of the cases that you've watched, and then this case, you can see the difference in the questions you have while the prosecution's presenting their case. When the prosecution was presenting their case in the Shabusiness trial, and we didn't watch that together on stream because the facts of that case are horrific, there wasn't a question of who did it and what they did. The question was, will the insanity defense fly with the jury or not? That was the only question in that case. The question in the Brooks case was not, did he do it and what did he do? The question in the Brooks case was, what's he going to do representing himself? So you can see the difference when you look at different trials based on the strength of the evidence. When you find yourself 3 weeks into evidence in the Commonwealth's case going, okay, but how did this happen? It's not good for the Commonwealth, right? It's all of you are saying the Rust, or a number of you are saying the Rust case. I can't say all because there's over 30,000 people in here, but a number of you are saying the Rust case, right? The question in the Rust case wasn't, did a shooting happen? The question in the Rust case was, is somebody responsible and who on set is responsible and how did a live round get onto set? Not did it happen? So you can see the difference in the different cases. Let's answer some more questions, shall we? Let's see. This case just has a lot of questions. A lot of questions. Just too many. I saw a lot of you talking about drum corps. Thank you. I know my kid has written a whole corps show to the Black Parade album. he's got a whole show outline of MCR. He's like, it's a rock opera and you can do, and I'm like, buddy, I hear you. You just have to become a director and then you can write your own shows. And if you want to do an entire Black Parade show with a marching band, I'm here for you. It sounds like a great idea. You're going to have some millennials that are corps directors that are in. I get it. Just hold your time. He's just like, it'll happen, buddy. It'll happen. Colleen, thank you for the gifted memberships. I know September is going to be hard because we are going to go see MCR together. And I'm very excited, but it's going to conflict a little bit with Idaho. Idaho's going to be, It's going to be busy. There's going to be a couple days in there that are going to get squishy, but it's going to be fine. It's going to be fine. Christy asked, were they released from their sequestration order? I don't think they were released from the sequestration order, but my supposition on the sequestration order is that there wasn't a violation of the sequestration order because that report by Whiffen was done quite a while ago, and the Commonwealth's allowed to provide their reports to other experts who might rely on those reports. The problem for me will be if that expert says, I was not provided Whiffen's reports and I did not review them. Then I have a problem. But if that expert had Whiffen's reports, hold on, let me pull this up real quick. Whiffen's reports had all of those charts. I think that the expert for the Commonwealth had Whiffen's reports and reviewed it. Now, why did he need to update them? That's a good question, because Whiffen's chart was real clear on what the phone was doing. It was incredibly clear. Let's see. Sparky Blue said, am I misunderstanding, or is the expert admitting to changing his report to make it fit the Commonwealth theory? How is that appropriate? Thank you for your streams. That is what the defense is alleging. The Commonwealth has said that the defense has fundamentally misunderstood, and that is not what's happening, and the court agreed with the Commonwealth. We haven't seen the report yet. I am waiting to see it, but why is there a new report then if nothing needed to shift? The Commonwealth said, no, our expert is clarifying what the defense expert said about the time differentiation, which was a known issue. That was 100% a known issue. But the defense said, no, the Commonwealth locked in that time issue in earlier reports. And the Commonwealth said, yes, we did, and that hasn't changed. It's the time variance that changed. Are we splitting hairs, or are both sides just pushing too far from the middle? I don't know. But that's what the defense is alleging. The court did not agree. Let's see. Donnie B said, how is it both parties sometimes disagree on when items were sent and received? Isn't it an easy thing to prove? Do their clocks keep different times? The Commonwealth says they provided it on the 8th. The defense says they got it on the 11th. I don't know when the email was sent. I think that could be easily proven. Don't know how much it matters. Did the defense see it before the 11th or not see it before the 11th? Did it not get sent? Did it get lost in, I don't know, the email system? I have no idea. But it could be sent on the 8th and not received till the 11th if the defense didn't see it. I don't know. We will have to see. But are there times where the Commonwealth has not turned things over to the defense in this case? Yeah, there is. But are we just getting into a huge battle of experts? Yeah, we are. But could it be proven? Yeah, it could. But did the defense bring that in and fight with it? No, they didn't. Alessi Never Sleep says it was dated 5/8. They sent it 5/11. The Commonwealth says they sent it 5/8 though. The defense says they got it 5/11. If the Commonwealth said they sent it 5/11, we wouldn't be arguing over it. But the Commonwealth and the defense don't see eye to eye on this. They have seen eye to eye on some things, not this, and they're not going to. So, Charles Vance, thank you for the 10 gifted memberships. Robin said, I'm in South Carolina floating in a pool with the EDB. Bruh. Yeah, it's today, all today. Lots of bruh. Lots of bruh. But again, I think at the end of today, one of the big issues that the defense has done a really good job of pushing is Proctor. Every single time they ask a question, the answer is Proctor. Who did this? Proctor. Who did that? Proctor. The jury has to be sitting there going, when are we going to hear from Proctor? And I think it might be a huge error for the Commonwealth not to call Proctor, but it seems like they're not going to. It seems that they're not going to. Harmony says, not sure how I'm 45 today since I'm 12, but happy birthday to me. Harmony, I'm with you. We are all just, repeatedly turning like 22 over and over again. It's fine. It's fine. Thank you, Jojo, for the very kind super chat. Team Baker has done so much work. It's just been very busy. Very busy. Joe D said, cars on reverse have one gear. How fast can you go? The Commonwealth says 24 miles an hour, but we haven't gotten there yet. So that's what they will say. I found the testimony about Karen Read's SUV, the last trial, incredibly confusing. I don't know what we will see this time, but they say 24. It's going to be interesting to see. Liz said the times don't need to add up for Karen Read's team. Anyone in the house could have removed phone from pocket and shown his face to the camera. How do they bring that in, though? They can argue it. So late as 29 seconds a lot. It is in this case, but they can argue it. And they can also argue that the Commonwealth is trying to make fetch happen. They're giving you all these times, but nothing indicates on John O'Keefe that there was a collision. So I think the other thing, and the reason they were really hammering Jen McCabe about that 12:45 timeline is because no matter what way you slice it with the Commonwealth, 12:45 and her saying she saw the SUV around 12:45 when she sent that text, and the text timestamps seem to be agreed on by all sides. So when she sent that 12:45 text asking something in the neighborhood of where are you or are you here or what have you, I need to go back and look at the exact language of it, but sending that text at 12:45, if the car was gone, then why are you sending that text? And if the car is there, then why aren't you seeing John O'Keefe? And if the car is gone, then why aren't you seeing John O'Keefe? Because there's the lawn isn't covered in snow. And so the jury got to go on a jury view to see how far the distance is from the house on the lawn. How dark is it over by the flagpole and the fire hydrant? It's going to be hard for the jury to assess that because they were there during the day. I imagine that's going to be the argument, but how do you not see someone on the lawn? It seems from the jury view that the lawn is not as big in person as it may appear in pictures. And so the jury's going to have that question because they brought in all of that evidence showing that there was a cat track of snow, my favorite phrase ever, a cat track of snow at that time. So it's not as if the snow would be making it apparent that there wasn't somebody there. So if you're looking out at the car, how do you not see John O'Keefe? And if that question's not answered, then doesn't that leave a lot of questions for the jury? Let's see. I saw a question in the chat. Oh, Shaylee Chapman said, I think it was just hello question mark. It might have been that last one, a hello question mark. And there was, Jen McCabe said that she wasn't sure if the car was still there or not. But I think and I don't remember if it is the hello or not, but I trust chat. If it's hello, it might make sense that the car's gone. And the Commonwealth might argue that the car's gone and he didn't come in. And so she's texting like, hello? Wouldn't everything have been much more clear if she had just texted, where did you go? So, isn't it all just kind of a mess? Yes. Yes, it is. But a mess is good for the defense and bad for the prosecution. Because if the jury, how do you convict someone if you feel like everything's a mess and you don't have answers? I don't know if most jurors would feel good about that. But last trial, numerous jurors were at the manslaughter, like there was involvement. Karen was a factor in his death, and that is count 2. Could the jury find that there was no intentional anything and say, look, we think that she clipped him with the car? I don't know how the accident reconstructionist is going to come in. So we're going to have to wait and see. But is that different than a full vehicle collision? Yes. But then how did he end up where he ended up on the lawn? I don't know. Someone's going to have to answer it. I don't know who is going to answer it. But when there's that many questions, Truly Laws, thank you so much for the gifted memberships. When there's that many questions, it is hard for jurors to acquit or to convict. That's not what I'm saying. Because there's too many unanswered questions and they have to find those questions answered. Mercury Stars asked if I've ever fallen over in court. Yes, It was mortifying. It happened once. My heel, very tall, spiky heel, got caught in the cuff of my pants, and I toppled over in court. I have told that story more fulsomely on a members only live stream. I landed on a defendant who was terrified of me falling in his general direction. The bailiffs were livid with me, and the defendant who was in court waiting for their trial was terrified and was like, pushed me back up. It was like, are you okay? I'm glad they were uncuffed. Otherwise, I don't know what I would have done. I was mortified. The bailiff was so fucking angry. Just so fucking mad. The bailiff is like, oh my God. Oh my God. What are you doing? And I'm like, my heel caught my pants. I was in court to drop something off with the clerk before trial started. It was not my trial, not my defendant. So yeah, just poor defendant who was there for like 7 or 8 pretty violent armed robberies and was just like, ma'am, don't cause me problems. The bailiff was just like, oh my God. Oh my God. I felt terrible. They felt terrible. Everyone was fine at the end of the day, but I was mortified. Why was the bailiff mad? Because I created a safety issue that could have been a much more substantial safety issue. I created a safety issue. And so the bailiff was, you know how sometimes when you're scared, you get pissed? That I created a problem, or my heels did. So that defendant. Liz Bird said the defendant that ran, totally different case. The defendant that ran was in juvenile. And no one had to worry about me running after anyone in court. I'm sitting my ass down. I know my job. My job is not to go running after people. Other people got in trouble. I didn't. Yeah, I was the danger in that situation, and the bailiff was. They have a hard enough job. Me being clumsy doesn't help. It was a full wardrobe malfunction. Jolie said, why would the bailiff be angry? Because I created a problem. And again, that level of like instant stress, the response does not surprise me that it's anger, because literally I'm the problem. It's me. I was the drama in that moment. The defendant was very sweet and also mortified. But I was also mortified. So no one yelled. That time no one yelled. I did yell when I almost broke a nail opening my 3-ring binder, but no one was harmed in the Emily falling in court. And it was in the courtroom of the judge that hated me. So I was rushing into court to get out before the judge was out on the bench. Like I was really trying to like sneak in and drop stuff off to the clerk and like get the fuck out before my colleague came in for trial. So I was moving quick. Shockingly, this will shock you. The circumstance probably also involved me running late. So I was just like, oh. Did I ever wear those pants again? 100% not. 100%. That I went through my closet and took out every single pair of pants with a cuff and yeeted them. I thought they were so cute. They hung right over the big spiky heels, but no. That was earlier on in the career. Later on in the career, there were no spiky heels. And then after the spinal surgery, there were no more heels, period. I've told stories about that judge before. That judge and I did not get along. We did not get along. She called all of my bosses for a meeting after a trial in her courtroom. Emily, did you get in trouble with this judge about your face? No, it was a different judge that I got in trouble with because of my face. This judge called all of my bosses, and like Office Space, there's like 17 bosses, but called all of my bosses that were on site into a meeting because in closing argument, I told the jury that the jury instructions in the area of law we were talking about were really complicated, but they're written by the legislature and we can only do what we can do. And the jury instructions are complicated, and so it is my job to explain them. So we're going to talk about them, but yes, they aren't well written, and yes, it's frustrating. And the level of angry she was that I was disparaging the elected officials of the great state of California was a fucking a million out of 10. A million out of 10. So mad. So mad. So mad that I, a representative of the county, was disparaging the elected officials. The horror. It was like, I mean, go off, I guess. These jury instructions on this particular case are kind of a piece of shit, but okay. I think she was mad because the jury liked me. That was a courtroom where I did jury selection based on people she yelled at during jury selection. Emily, how did you pick a jury in this courtroom? Well, if she was an asshole to a juror, they stayed on the jury. Because invariably she would yell at me during trial. And so I kept a jury full of people she'd also yelled at. And we all just kind of were in it together. I'm like, she's going to yell at me during this trial? Yep. And she yelled at all these jurors during jury selection? Yep. Perfect. That's my jury. Stay with me. Stay with me, everybody. This judge. Oh, yeah. But there's different ways to pick a jury. It's very rare that you have like a common enemy strategy because generally judges don't yell at jurors during voir dire, but this one sure did. This one sure did. That court was a trip, but there was a defense attorney. This judge hated me, but the judge was just screaming at me about something. And the defense attorney was like, actually, Your Honor, that's not how that happened. And the judge told him to stop talking. The defense attorney was like, I would just like to make a record that that's not how this went down. And the judge was like, you need to stop talking. I was like, we're just going to stand here. I mean, I knew she was unlikely to shoot me. So I was sitting there going, well, she probably can't actually shoot me. So it's going to be fine. Look, man, trial's dynamic. Judges are dynamic. Workplaces are dynamic. I mean, I definitely wasn't the only attorney she yelled at, but yeah. Oh, but I was pretty confident that she couldn't actually kill me. So I'm like, all right, so I get yelled at. Fine. Again, playing water polo definitely helps with the way that you categorize things in life. Being an attorney in court is not for the faint of heart, like not at all. So it just is. Is there much you can do? No. It was Emily Ippolito said the epitome of, but did you die though? Yes. Yes. Oh, there were other DAs that this judge hated. 100%. And then there were DAs that she loved. So I was like, can you just have the attorneys that she likes work in her courtroom? But again, the bosses were like, no, we can't just reward her for bad behavior and just give her the attorneys she likes. I'm like, it would just make everyone's life easier. Can you spare me? Nope. It's kind of like the lawyer version of hazing is what it felt like. Colleen, thank you for the gift of memberships. Emily, you seem to take a more balanced view on the judge versus some former current defense attorneys. Do you feel she's been fair and unbiased in your view? There are things I disagree with this judge on. There are things I agree with this judge on. With every judge, there are things I disagree on and things I agree on. There are calls that the judge has made that I very much don't like. There are calls that the judge has made that I very much agree with. There are also things that I don't know. And so when it is a call I disagree with and I don't have enough information, I am going to wait until I have more information. When there's a call that I disagree with and I feel like we have all the motion filings and we've seen everything, I'll let you know when I disagree. I think there are things this judge really doesn't like that this defense team has done. I don't know how this judge is with other defense teams. So it's hard for me to know if this is her general temperament or if it is particularly this defense team. But there are definitely things that the defense team has done that have ruffled the feathers of this judge. And I get it, because there are some things, especially when it got to the ARCA stuff in this trial, that pissed off the judge and should not have happened. And there are those that are going to forgive the defense everything that they do. And I think there are probably those who are going to forgive the prosecution for everything they do. There have been things on both sides in this case, and I'm like, what are you doing? And those things tend to piss off a judge, especially when it came to the ARCA communications. We saw how mad that made the judge. Now, do I think that the judge should have been equally mad about videos getting turned over from the prosecution? Yes. But do I understand how the judge sees that differently? Yes. Because the ARCA situation had to do with the court's direct orders, and the video situation has to do with discovery. The court will view them differently. The internet won't, but the court will view them differently. Are there times she tells the defense to move on? Yes. Is it more than she tells the prosecution to move on? Yes. But does she sustain quite a lot of objections for both sides? Yes. Are there objections that I agree with on both sides? Yes. Are there objection rulings I disagree with on both sides? Yes. So I need to know more about this judge, because there are times that the prosecution is right and she still rules against them. And I think the judge does that to protect this case on appeal. She could have kept out all the ARCA stuff. I'm glad she didn't. She could have. Some judges would have. And the prosecution was pissed. Does it make it harder for them? Yeah. Is that also part of the job of being a prosecutor? Yeah. I mean, is it fair? No. But is it fair the prosecution was turning over videos in the middle of the last trial? No. So in some of those rulings, I think the rulings break in favor of the defense when they are big for the defense. I disagree strongly with the court keeping out a law enforcement expert. Like, I disagree strongly on that. But we'll need to see. So I have not observed this judge in other trials. I also think having a mic right up under the judge's mouth probably doesn't help the opinion of the court, because you can hear, though I will say the sighing has definitely reduced in this case. Like, I have not heard as much of the judge. I haven't heard as much of that. All right, I'm going to answer a few more questions since it's a half day, and then I'm going to get going, because then Team Baker can get done earlier today, and I want to make sure they can get done earlier. Wise Gal 81 asks, can you explain the Aperture Alessi mentioned? That is the accident reconstruction firm for the prosecution that is new for this case. I appreciate theories of the case, Christy. This is going to come in with ARCA, I think. So we will see. Susie said, I'm extremely ADHD. I appreciate that we are not on real time, especially since I'm working and I can stop and listen as I need to. I appreciate it too. There are some times it is hard when big things happen in court when we're behind time, but it can be distracting to me, which makes it hard for me to focus on the testimony, which is literally all the rules on this channel are to help me stay focused on what we're doing and not side quest. Because sometimes the brain wants to follow the dopamine and you can't wrangle it back. It's not a lack of attention. It's just, I can't always direct the attention where I want it to go. Sometimes the attention just wants to focus on feeding my Snorlax. Deborah said, EDB, if anything has changed, then why? If nothing has changed, then why an amended report? This makes no sense. It's a very fair point. The prosecution says it is in response to the defense. Like, the defense said this, we looked at this, and now we're giving you a report on that. But I agree. Sweet Pea said, when you take notes, are you using shorthand? How do you keep up? I am not using shorthand. I have very sloppy writing and it helps keep me engaged. I can also write and listen and read the chat generally all at the same time. So it is not verbatim notes, but it is not technical shorthand. It is my bullet points of things I want to remember. Sometimes it's just impressions of how I feel the cross is going, how I feel the direct is going, and what I think are good points. Sometimes it's keeping in order what they're saying in evidence, like the different evidence numbers and things like that. Shane said, I'd be happy to refresh you on how to do the time warp. Your steps and jumps are reversed. I might have. Would that shock me? I don't know. Are we a step to the left and a jump to the right, or a step to the right and a jump to the... I don't know. Laura asked, is writing on the Remarkable much different for a paper pad? For me, it's easier because it has a little bit of slip, not as much as like an iPad, but it has a little bit of slip, so it's faster for me to write than on paper, just because it moves across easier, and I can circle things and move them down the page, so it's easier for me to move the notes around if I need to move something. I love it. Do I wish they were a sponsor on the channel? Yes. Have we reached out to ask? Multiple times. Also, I went through a stack of notepads in, I think it was Depp Heard that I went through so many. And then by the time I got to Murdaugh, I'm like, I have to do something different because it was so many notepads. The only thing that's harder for me in the moment is flipping back and forth. I am not as good at that yet, but I like being able to pull up the Remarkable screen on the computer so I can flip back and forth in my notes on the computer while I'm still writing on the Remarkable. So, yeah, that. For those of you asking what is a Remarkable, it's the digital, it's just a e-writer notebook or e-writer. And it has a screen more like a Kindle. And so it doesn't have a backlight on this one. I find myself using the Remarkable 2 the most just because the weight of it works really well. Yeah. So it has a screen more like a Kindle, so it's easy on the eyes. It's great. I wish I had a code for you guys. I will link it on Amazon below this video. I really like it for all of those reasons. And because you can sync it, it does annoy me that you have to pay to sync them on the computer though. But I like an e-writer and it's easy. So it's easy. You can also convert things to text if you need to. So it just depends. Loretta said, been MIA the last 2 days taking process server certification. I just passed my test. Loretta, congratulations. Stay safe and enjoy working with lawyers. Just here's the thing to remember about working with lawyers. It's not you, it's them. Their emergency is not your emergency. They will try to make it your emergency. Everything is last minute because they have too much going on and they are often hungry. I wouldn't advise just throwing snacks directly at them, but a lot of lawyers are overtired, dehydrated, and hungry, and they can be just fucking grumpy. Find lawyers that you like working with, because some lawyers are great. Some lawyers are not. Some lawyers, it depends. But they're often hungry. Oh my God, we had a judge that would do keto like twice a year and just hate life. And I'm like, you would come into court, I would see the clerk and the court reporter. I'm like, is he on keto again? They're like, uh-huh. I'm like, fuck. No, so sometimes the judges are too. Sometimes the judges are also hungry and irritable. I was like, can we not? Can we just not? Nope. All the time. I'm like, that judge is so mad. Let's see. What else? Carla said, so what are we learning, that the clothes are John O'Keefe's? Yes. And the defense is going to argue that the unknowns weren't tested, and shouldn't they have tested? And the Commonwealth is going to argue the unknowns are unknown. So, Neurotic said earlier in the chat, I've been on a murder trial, I'm assuming as a juror. The hardest thing was keeping track of all the testimony after the fact. We were able to keep notes, but you don't always know what is important. I completely agree with you, because when the jury doesn't know what's happening or what happened, and they learn what happened, they might be like, shit, I wish I had paid more attention to this. And it's really hard to keep things in order because you just don't know. And that is a difficult thing. It's why there's 12. I get it. Let's see. Jocelyn said, do you think the defense tried to talk her out of the docuseries? Why would someone do it before trial? We know from the articles regarding the Discovery ID docuseries that it was the defense that reached out to the production company that did that. So the defense affirmatively did this. Why would they do it before trial? They didn't think it was before trial. When the defense started doing the docuseries, this is purely my speculation. I wonder if they wanted to document the road to victory, if you will. I wonder if they were so confident in their case that they saw this case as no jury can convict her on these things. Of course, they're going to see it the way we see it. Between the butt dials and the rehomed phones and the rehomed dogs and the rest of it, of course, that's going to be the result. And I think the defense was very confident in that. And they saw this as a docuseries that would reveal later the moments leading up to their victory in this case. And then when the jury hung, I imagine they were like, well, shit. That didn't go as expected. But by that point, you've already agreed to the docuseries. They already have the rights to the footage. They've already done the footage. And of course, they're going to release it close in time to the trial, because that's when you're going to get all the views. That's when the interest is high. I think they thought that a hung jury was a very, very distant possibility. But they don't see it as a problem. They're like, okay, well, nothing that Karen Read says is going to change what the evidence is. So what's the problem? So that's what I think. But I don't know. I'm sure we'll hear them talk about it when there's no gag order. But the issue of the docuseries is something that we are going to be talking about more and more, because judges, well, we'll talk about Idaho later. Judges are not happy, and I worry that docuseries before trials are going to cause more problems. It is a problem. It is a problem, and docuseries, legacy media puts out this like air of authority, or they try to. Not everybody agrees with that, but they try to come across as the most authoritative in a space, and it continues to cause problems for defendants that are looking for a jury that doesn't know a lot about a case. So this is a high profile case issue. I think covering the documents in court, the court can seal what isn't for the public. Covering documents in a case, if the jury has seen a lot of those documents, it shouldn't be that highly prejudicial because they are documents in court. But when you get to docuseries, doing recreations and presenting things as fact ahead of a case, it's difficult. Lavelle said, what if they do a docuseries without her consent, without Karen Read's consent, then they wouldn't have had interviews with her. Somebody could put together their own take on a thing, but they wouldn't have had her interviews. And they wouldn't start filming her interviews without having those contracts in place, or they shouldn't. I can't say they wouldn't, because production moves quick and TV moves quick, but they would have those contracts in place, and they would have the right to use and edit with some limitations how they want. I don't think if you're going to get involved in something like that as a defendant, you can do that without having like a Final Cut approval. And you would have to have Final Cut approval. I don't know if they asked for that. They would have to, like, full Kardashian with like a producer credit and everything. Michael Pepper Tech, thank you so much. Congrats on 826. Look at us. We're on the road. We're on the road. Michael Pepper Tech's like, I've been here since you were covering tech around 10K. So proud of you. I've learned so much from you. Learned Lawnard, thank you so much. And yeah, we're on our road to 850. 850. Let's go. Speaking of which, no, not you. My devices are like, Emily, are we done? Are we done yet? Just about. Just about. So let's see. Who do I think we will hear from next week? Well, accident reconstructionist, they said either next week or after the holiday. Are we going to have to wait till after Memorial Day? We might. It might be their last witness. If I'm the Commonwealth, I think I'd put them on last. I really do. So who else? Well, all the medical experts, the Commonwealth's dog expert. That might be it. I think the medical experts will take some time, but I don't know if they're going to call any more civilians. And I don't know if they called Trooper Proctor, if they would get to their accident reconstructionist soon. I think Proctor would take 2 or 3 days. The defense is treating it as if Proctor's not going to be called. And I'm wondering if that's the case. I mean, the Commonwealth could still change their mind, but they're acting as if Proctor's not being called, and all that evidence that he handled's already in evidence. I don't think they're going to call Higgins. I don't think they're going to call Alberts. I don't think they're going to call anyone else. I think we're going to just be in the scientific evidence. But I mean, I'm not the Commonwealth. I don't know what they're thinking. So I could very well be wrong on that. But in the order of things that are going, I think it's going to be, they've got a medical expert, like a neurologist. They've got a medical expert about the injuries to John O'Keefe's arm. They have the accident reconstructionist. They have some more of the scientific evidence from the testing. But I don't know who else will call, because we've got a full day of witnesses Monday, Tuesday, Wednesday. And some of those scientific witnesses went pretty quick. I don't know if they're going to call Aruba. And I haven't seen a ruling on that. The court hasn't put it on the record. I haven't seen one on the docket. So I don't know if we're going to get into that. But I didn't see a ruling on the docket as of this morning. It doesn't mean there won't be one by next week. They might call the Aruba witnesses. We'll see. Law nerds, with that, we've been streaming for 5 hours. It was a half day of court today. I'm going to take advantage of the half day. I'm going to give Team Baker the advantage of the half day so that everyone can get some rest. I'm going to prep the podcast. Members, I'll let you know when we record the podcast, which will be earlier in the day tomorrow. And then, well, I'm going to hope that we have power tonight, but it's fine because generator. So I'm going to stay on top of the weather, get the podcast prepped, let Team Baker get some work done, and let everybody have a good Friday night and get some rest. Law nerds, you're the best. Thank you for chatting with me after court. It was a lot of fun. We got lots to do and another full week of trial. So week 4, and the way I count weeks is by evidence, not by jury selection. So we're getting into week 4 of evidence on Monday. Law nerds, that's enough for this week. We've done enough work for this day. I turned that down way too much. Y'all have a good weekend. Today was wild and we all need to recover. Emily, you're going to rewatch the judge's ruling and talk about it more on Monday? I sure am. I really want to see that report. And there's a gag order and it's not going to be on the docket. That's what I want to see. All right, Law Nerds, don't forget to get the Law Nerd app. Stay in the loop with what we're doing this weekend. Members, I will see you this weekend. Mods, thank you for all your work this week, and especially with all the... Today got a little wild. I appreciate you. And I will talk to you guys soon. Bye. Thanks for joining me on this stream. If you don't want to miss a moment in court, you need the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android where I can keep you in the loop with everything happening in court. And, of course, when the jury has a verdict. So if you don't want to miss a moment of this trial coverage, make sure you get the Law Nerd app. Thank you for being here, and thank you for being a Law Nerd.